Hey guys, how is everybody? So, hopefully today's a little bit more interesting than yesterday. I don't hear court sound, but there's movement. And actually, we'll catch up. I did see a motion in limine I thought you guys might think was interesting. It's very short. It's in relation to Marquavius Huey, and they want to preclude introduction of text messages and testimony regarding an alleged domestic verbal disagreement via text message between Huey and the mother of his children. They want it to be excluded because it's unfairly prejudicial. I'm going to show you what this is supposed to say. And a waste of time. So we got a 403 in here. Further, the same should be excluded as there is no probative value which are relevant to the issues that are being tried in this case. Finally, pursuant to OCGA 16-14-3, the text messages intended to be introduced into this trial are not acts in furtherance of the alleged conspiracy, as alleged in Overt Act 123 of the indictment. Do you want to see how they're characterizing a text message and what the text message is? And I'm not going to say it's pretty when it comes to speaking to someone that's, a parent of your child. But it's not what they say it is. 123. Defendant Marquavius Huey, an associate of YSL, did commit the felony offense of terroristic threats when in conversation with Justice Woodard, the mom. After Woodard stated she would see him in court, Huey stated, "You'll die if you put the police on me," in violation of Georgia law pursuant to OCGA 16-11-37, which is an act of racketeering activity under OCGA 16-14-3, and an overt act in furtherance of the conspiracy. So this might not be nice. This might be a bad thing to say to somebody. But how is this in furtherance of the conspiracy? So Carton Matthews has filed a motion in limine for that. So there you go. What do you guys think? We'll get caught up here. Probably very quickly. Hope everyone is doing well. If you missed yesterday, rewatch Mariah Smith's cross-examination testimony. It's clipped separately. You'll get caught up. It wasn't that long. And then come tune in because one of the detectives, Detective Hogan's going to testify, and so is BJ, Bernard Mitchell, who's actually in custody. He's one of the people that the deputies had to bring, and Rodney Ooten, who was in the car.
Okay, this is just about scheduling.
Okay, the court's still muted.
Well, it had been the understanding, I think, of the
Right,
sheriff's
arguing
office
with your
that
baby
y'all
mom
wanted
might
to
get
use
you in the
that
homie
once
slapped with
so,
a Rico.
I mean, I don't know.
And, I get it, it's not nice, but
Okay.
in furtherance of what
Yeah,
conspiracy?
fridge.
They're already at the bench. They put the sound on when they get to the bench. Good morning to everybody, though. Hope everyone's having a great Wednesday. Yeah, just a little bit of a stretch there. Shout out to our workers and lurkers here, like Charlotte. Hey, Yoshi. Hey, Nancy. Lots of people saying it sounds desperate. Oh, man. And yesterday was rough, you guys. I expect, Hogan, Detective Hogan, we're probably going to get a decent amount of recall on direct, and then suddenly on cross, I'm predicting a bunch more. I don't really remember. I don't recall. But this is really important for Rodalius Ryan's team because this is another witness that testified in his actual trial. That they have those transcripts. They have their prior statements under oath. And it'll be really interesting to see. Because what did I note? So we learned a lot from Angela de Williams Cross, and if we take her representations and her questions at face value, which I have no reason not to, she asked Mariah Smith, "You originally told police that BJ, who's going to testify today, put a gun to your head that night. You kept saying there was one shooter. Detective Hogan asked you if you knew the difference between the truth and a lie. Then Detective Casey told you This is the time to sing your butt off, or you're going to find yourself in jail. That's when you started adopting Detective Hogan's story, who's taking the stand today, that there were 2 shooters, including Lil Ron. And you started putting him in the story, and at some point you told Hogan that he had a big gun. Now, she seems confused and doesn't really recall that. Then she says she was trapped on the bottom floor, found some phone down there, that she was able to make a call. She calls her grandma first. Seems like she may, I'm not exactly sure on this, but she might have been getting on Instagram to do Instagram messaging at this point. So what phone? Who knows what? She had claimed not to have a phone at all, if I'm not mistaken. She said she worked at McDonald's, didn't have a phone at the time. But, was she just going to a laptop every time she was doing voice calls on Instagram at weird hours, a tablet? It's possible, but does that seem likely? So I have a ton of questions. Things that didn't really get cleared up for me yesterday. However, there is something that I think is a little bit damning for Rodalius Ryan, and it could be a staged text. It could be someone in the car didn't know anything that was going on. But we did get from Reeves Hiles, he did show us a message where, I think it was BJ in the car, and I'm sure he's going to be pressed on this when he testifies. But BJ's like, something, we shot back, right? And so I think the state actually finally got to make a good point that, typically when you're shooting back at somebody, you're not the one that initiated. Now it becomes a self-defense situation. So I see that this is serious stuff that Leah Abbasi, Angela DeWilliams have to work with. But there's so many inconsistencies. So I think it's going to be really interesting to see what we get from Hogan, what we get from Rodney Ooten, what we get from BJ today. Lots of stuff. And that's got to be pressure. That's got to be pressure for Rodalius Ryan's attorneys. Because this could really help them in their arguments about his first trial. Shout out to Coley. Been a member for 2 months. Good morning, Kat and the chat. Everybody say hey to Coley. All right, let's see. Nick Starro says, no stream yesterday, might not be one today. Don't you just love when repeat clients call? Hey, I feel a little bit of that with real life clients. But also some of this, the way they call these witnesses. And Nick, were you watching yesterday when Leah first got up to the stand to do direct examination? Miss Abbasi gets up on the stand and she says, "Good afternoon, Mr. Hiles." And he goes, "You mean evening?" Because it had been so long. He's ready to go. Oh my goodness. Good to see you, Nick. I still think you very well could do a very quick recap of yesterday, just like this. That's all you need. Good to see you. I'll tune in either way. I'll come hang out. So whatever you decide. Great to see you guys. Every time they talk about Big Nick in this trial, you might hear me say Nick Starro. They are not the same person, but we pretend they are. Make sure you go follow Big Nick Starro. And then Lisa Mahoney, thanks so much for becoming green. Welcome aboard. Okay, that might be true. Mark's saying, I don't think BJ will be called. I mean, I think it's risky, but I think the state makes some decisions that don't pan out. And, sometimes I wonder if they think things panned out the way they wanted them to. Despite everything that I can see myself. Maybe they think stuff works out for them. So I don't know. Definitely was a boring day yesterday. Maddie B! You guys... Man, the Lions got a good win this weekend. Shout out to Maddie B. Sup, Slime. Hi, Cat. Go Lions. I feel like you've been waiting for this, but I appreciate you. Good to see you, Maddie. Yeah, Nick, 10 out of 10 rants. And every once in a while, you get the Bucky suit appearance, which it just makes it an 11 out of 10. Yeah, great point, factual lie. It says, yeah, Love thought Derek Wright on the stand was good for her. And then we've all talked about, wow, he's a crap attorney. So how do you get a crap attorney on the
Does
stand
anybody have
and it still burns
proposed
you?
instruction to submit
And this is about
or
Kendrick.
comments
Steele
about the
submitted
one that the
one.
court drafted? All right. Good morning.
All right, so Steele has a footnote on this. He's reiterating over and over that a curative instruction is not enough. I think this is about Deamonte Kendrick.
Sure.
Oh, there is a new sleep timer feature on YouTube that I've never seen. I hope I don't press that accidentally. The screen goes out. Shout out to Katie Hingerty.
Good morning, Your Honor.
Morning.
On paragraph, it's in the alternative wording for Mr. Kendrick. It states, hold on, I've lost my place.
And it, honestly, I'm looking at it now and it may not even be 100% applicable. That second sentence in the alternate wording, I had just noticed that in the other guilty plea limiting instructions, that was more the language. So I was throwing that in for y'all's consideration as to whether anybody would prefer wording of that type to the couple of paragraphs above that. But yeah, I mean, whether another person has been convicted of the same charges isn't necessarily applicable anyway.
So, and my concern is that the court's not addressing, yes, I understand that something could be used against, I'm just using his name, but Mr. Kendrick, not against the others, but
Right.
But then it says that you can use the other evidence, and there's no instruction that's only if the jury finds beyond a reasonable doubt that one or more of the persons entered into a willfully and knowingly. And
Right, but we're talking about overt acts. I mean, they're going to have to, that's another step or portion of what they're going to have to decide. And obviously they're going to get full instructions at the end of the trial. So I'm not going to get into, here's how you're going to consider all of these different parts of the RICO count,
I do understand, but as a listener, I guess, for a juror, they don't even get to decide the acts unless they first find it. They could do it any order they want, I guess, but they first find that there was a willful and knowing joinder of the conspiracy.
Sure, that's a part of what they're going to have to find as to each defendant before they can convict anybody.
And I'd like that language in any instruction, because otherwise, let's assume that this trial ends, the state rests in December. That's approximately a month and a half, maybe 2 months from right now. Meanwhile, the jurors are being conditioned, in my words, from the Honorable Court's instruction, that, hey, yeah, we can use evidence against everybody except certain evidence. So I'm going to realize that this is against everybody before there's been no instruction, to my knowledge, in this entire case, that they have to first find that there's a conspiracy, that a person joined the conspiracy. So
They're not supposed to be deliberating until the end of this case, the close of all the evidence, all of the jury instructions. So there isn't a danger of that.
okay, well, that's my problem.
All right.
Because
Well, I'm not going to give them a full kind of mid-trial mini instruction on how to consider RICO. They're not
Okay.
supposed to be doing that yet.
Okay.
Do you think that would be
I'm
precedented
not
for a
trying to say
150-day
full
trial?
instruction, but just a line, maybe. I put it in
I mean, I
our,
can say, I'll give you further instructions later
I would,
on how to consider all of this.
and whether a conspiracy even exists, or a person joined a conspiracy. That's what I'd like, because I do find, and that, yes, I understand that they'll be instructed later, but I do find that it is, jurors should have some context of this instruction. This instruction standing alone seems like it's already, there's a suggestion. I'm not saying the court's doing it on purpose, by the way, but there's a suggestion that other evidence can be used against everybody. Well, that may not be true.
I'm only saying it as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So if I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based upon my instructions that will come at the end of the case or at an appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, and then go into something about then you may not use the guilty plea or verdict, whichever.
All right, well, I
against anyone else.
appreciate that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong, really. Okay.
And
So,
I still believe my original that the evidence shouldn't come in at all because I'm struggling with the instruction. So,
all right, well, I
with that
think
being said.
in terms of.
So if I'm struggling with
if-
it.
If anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay.
I don't want either one, sorry.
Clea, I
Well,
don't want either one. and I'd
I'm
like to-
definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to build in reversible error, but I would prefer not to do that because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, I still maintain my objection. I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute so we may have
And
a split?
y'all don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today. Yes, ma'am. Okay.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right, how about announce, and then if they want to huddle, they can huddle.
So- And good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will
Wunnie Lee?
probably be our third witness this
All
morning. I know Miss Abbasi and I were supposed to speak very briefly. After they're huddling, we can have just 2 minutes to speak.
Well, I may have them huddle later
Okay.
Because the Wunnie Lee stuff's more pressing, because you can tender the conviction, in any order.
Yes, Your Honor.
So on the Wunnie Lee evidence, is there any objection that still needs to get hashed out?
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know.
I was just
at
talking about
the
that.
lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong.
State doesn't
My
like what he's going to
understanding was it was
say.
Still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him, and I think we're faced with a confrontation clause issue.
So they had him ready to testify. We talked about this materials witness thing. They had him ready to testify yesterday. They also brought in Wunnie Ooten, someone else who was in the car on the incident we talked about yesterday. Leah Abbasi raised the court's attention early yesterday morning. They're supposed to be here, but we can't find them. So, make an inference there. Probably talking with state investigators in some room somewhere in private. Leah can't find them to speak with them, to interview them before they take the stand. Today, they're called. They're still called by the sheriff's office. Now Leah's like, where are they? Are they not testifying? Because we put our whole strategy around being able to cross-examine this witness. Otherwise, we could have tried to go to Instagram records, but we chose not to do that because we were just going to use his testimony. And now the state, after interviewing Bernard Mitchell, BJ, yesterday, they don't want to call him. Why might that be? Why might that be?
Because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
There you go. There's your
Would
mistrial for the
state like
day.
to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic. Pick one up, maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Ooten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Ooten or Mr. Mitchell, and yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today if we decided to put Mr. Ooten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that? Did y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me, at the very end of the day, I had inquired to the court, said, you know, discuss what's going to be the order tomorrow. And I
Right.
said, well, Mr. Mitchell, Mr. Ooten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, you know, who are we going to get to? And they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in, and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Ooten and Mitchell over the lunch break.
We went back, he didn't want to speak with us, that's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch, and I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
my recollection is after lunch, I was sitting there, Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch, and we didn't call Mitchell. And the messages came in unobjected or not objected to, and there's been no conditional admittance of evidence that's been
There
permitted
has not.
or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory, that's fine, it is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it, because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed, we all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abbate that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Ooten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, you know, Mr. Abbate's, I can't promise you my memory is 100% accurate, and I'm certainly not getting up and saying that Mr. Abbate's lying. I'm not going to do that. But I have no memory of that conversation.
So
at
his
all.
memory isn't 100%
You know,
accurate
as I said, I
either.
brought up at the end of the day, you know, what's the order of the witnesses? When are Mr. Mitchell and Mr. Ooten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and, no, you didn't,
That was at the very end of the day. We were just,
amongst
But why,
counsel?
why would you ask that if
I believe
you
Your
heard
Honor was on
otherwise?
the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying, when are we getting to Mitchell and Ooten?
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it, because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with the, I don't see a basis for a mistrial. So we need to deal with Wunnie Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you.
You tell them to do things off the record and get it together. And I think it's Leah. I'm saying it wrong. Leah Abbasi just argued that to you. Hello?
Want to avoid misunderstandings in the future.
That's fine. We'll litigate everything forward.
Good.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
Kokomo?
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him and then defense counsel can cross him if that will solve the issue.
What's the
I
scope
don't-
of cross?
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him.
Why was your staff trying to get him over if you knew yesterday that nobody was calling him anymore? Hold on. That doesn't add up.
At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office. They don't need him. I don't know where he is at this point.
Okay. And Your Honor, Mr. Kokomo checked at the end of the day. I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling him.
All right, well then,
Oops.
that's even more of a record against your recollection.
I guess I don't understand. There would not have been any reason for me to ask about whether people were coming from the back after the evidence had already come in if I knew he was appointed to be testifying.
So you're saying you pointed towards the holding cell doors?
Right, asking about witnesses for tomorrow.
Yeah, not for nothing. Saying
Well,
someone's
that
not being
is
called
no
tomorrow is
record
not the
upon
same
which
as not
to
at all.
grant a mistrial. So let's get to the Wunnie Lee evidence.
So no Rodney, Ooten, or BJ. Scratch everything I said this morning.
Yes, Your Honor. We sent it. Sent the email on yesterday at 9 a.m., Your Honor.
To whom?
Well, you know what? I don't think Ms. Percival is on it, so let me forward it to Ms. Percival. I'm sorry. We're forwarding the
We're
reduced.
just trying to get the whatever evidence we're going to litigate now up.
All the attorneys should have received it yesterday at 9 a.m.
Right, I'm just saying the court doesn't have it.
Yes,
so.
I just said, I was forwarded wrong.
So we are up to 2 squeaks for the day, you guys. 2 squeaks. Atkins bringing us some entertainment. Thank you to STS for gifting a membership out here, helping someone become green. Make sure you guys are saying thank you. Ashley Linnell says, Kat, we didn't hear Young Thug after hours. Now, hold on. I don't want to hear any Thug with what YouTube did to me. I gotta, like, do that on off time. No videos. No
Can
music
counsel
played
approach
on the
for a minute,
stream.
please?
That was a day when they took that stream down. Okay, wait, are we getting headphones? Why are we approaching? But shout out to Young Thug. Tons of music. Oh my gosh. YouTube got me that day. And I'm still pretty confused about that because regardless of, I still think it's totally reasonable for someone to say, hey, are you calling someone? And if they say, well, we don't plan to call them, that could mean tomorrow, one day, because the state likes to say they're going to call somebody and then they don't call that person for a week. Think of Martinez Arnold. They were supposed to call him like a week or two ago, and now they're going back and forth saying that they want to call him in November when Ashley Merchant's going to be away on vacation. So why would it be unreasonable for Leah to say, oh, just not tomorrow then, because they're going to be calling Hogan and Wunnie Lee. Wunnie Lee will probably take a long time. Right? I imagine Wunnie Lee's not going to be a quick witness unless he just doesn't want to say anything. So it'd be reasonable if you were Leah yesterday to say, oh yeah, they have other witnesses they're going to do tomorrow. So for the judge to say that that conclusively means she was told that they weren't going to call him at all, but yet this morning they had them transported to the Fulton County Courthouse, just doesn't make sense. Great recall here from Brooke Harrington. I remember when they litigated the text messages, Atkins said to the court they are calling BJ and defense could cross the meaning. Now this is really rough.
We've got the jury and they've been waiting for 20 minutes already. And I just think it's not considerate of any of us to litigate things that they can't hear and just make them sit around. So we'll just do if y'all have to take somebody out of order, you have to take somebody out of order, but I'm not going to have them wait anymore. Call your next witness and we'll get to the Wunnie Lee evidence when we can get to it. Okay. All right, I'm going to get the jury out.
It's going to be a day, you guys. Oh my gosh. But yeah, and you know, that one text message shot back.
Okay.
So Hogan's still coming up first. Shot back, that's a big deal to not be able to cross somebody on. You can't really cross Hiles on that. You can ask general questions about if I shot a water gun at you, and you shot your water gun back at me, how would you characterize that? What words would you use? Shot back. Oh man. Big shout out here to Sherry Aguilar for gifting a membership. Appreciate you, Sherry. Well, this is a day already. Right. This too, Sheriff Chuck says, judge told everyone to make a record, and then she says, stop making the jury wait while we litigate. Like, what do you want us to do? Hogan is the detective that was interviewing Mariah Smith and said, do you know the difference between a truth and a lie? Reform convict says Santa showed up. How about that?
Thank you. Go ahead.
He's got the hat.
Sure. My name is Al Hogan, A-L-H-O-G-A-N, and I'm a detective with Atlanta Police.
Good morning, Detective Hogan.
Good morning to you, sir.
Can you tell the court how you are currently employed, sir?
I am a detective with Atlanta Police. Currently, I'm assigned to general investigations out on Fulton Industrial, but prior to that, I was a homicide investigator for about 10 years.
And Detective Hogan, can you tell the jurors how long you have been employed with the City of Atlanta Police Department?
I have been certified police officer since 1987. Had a couple of different jobs with the sheriff's departments and the air marshals, but anyway, I landed in Atlanta about 15 years ago.
And you said you had been a police officer since 1987. Prior to working with the City of Atlanta Police Department, where were you in law enforcement?
I started in the jail in Fayette County, was there for a few months. They put me on the road, was certified then in 1987. I worked as a road deputy in Fayette County. I was promoted to detective, worked undercover narcotics locally, and then I was assigned for a good many years, 10 years or so, to the DEA task force at the Atlanta airport. We did drug interdictions there. In between there, I spent a brief period of time as a federal air marshal. This was before 9/11, and that job wasn't for me, so I came back. And that's when I went on through with DEA, and then eventually landed in Atlanta about 15 years ago.
Now, you a few minutes ago told the jurors that you were assigned with the homicide department for 10 years.
Yes.
And can you tell the jurors, were you assigned with the homicide unit here with the City of Atlanta Police Department back in February of 2019?
I was, yes.
And can you tell the jurors a little bit about, I guess, how you're assigned specifically to any homicide case that you're working here in the City of Atlanta?
It is the luck of the draw. We're all in a rotation. There's a big board in the office. There's about 17 of us that are in the rotation, about 6 of us that work cold cases. At the time, I was in the rotation, and your name is on a magnetic strip with a label on it, and everybody's name's in a row or in a column. As murders occur, the person from the top catches the murders. He's the leader, he or she's the lead investigator, and they go to the bottom, and everybody moves up. On this particular day, I was at the top.
Okay. And can you tell the jurors on February 23rd of 2019, were you dispatched or called to come out to the location of 50 Mount Zion Road?
Yes, I was.
And can you tell the jurors what was the reason you were dispatched to that location?
There had been a homicide, a criminal homicide. What they suspected to be a criminal homicide, and they asked homicide to come to work the case.
And is that address 50 Mount Zion Road? Is that here in the City of Atlanta, Fulton County?
It is. It's in southeast Atlanta.
Okay. And when you, I guess, can you tell the jurors? We've heard about different zones that are within the City of Atlanta. Which zone does this location fall within?
Zone 3.
Okay. And the Zone 3, does that include the area of like Cleveland Avenue?
It does, yes.
Okay. Now, can you tell the jurors when you arrived to the incident location, can you kind of describe for them what kind of property it was? Was it a business? Was it a residential location?
It's an apartment complex.
Okay. And were you the first to arrive on scene?
No, sir.
Can you tell the jurors? Now, with not being the first to arrive and being, I guess, assigned as the lead detective because you're number one in the rotation, can you tell the jurors a little bit about the first things that you do when you interact with other first responders who arrive before you, other officers and detectives?
Sure. So they, just by the act of being there and doing their job, they've gathered some information that may be interesting to me or help me with my investigation. So of course, I get there, observe how things are laid out. They have delineated the crime scene and what they think the crime scene is. So they mark that out with yellow tape, trying to make that a pretty big area. This particular one was a fairly big crime scene. So I could see that when I pull in, and then I speak with the two officers that are watching the crime scene log. I speak with the general investigator who has started the crime scene drawing. I talk with the ID technicians that are there that are, and I assist them and make sure that any evidence that I see on the scene that I'm interested in or like for them to gather or document, I make sure they do that. And I just try to glean as much information from what they have from them so I can help me further my investigation.
Now, after speaking with other members of law enforcement who are on scene before you, can you kind of describe, I guess, the layout? You said that this was an apartment complex or a residential complex, a little bit about the layout of the complex as you first observed it when you arrived.
Yeah, it's a large complex in two phases. There's a Mount Zion Road. Obviously, it faces Mount Zion. The address is 50 Mount Zion. Then there's a phase, I'll call it phase one, which is in the front that's up closest to Mount Zion. There's a creek that runs behind that phase one is a creek. So there's a bridge and an access road down one side of it. I think it's the east side of the property that goes past over the creek. And then there's a large recreational area, a big grass field, and then a playground for kids. And then the second phase is in the back, but there's only one way in and out to get to the second phase. And it's in the back of the property across the creek. This crime scene encompassed all of the access road to get to the phase two, and all the way up into a pretty good portion of the phase two where the road runs up into the parking lots, the access into the buildings in the phase two.
So in a second, Detective Hogan, we're going to put up State's Exhibit 11NN, which was previously admitted into evidence.
Yes, sir.
Can you see it on the screen?
I do.
Okay. So do you see at the top of State's Exhibit 11NN, there's, I guess, a red line that's drawn. It's right by where the time is, where it says 9:33 a.m.
Right there you're talking about?
Yes. Can you tell the jurors, is that building that you can kind of barely see at the top of State's Exhibit 11NN, is that the first phase or the first building of the complex?
That's correct, yes.
And then do you see in the middle of State's Exhibit 11NN, it looks like something, looks like a brown kind of, something that's separating the grass in the middle of State's Exhibit 11NN?
Right here.
So in the middle of State's Exhibit 11NN, you see trees, and there's this.
Oh, that's the creek. Okay. There's the bridge.
And then it's the area you described, I guess, where the playground and things, the recreation area.
It's under here, under the trees, back over here in this area.
Okay, so it's towards the, I guess, the left side, kind of middle of State's Exhibit 11NN.
That's correct, yes, sir.
Okay, now you described to the jurors briefly about the second phase or the second half of the apartment complex. Do you see that phase in a State's Exhibit 11NN?
I do. It's this phase here.
Okay. And can you tell the jurors what areas in State's Exhibit 11NN, if you can see it, were pertinent to your investigation in relation to the crime scene?
Immediately when I pulled up, I parked in the parking lot up here, if you can imagine the face, goes up Mount Zion Road would be up here. I parked my car outside the crime scene tape and walked in. I checked in with the crime scene technician. Immediately, I could see that there was a blue car resting against the fence, and I think there was a big rock there it ran into right here, where there was some stuff on the ground and stuff on the car. And as I walked up, of course, that's going to be pretty interesting. It's not supposed to be there. So as I walked up, I saw that it was part of the crime scene. There was blood in the passenger seat. There were bullet holes in the car. There were shell casings on top of the car. Items of clothing were on the ground and on top of the car. And then as I walked further past, I could see there were some tire tracks that were through the grass here, beside the building here, as well as more shell casings that were kind of scattered out in this area over here. And then they had crime scene tape stretched out across here and across there to deny any access into the crime scene.
Now, you talked about crime scene tape and things of that nature. When you arrived, had the crime scene been fully secured?
Yes.
Okay, can you tell the jurors a little bit about how that's done and why that's done?
Yeah, well, we're trying to preserve evidence. Everything in there may have something of value to us that we could use to further investigation. So obviously we don't want anybody to tamper that either on purpose or by accident. So we try to protect it. We try to make it as big as the officers that responded made it as big as they thought they needed to protect everything that I just described to you. The shell casings are easily kicked or moved. We don't want to touch anything that may have DNA or fingerprint evidence on it. There's just lots of things we need to try to protect so we don't damage our own investigation.
And Your Honor, can I approach the witness?
Yes, you may.
I want to show you what's been marked as State's Exhibits 48 NN through 67 NN. If you'll just flip through those, have you had an opportunity to go through those prior to your testimony here today?
I've seen them before, yes.
And as you're flipping through them, I guess, what are State's Exhibits 48 NN through 67 NN?
These are all crime scene photographs from the scene.
And do the photographs in State's Exhibits 48 NN through 67 NN fairly and accurately depict the crime scene, 50 Mount Zion Road, when you arrived on February 23rd of 2019?
Yes.
Around at this time, the state would tender what's been marked as State's Exhibit 48 NN through 67 NN.
Those are admitted.
Now, you talked about the area of, I guess, where you said it was a blue vehicle,
Yes.
and in your investigations, did you determine what type of vehicle it was?
I do. It was let me look at my notes here for the year model, but it was a Dodge Charger.
Just looking at your report,
Yes.
help refresh your recollection?
Say again?
Is reviewing your report, will that assist you in the refreshing? your
Yes, I'm just trying to get a 2014 Dodge Charger.
Okay. And can you tell the jurors, when you arrived and began to investigate and look around the Dodge Charger, was it occupied? Was there anybody in it?
No, sir.
Okay. Can you tell the jurors, you talked about the tire marks that you had seen. Can you describe the condition of the vehicle as you began to investigate and process the vehicle?
Well, we had run the tag, or somebody run the tag, and it came back stolen out of Cobb County. It did have some defects in it. It had several, which appeared to be bullet holes to me, from my experience. And there were 12 of them total. Again, there was a large amount of blood in the passenger seat, front passenger seat, and some clothing. A baseball hat was on top of the car. There was a projectile that fell out of the hat when we picked it up. And then there was, you know, other items inside the car that were gathered and
Okay.
documented.
In a second, Ms. Knight is going to put up State's Exhibit 15NN, which has been previously admitted into evidence. Actually, my apologies, 16NN. And in 16NN, Detective Hogan, can you kind of point out for the jurors the areas in which you just described as defects? I think you said 12 in the Dodge Charger.
Yep. You can look pretty close, you can see whatever's kind of out of place. In this particular image, my memory serves right, this white is a defect. You can see the different whites that stand out pretty readily, and you can see why I'm assuming they're bullet holes. But in that particular picture, I see four defects.
Okay. And you said that around the car, was there, I guess, ballistic evidence also located, I guess, on the car and surrounding it?
Yes, there were shell casings. Off the top of my head, I don't remember how many, but there was 2 or 3 on top of the car. I think maybe that's what that is. But they were up here were spent shell casings. They'd been fired and ejected out of the car, out of the gun and landed on top of the car.
And can you?
Objection, Your Honor, that's speculation.
Sustained.
Well, you said they were spent shell casings. How did you know that they were spent?
They didn't have a bullet in them anymore.
Okay. Now, can you tell the jurors, as you're kind of walking around and observing and processing the scene, are you being assisted by members of the Atlanta Police Department's crime scene tech unit?
Yes, and if they were there before me, and they started working the crime scene, so they were really very familiar. They showed me a lot of stuff, and then I just went in behind them and made sure that everything they showed me I was interested in, and make sure that if there's anything that I saw that they didn't know about, and make sure they knew about it to gather it.
Okay. And can you tell the jurors, as it relates to your working in conjunction with the crime scene techs that were present that early morning, what type of shell casing do you remember was identified as the shell casings found around the car and in the general area?
On the car, and then a little further up on the crime scene, they were all smaller caliber shell cases, like 9mm.
Okay.
Later on, we did find some 7.62 as well, some larger caliber.
And you said around the car, and then I guess a little bit further up from the car. I'm going to show you what's been admitted as State's Exhibit 52NN. Can you tell the jurors when it comes up what to your recollection, the yellow placards in this photo are marking or representing?
Sure. You can barely see them on this one, but there's a little yellow square there and another one up around the corner. Those are placards. They have numbers on them. ID techs, when they document stuff, they document it right where it says. So they put the placards up next to or adjacent to the pieces of evidence, and then take pictures and document where they found it. Later on, after they do that, then they'll gather the evidence, and it'll be delineated on their report by that number, whatever number it was nearest to the piece of evidence. But this, if you can imagine, if you were in this picture, if you turned around directly 180 degrees, that's the access road that goes out to the front of the property, and then the blue car is down right behind you.
Now, if you are looking at the right side, it states the 52 and it looks like a raindrop that reflected off from the photo. If you see where there's a vehicle or a red car kind of in the middle right-hand side, it states that the 52 NN.
Yes.
Can you tell the jurors if you continue to go straight down the access road and take a right where that red vehicle is, can you tell them where would that take you?
That takes you into the parking lot in between two of the buildings in the complex.
Okay, and is that the buildings that I guess would be the front buildings, the first one we saw that was closest to Mount Zion Road, or the back set of buildings?
That's right, yeah.
That's what?
The back set,
Backside. Okay.
phase 2.
Now, you referenced or talked to the jurors a little bit about the fact that there were additional shell casings that were found in a different area in relation to the vehicle.
That's correct.
Can you kind of describe to the jurors, I'm going to show you what's been previously admitted into evidence as State's Exhibit 10NN. And using State's Exhibit 10NN, Detective Hogan, can you kind of orient the jurors as to the area that you described that you found the second set of shell casings?
Sure. Well, I told you about the shell cases that were on top of the car. Those were 9mm. There were several more that were scattered around in the roadway and the grass over here in this area. And then there were several that were found in the grass. These are the larger caliber shell casings over here. Over here at the corner of the building and around and on top of the car were the 9mm. The larger caliber 7.62 were in this area.
And if you can recall, in that area that you just kind of described and oriented the jurors to, where the second set of shell casings you found, how many did you find? And looking at your report will refresh your recollection.
Yeah, let me look and see. I don't remember.
If and when your recollection is refreshed, just look up and I'll re-ask you the question. If it helps, I can direct you to maybe page 4.
Yeah, if you would, because it's not jumping out at me.
Yeah, if you look to page 4 of your report, and if that helps refresh your recollection towards the bottom.
Oh, 15. Thank you.
All right.
15 7.262 caliber shell cases.
So it sounds like after looking at page 4 of your report, your recollection's refreshed?
It is refreshed.
Okay. And you described them to be a larger type of, or larger caliber of ballistics or shell casings. Can you describe to the jurors a little bit about that?
Sure. Well, a handgun is a smaller caliber, usually somewhat smaller caliber. Police carry 9mm or 40 calibers. Each caliber is a different size. So each shell casing is going to be a different size to accommodate whatever size bullet it shoots. For example, the 9mm the bullets are about as big approximately as the end of your pinky finger. So the shell casing has to be the size for that to fit in. A 7.62 is normally associated with a long rifle, like an assault rifle. And it's a much bigger bullet. It has a lot more gunpowder behind it. It shoots a lot faster and longer. So the shell casing for that is going to be larger and distinctive for that caliber of weapon.
And based on your investigation, is it, or based on what you saw and observed, were, I guess, all of the shell casings that you saw was larger, the 7.62, kind of grouped in one area?
Yes,
And
they were all
then-
found in one area.
The shell casings that you described earlier, a few minutes ago, that you said were smaller caliber and are 9mm, were those all kind of grouped within, one small area, separate and distinct from the
The
7.62?
majority of the shell casings, the 9mm were discovered here. The
Oh,
only
show us.
exception to those would be the ones that were found on top of the vehicle where it was abandoned.
Now, can you tell the jurors, do you see the red line that kind of travels throughout State Exhibit 10NN?
The long one?
Yes.
Yes.
Can you tell the jurors, based on the investigation at that point, the shell casings that you had found in different areas and the tire marks that you described, why, I guess, that red line is there and what it represents?
For me, that was, I created this, so, I know it's pretty rudimentary, but I'm not a computer guy. The little red dots it's not accurate, but it just indicates where the shell casings were found. This was a line based on my investigation of where.
We can see now.
That they had parked. And this is the access that they took trying to get out when the shooting broke out. So there was a shooter that came out here when it started shooting. They drove out. Another shooter down here drove past, walked, well, you can see the tire tracks in the grass. Drove off the road, back on the road. The car was not functioning, so they rolled to a stop here and then exited. It's just a line to kind of show where I thought they went when the incident happened.
And I'm going to show you what's been marked and tendered and admitted into evidence. It states that it's 59NN. And in this photo, do you see kind of the grouping of the yellow placards that are seen within State Exhibit 59NN?
Yeah, same procedure as what I described earlier. Where there is a shell casing, they put a placard, and next to it is a corresponding number that indicates that particular shell casing. This is coming out from the Rick Breezeway, and this is where they, all the different placards indicate the different shell casings that were found.
And do you see kind of in the middle of State's Exhibit 59NN towards the, I guess, the breezeway? Let's see if we can get this out your way. There we go. In this area right here,
Yes.
are those placards, are they also the larger caliber shell casings?
Yeah, they were all the same shell casing.
Okay.
Caliber.
And are photographs taken of each placard from, a faraway distance or a full range distance, mid range, and then close up?
Yes.
Okay. To your recollection, was that done in this case?
I wasn't present, but I'm assuming they do it the same way every time.
Okay. And for time and efficiency, is that what we see in State's Exhibit 60NN through 67NN?
Yes.
Okay. Now, after you completed kind of walking through the scene with members of the City of Atlanta's crime scene unit, while on scene, did you get information that two males had contacted 911 indicating they had witnessed what happened at 50 Mount Zion Road?
I did.
Okay. And I don't want you to tell me what anyone said as I go through the next questions. As a result of that, did you go to APD headquarters just down the street here off of Peachtree?
Yes.
Okay. And can you tell the jurors When you arrive, did you speak to the two males?
I did.
And without telling me what they said, can you tell the jurors who you spoke to that early morning?
Sure, is Bernard Mitchell and Rodney Ooten.
Okay.
Two witnesses
can
we're
you
not gonna
explain to the
see.
jurors, without telling me what they said, kind of the circumstances and of the setup of the interview? Let's start with that.
Oh, it was just an interview. Well, there's two different areas at headquarters that we speak to people in. One's an interview room. It's just like if you guys came in and had something to tell us, we put you in an interview room and we speak with you. The other is what they call an interrogation, or when they're in custody. In those rooms, you're secured, chained to the floor, and both rooms are audio and video recorded. Both types of rooms.
And you said they were in the first room, the interview room that you described?
They were in yes,
And
witness room.
can you tell the jurors, do you interview them together or do you interview them separately?
They were done separately at different times. Same, one after the other.
And after speaking with both Mr. Ooten, they were in the first room, the interview room that you described?
They were in yes,
And
witness room.
can you tell
This
the jurors,
better
do you
for
interview
volume?
them together or do you interview
There's no
them
captions.
separately?
They were done separately at different times. Same, one after the other.
And after speaking with both Mr. Ooten and Mr. Mitchell, can you tell the jurors, do you speak with a female, Miss M. Smith, after speaking with both Mr. Mitchell and Mr. Ooten?
That's correct, yes.
And can you tell the jurors, do you speak with her that same day, later on February 23rd of 2019, or at a later date?
It was on the same day, on the 23rd.
Okay. And can you kind of explain to the jurors in relation to when you arrived to the scene and kind of worked and processed the scene with members of the police department, about how long after you arrived did you begin to interview people in relation to your investigation?
Multiple times in the report. It all came together fairly quickly once it started rolling. Let me see if I notated it in my report. Do you know specifically in the report where I need to be looking?
Let me ask you generally this question based on your recollection. Was it a matter of hours that you began speaking with witnesses, for example, Mr. Ooten and Mr. Mitchell?
It was all in the morning time, yeah. It was like 6 in the morning when I got to the crime scene. It was well before lunch when I was talking to Mr. Mitchell and Mr. Ooten.
Okay. And when you spoke to Miss Smith, can you tell the jurors kind of the setup or the arrangement for that interview?
That was in the witness area. It was later on in the day. I think it was after lunch, thereabouts. But same, voluntary. She came in and I spoke with her.
And when you're speaking with Miss Smith, is it just you and Miss Smith, or are there any other members of your team that are also present?
Detective Casey was with me.
Okay. And can you tell the jurors, as you began the interview
You're talking about Mariah, right? With Miss Smith, or with the other two?
So I'm talking about Miss Smith.
Okay, yeah, Miss Smith.
Yes.
Detective Casey was with me. Yes.
Yes. So can you tell the jurors, when you began the interview with Miss Smith, can you kind of describe for the jurors her general demeanor that early morning?
Sure. Yeah, she was upset, nervous, crying, young girl, and you can imagine. She said she was a witness to a shooting and a murder, and she was upset.
Objection, proper bolstering.
Now, as you began the interview, can you tell the jurors, how did you start?
Sure. Well, I started all the same way. I introduced myself, and we start talking about, and I asked, talking about the situation that they witnessed, and I asked for their statement. And she began by telling me a series of events that she relayed to me at that time that I knew were not to be correct based on what I knew from the crime scene.
Okay. And when you say knew what not to be correct in relation to the crime scene, can you explain to the jurors, I guess, what you mean by that?
Yeah, she was saying that this victim had been shot by one of his companions. The way she described it, it was not possible based on what I knew from the crime scene. So I brought that to her attention. After some consoling and some speaking with her by me, she realized that she changed the story to what the truth was, which we knew that she was not telling the truth.
Okay. And as you continued, I guess, to confront her with the physical evidence that you had located on the scene and through your investigation while on scene, did she provide you with names or nicknames of individuals she knew to be involved?
Yes, she did.
Okay. And do you recall, or can you tell the jurors the nicknames that she told you of the people she saw shooting that night?
Yes.
And if referring to your report would help refresh your recollection, by all means.
One was Little Rod and Bali.
Okay. And can you tell the jurors, as she described what she saw, did she tell you, or tell the jurors what she told you about the firearms that she saw Little Rod and Bali having?
Judge, Your Honor, I'm going to object that this is improper bolstering. She's already testified to this.
This is impeachment, Your Honor. She testified she couldn't recall at times during her testimony as it related to the firearms, what they look like.
Can you approach from
All right, I have no problem mentioning that there is a march starting for 7 a.m. for Thug, but is this like at the courthouse or just for like the actual details? But yeah, so I think it's interesting that we have him confirm I knew she was lying. It didn't make sense with the crime scene. So I get why Carton Matthews and then now Miss Abbasi are saying, you know, a little bit of bolstering there. We had some testimony on this yesterday. So we'll see what happens after this approach. Yeah, she also said she lied. And that's the thing, like, the jury gets to determine what they think is credible or not credible. Ike says my closing right there. Everybody is lying, has attempted to lie, or admitted to lying, not just to investigators and police, but right here on the stand. Nothing is as it seems. I mean, it hits all the points. It hits all the points. Also, big thank you. Tons of kindness in the chat today. We have April O'Neill's baby daddy gifting 1 Catnut Williams membership. Thank you so much, April O'Neill's baby daddy. Leah's dad says, I try to give Paige the benefit of the doubt, but this is crazy as. And yeah, I mean, I don't trust the state, and I hate that she always seems, when it comes to one attorney being truthful and the other being truthful, she decides the state more often than not, well, really across the board. I don't really know if there's been an exception. She trusts the state. It always leans in favor of the state. Well, you think Abbate has a perfect memory? And he's been dishonest before.
You've been describing the fact that the first part of the interview you had with Ms. Smith, she gave you a number of facts and scenarios that were not aligned with what you knew to be consistent with your investigation at the crime scene, correct?
That's correct.
And as your interview with Ms. Smith continued, I believe you indicated earlier about the statements that Ms. Smith made going forward about what she observed on that early morning of February 23rd of 2019 as it related to the shooting. The facts that she relayed to you after you confronted her with what you knew to be true about the physical evidence on the crime scene, the facts that she was giving you, did they become consistent with what you knew through your investigation at the crime scene?
They did become consistent, yes.
Okay. And as you continued to interview Ms. Smith, did she continue to provide you statements as it related to what she saw and heard that were consistent with what you've described to this?
Your Honor, leading the witness.
Ruled based on our discussion at the bench.
So let me see if I can remember what I was asking you. So as she continued to describe things that she saw and heard and observed on the crime scene that early morning when the shooting was occurring, were those statements consistent with what you knew that you found on the crime scene earlier during your investigation?
Yes, sir.
Okay. Now, can you tell the jurors, we talked a little bit about she was able to provide nicknames. Can you tell the jurors, without telling me what she told you, but was she able to provide you with Instagram handles or usernames for the two people she gave you nicknames for?
Yes.
Okay. And as a result, I guess in conjunction with that, was she actually able to pull them up and show you photographs as it related to the person she knew as Lil Rod?
Yes.
Okay, and I want to show you what's already been admitted into evidence as States Exhibit 23NN and 24NN. While she's pulling it up, I will give you a physical copy so you can see it.
Oh, yeah.
And while Ms. Knight is pulling it up, if we can get the technology to work, are those the photographs that Ms. Smith was able to provide you in relation to the person she knew to be Little Rod?
That's correct, yes.
And can you tell the jurors, do you see her signature on those photographs?
I do.
Don't pull it up. And can you tell the jurors what date is her signature on those two photographs?
The 24th of February of 19.
Okay. And was Ms. Smith able to do the same thing as it relates to the person she knew to be Mr. Bali?
Yes.
Okay. Now, can you tell the jurors, after receiving this information from Ms. Smith as it related to who she saw shooting, can you tell the jurors, were you able to determine the identity of the people she knew to be Bali and Little Rod?
Yes.
Okay, and who were those people?
Little Rod's name is Rodelius Ryan Jr. Bali's name is Damon Blaylock.
And let's see. Now, before we move on from Ms. Smith's interview, can you explain to the jurors, so during Ms. Smith's interview, you described how you confronted her with the physical evidence as it relates to the statement she made initially at the beginning of the interview. You remember that?
Yes, sir.
And can you tell the jurors, when you confronted Ms. Smith with the fact that what she was saying didn't make sense with what you already knew, did you tell her the identities of the people who were shooting?
No,
Did you, before speaking to Ms. Smith, have any idea who they were?
I didn't know him from a can of paint, no, sir.
And was that something she was able to tell you based on what she described as what she saw and heard that early morning on February 23rd of 2019?
That's correct, yep.
And while you were interviewing Ms. Smith, did you provide her with any facts as it related to the identities of Mr. Ryan or Mr. Blaylock during that interview?
No, sir.
Okay, and was that information that she was able to provide, or did she provide you information that assisted in your investigation in identifying both Little Rod and Mr. Blaylock?
That's correct.
Now, after speaking with Ms. Smith, can you tell the jurors, did you attempt to identify another female described to you during Ms. Smith's interview?
Yes.
And can you tell the jurors who was that?
Her nickname was Brazen. She was with Miss Smith.
And if, your report.
Tahira Hartfield. Oh, excuse me, that's her mom. Oh, yeah, Tahira Hartfield. That's right.
So it sounds like using your report refreshed your recollections?
Yes.
Okay. And in your identifying Ms. Hartfield, can you tell the jurors, based on your investigation into Ms. Hartfield, what her living situation was?
She was a runaway, listed as a runaway at the time.
And ultimately, before, let me ask you this question. Based on the information that you've talked about here today, can you tell the jurors, did you make charging decisions?
I did.
Okay. And can you tell the jurors, did you swear out warrants for the arrest of Mr. Ryan and Mr. Blaylock?
Eventually I did, yes.
Okay. And can you tell the jurors, did you ultimately get to speak with Ms. Hartfield?
I did.
Okay. And without telling me what she said, did you, I guess, speak or interview her in a similar fashion that you've described as it relates to Mr. Mitchell, Mr. Ooten, and Ms. Smith?
Yes.
Okay. And during your investigation, can you tell the jurors, did you also receive a social media posting as it related to Mr. Ryan hours after the homicide?
Yes.
Okay. And was that something that you used and utilized in your investigation in taking out the warrants that you've described?
Yes.
One moment. And I don't have any further questions pending redirect.
Did you really get I get that he's like lining up the stuff about the shell casings, and I feel like the crime scene testimony he gave was much more compelling, although a little bit boring. I didn't really, do you guys think Abbate effectively impeached Mariah, because remember, Mariah was telling things that could go either way, things that made it seem like Lil Rod wasn't doing something, things that make it seem like Lil Rod was doing something. So Abbate's goal is to impeach the stuff that doesn't help his case, right? And I don't really think the second half here did that, and he's passing the witness already. So
All right, are there defense questions for this witness?
There are. I do want to make sure I can get a hold of at least one of these snippets.
Okay.
please be the video. Show us the video. Oh, hot mic. So the Honorable Yeah That about Abbate says, he says and more than YSL says slime and slat 300 times. Posy McPoserton became a member, and thank you so much for the 5 on Cash App. Appreciate you, Posy McPoserton. Thank you for becoming green, and also for just having one of my favorite names. STS out here sniping yet again with another gifted membership.
All right. Good morning, Detective.
Good morning.
Let's see how this goes.
Coming into today, you had a chance to review the interviews you did with the witnesses you spoke to?
Not all of them, but yes.
Okay. You haven't had a chance to review them?
I haven't reviewed, I reviewed Mr. Mitchell and Mr. Ooten's recently, the others have not.
Okay. All right. So I want to start. You've been an officer for quite a while, yes?
Yes,
And so you know that when you are getting information from people, it is of the utmost importance to make sure it's accurate, right?
yes,
And that's one thing you were doing with Ms. Smith, is confronting her with facts to test whether what she was saying was accurate, correct?
that's correct.
All right. And especially in a situation kind of with young people, they may not always be fully forthcoming in the beginning, correct?
It's not limited to young people, but yes,
Right. Especially if they think there's something they could get in trouble for, correct?
yes,
All right. And the folks that you were speaking with in this situation, they were not, well, the 2 young men you spoke with, they were not lawfully allowed to have weapons, were they?
no, I don't think so.
Okay. So that's something they theoretically could get in trouble for if they admitted to it.
Yes,
Okay. So when you're speaking with them, when you're speaking with Ms. Smith, you're asking questions to make sure you can verify things. One of the things you told Mr. Mitchell you would do was get his Instagram records, correct?
I may have, that doesn't come to mind off the top of my head, but it would be something I would do, but I don't know if I told him that.
Would it help refresh your recollection to see a copy of a transcript from that interview?
Sure, yeah.
Right. One moment. Here we go. All right. I'm going to direct your attention to page 19 here. If you could quietly read that to yourself. Let me know when you've had a chance to refresh your recollection from that.
Before he answers the question, I'm going to object to hearsay. What Mr. Hogan said during the interview to anyone would be hearsay.
He's-
Out of court statement.
He's on the stand. He can repeat what he said.
That doesn't make it not hearsay, but
I mean, I can ask whether he asked somebody.
yeah, I think it's not hearsay in this circumstance, so overruled.
I mean, in this circumstance, it would be.
It's overruled.
Okay.
So.
So were you planning on getting Mr. Mitchell's Instagram records?
I may have been. It's hard to say. This is a lot of years ago, so it's part of my tools that I use for in each or any case that I have that I work. If there's an opportunity to pull those, and I need those, then yes. But I don't. I don't remember if I wrote a warrant for his Instagram or not.
Okay. You said if you have the opportunity, you certainly had the opportunity, right?
Yes,
Okay. And with those, if you had them, you could come back to him and say, hey, was this true? Was this not true from what you told me, correct?
yes, I could, yeah.
Okay. And Mr. Mitchell and Mr. Ooten, they were both cooperative, correct?
Yes,
So if you wanted to follow up with them, they gave you no indication that they wouldn't speak to you or anything like that. They were readily available.
yes, not at the time they were cooperating with me that day, yes.
You didn't attempt to contact them any other times, though, did you?
I don't recall doing so, no.
Okay. So in this case, do you recall what search warrants you did take out?
No, not all of them, no.
Okay. Do you recall taking out warrants for Instagram records?
I do.
Do you recall whose records you requested?
I know I got little rods, I got valleys. And without going through the index on my report, I can't tell you exactly, but I know I got little rods and I got valleys. I got Rodelius Ryans and I got Damon Blaylock's. May have gotten Mariah's and Brazy's as well, the Tyara Hartfield and Miss Smith.
Okay. What was your purpose in getting those records?
It's any information there that might help with the investigation.
Okay. Did you look at those records?
Not personally, no. I looked at some of the pictures. It comes in a format. Again, as I indicated, I'm not a computer guy. I'm not even on social media. I gave that information to somebody who could put it in a format that was easier to read, and then those people looked through it, and they let me know what they found.
So it wasn't for you to get more information. Someone else was supposed to get more
The
information.
information is going to come to me. It just didn't come through me.
So at what point did you get the information of what was contained in those Instagram messages?
When they gave it to me, I don't know what day it was.
Who's they?
I don't remember who the analyst was that did the examination of those records.
Okay. And the examination of those records, I would assume you included in your report?
Some of them, yes.
Some of them. Could you let me know then when? I assume if you put them in your report, it says then when you got them, correct?
It says when I put it in the report. Let me see.
I mean, that's something you would put in the report, right?
One that jumps out at me was from February the 26th of 2019. Somebody sent me an Instagram post on that day, and it was a short video that showed Mr. Ryan riding in a car.
Okay, but that's not the Instagram records, right?
It's from Instagram.
That's not the Instagram records for which you obtained a search warrant to get so you could get more information, correct?
I haven't verified it, but if it came from his Instagram and I got a search warrant from his Instagram, then yes, it would be in there. I
Right.
just got it before I got the search warrant.
And it wasn't in there? Where was it?
I'm sorry, if you
It
could
was
repeat that last
posted.
part.
It was posted. Somebody saw it. They sent it to me. If my search warrant had not been executed and the information sent back to me at that time, it would be included in both records, but I got it before the search warrant records came in because somebody sent it to me right after it was posted.
Okay, I think a second ago, because you said you didn't confirm it, right?
You're going to have to, I don't understand what you're saying. I've confirmed it. Yeah, what are you talking about?
Well, I think about the content of the messages, you said you did not confirm with the records.
I just said I'm assuming
Right.
if it's in his Instagram records, I received it before the records came back from the search warrant. I'm assuming that that information that I received that day before the records came back would be in the records when they arrived to me.
Okay. So without those records, having looked at them, there was no way for you to go to Ms. Smith or Mr. Mitchell or anyone else and say, hey, you told me X, Y, Z, but your records say something completely different. right?
I did not do that, no.
Okay. You could have done it though, right?
Wow.
Yeah.
Yes.
And that would have been confirming, right?
Sure, yes.
I want to ask you about what you testified to earlier about the actual crime scene. Mr. Abbate asked you questions about where you found certain things. Do you remember that?
Yes,
And you answered questions about where you found those 7.62 shell casings, right?
Groups of casings.
But you didn't actually find those casings,
no,
did
no, I did not.
you? Those photos, you weren't there when they were taken, right?
No,
You never saw where those 7.62 casings were.
not physically, no.
So when you say you found them, you didn't find them. Someone else did.
I said they were found. I'm not sure that I said I did.
Okay. When did you learn about those casings?
Later on the same day that the murder happened, I was at the office when I got the call.
Okay. And when you spoke with Mr. Mitchell and Mr. Ooten, were you aware of those casings?
As I recall, it was around the same time. I don't remember exactly the sequence of events. But I spoke with them later on in the morning. It was sometime around the same, a lot of things were happening at the same time, that we got the call about the shell cases. That's one of the reasons I did not physically see them, because I was busy at the office. So I asked the responding officer to collect them and supervise that. But I don't remember the sequence of when exactly they came in.
Okay. Would it help refresh your recollection to see a copy from your trial testimony?
Sure.
I'm sorry, not your trial testimony, the last proceeding, several proceedings ago.
Okay, sure.
Getting impeached by both parties, both sides of the aisle. Oh my goodness. They really are whispering at this table here. Whisper, whisper, whisper.
All right, I'm going to direct your attention to page 1076 from the prior hearing. Also turn to page 1078 if that's helpful as well.
Okay.
Oh, I don't think this is a stupid question, Zion. Zion says, why would Abbate agree to call said witness for the defense to, quote, alleviate the situation if he wasn't providing cover for a mistake? And I think they have to be conscientious that this is up on appeal, right? The state has to be aware of that just as much as Ryan's counsel.
All right, so what's your question again?
If when you spoke with Mr. Mitchell and Mr. Ooten, you were aware of the 7.62 shell casings.
Oh.
I was aware they described to me 2 shooters, but I don't recall if I knew about the shell cases at that
But you
time.
found them
I
the
may
same
have,
day.
I don't remember.
You said that they described to you 2 shooters?
Yes,
Okay. You've got a transcript in front of you, so you've testified about this before, correct? This matter?
yes.
Okay. And you don't recall attorneys asking you at length whether anyone besides Ms. Smith mentioned 2 shooters?
I read here that they were asking me about that, yes.
Okay. And your testimony was that Ms. Smith was the only person who said there was 2 shooters, right?
Yes. That's what it says here.
I mean, when you,
Wait, before we get too far around here, let's make sure we got the right context.
Okay, tell us.
you want to flip to page 1,100.
No, let me read these first.
Okay.
On page 1076, as I recall, they were asking me about my interview with Ms. Mitchell, and I had mentioned to her that I had 2 sets of shell casings. They were trying to determine if she.
Okay, well, I don't need you to testify
Yeah,
about what someone
well,
else
well,
is trying to do.
So what I'm saying is context matters. In this particular instance, I was describing my interview with her, and in the process of the interview, when I was confronting her with the evidence, I told her that I had 2 sets of shell casings.
Yes, I understand that.
You said page 1100?
Yes, sir.
Okay.
So having reviewed that page, Mariah was the only person who said there was 2 shooters, right?
According to that transcript, yes, ma'am.
According to that
was your sworn testimony
transcript.
under oath, right?
That's what I said. Yes, yes, yes.
All right, so that
Wow.
was the truth that you said then, right?
Yes.
And I'm going to back up for a moment. I think you said Mr. Mitchell and Ooten, they told you about not 7.62, but a weapon which would have fired larger shells. Is that right?
Yeah, they described a long gun coming out of the breezeway. Yes.
Okay. And when you were speaking with them, that was not consistent with the scene as you had seen it, right?
Again, I don't remember exactly when I got all the information about the shell casings. So at
You
that
said
point,
you got
I
it
was
that
just I was
day.
getting his statement,
At your office.
and I took it as he gave it to me.
Did you not previously testify about the shell casings? I did not know about it when I interviewed Mitchell and Ooten.
Okay, well, if my recollection was that then, I don't remember that now. If I didn't know about the shell casings then, if that's what I said, then that's what I said.
Okay. But you didn't confront them with what at that time would have been their testimony inconsistent with the scene, right?
No.
Okay. And they both told you 1 shooter.
Would be nice if they could be on the stand.
The number of shooters they told you was not the same as Miss Smith, correct?
That's the same question, just worded differently.
We've already been through this.
I'm going to overrule that one.
Bernard Mitchell described the shooter coming out of the breezeway, and also the shooter when he was going around. He was right beside he described the person right outside the car shooting in the car.
So that would be,
Described dreads and a hoodie.
so that would be he described to you two shooters, based on what you just told me.
Yes, based on my just reviewing my interview with him the other day.
Okay. All right, I'm gonna have you take, so you don't recall testifying that Mr. Mitchell actually never said anything about two shooters?
I got a sneaking suspicion you're going to show me that I did, but as I sit here, I don't
Oh.
recall that, no.
Because
You were able to
remember,
review your interview with him, correct?
Yes, I did.
Okay. You still have that transcript in front of you?
No.
remember Mariah testimony on cross
this
with
it?
DeWilliams?
Oh, okay.
Story change after Detective Casey said you better adopt Hogan's story about there being two
Take
shooters.
a look and see if that helps refresh your recollection about whether he told you there were two shooters.
Wow.
It may or may not refresh his recollection, but I'm going to object against it.
That's ruining my case.
I'm going to object to hearsay.
This is impeachment of what the officer previously said.
I'll let you ask about whatever he previously said.
Do you have a page or an area that I need to look through exactly?
Is Whitaker doing that thing where she feels bad for kind of being catty with somebody earlier in the morning?
It's a long interview.
No, sir.
How many pages are we talking about?
Can't see, maybe about 20. I can't see if that's right. It could be more. You know what? We can come back to it. We'll probably have a break and you can take a look and get back to me.
Okay, sure.
Cool. So when you went out to the scene at the time, you were looking to speak with other witnesses, correct? If there were any.
Originally, when I first got to the scene, yes.
Okay.
Yes.
You were trying to speak with as many people as you could, right?
Yes, I did.
Okay. And you had access to the cab reports and the 911 calls, correct?
Yes.
Okay. And you had access to the 911 calls themselves, correct?
Eventually, yes, I did.
Okay. And anyone you spoke with, you would have put that in your report, correct?
Yes, most of the general information. I don't necessarily put all the details, but yes.
Okay, but like their name, right?
Not always. If they don't wish for the name to be included, if I can exclude them, I will.
Fair. But you never spoke to the 911 callers, did you?
No,
Even though you had their name and contact information, right?
that's right.
Even though you were aware that one of them wanted to speak to the police, right?
If I was aware of that, I would have spoken with them.
Not really good when you're the detective to say you weren't aware, so you didn't do something. It's kind of your job to find out, be aware, and talk to people about it. Confront people with what you find.
I'm going to approach you with what has already been previously admitted into evidence and marked as states 1NN Nancy Nancy.
Okay.
Okay. And that is one of the CAB reports you've reviewed, correct?
It appears to be a CAD report from the case. I can't say I reviewed it, but this seemed to be from the case, yes.
So you didn't review the CABs, or you did?
Well, I look at it, I verify that it's got the right address on there, and if there's any information as the case progresses, and if I need to get back in touch with anybody, like a 911 caller, I would do that.
Okay. So you didn't see the,
And I would use the CAD report to get that number
okay.
and name. In this particular case, I didn't see the instance to it. Didn't need it.
You didn't need to see the person who wanted to speak with you?
I wasn't aware of that person.
So you didn't review the CAB?
I looked at the front page. I didn't read every word. No, ma'am.
Okay. So you didn't listen to the 911 calls?
No.
Okay. So if you're trying to speak to as many witnesses as you can, why wouldn't you speak to the 911 caller who wants to speak with you?
Again, I didn't get the word that they wanted to speak with me, or I would have. My plate was pretty full. I talked to a lot of people when I did a lot of work that day.
Oh, okay. You were too busy.
Yes, I was busy.
Okay.
I would have been argumentative. I would have said too busy trying to get Mariah to change her story.
So
I
when-
would have done it.
Mr. Mitchell and Mr. Ooten. No, let me back up. The photos of the 7.62 shells, you didn't take those, correct?
I did not.
Okay. Were they just sent to you? Is that right?
Yeah, they were included with the report, yes.
Okay. And so is it from those photos you pieced together, say 10NN that you've drawn a line on?
Yeah, too busy for a homicide when Love said, "Oh, someone can't be here because they're too busy investigating homicides out in the streets," or whatever Love said that day. So she was
10NN,
looking
you
for
drew this line,
records.
correct?
I did.
Okay. And the Earth image or whatever it is, that accurately depicted the apartment complex as you observed it, correct?
That's correct.
Okay. So, and the line on the left side where it starts, that's your belief, that's where the 7.62 shell casings were?
That's correct, yes.
All right. I'm going to put up on the screen for you what has been admitted as 59 NN. I don't know if it needs the share screen. Thank you. All right.
Lady C, this
So,
isn't uncommon for cops.
Looking at 59.
Great on direct, terrible on
NN.
cross.
What is it you see next to kind of that entryway, exitway, by the sidewalk to the building?
Well, I see satellite dish and an AC unit.
Okay, AC unit. And then you were standing at that AC unit looking at the parking lot. What is to your right? We have a line of bushes.
I'm turned around here. I don't understand what.
If you're standing next to that AC unit with the AC unit on your right, you're looking at the parking lot. Do we have a line of bushes there?
Yes.
All right. Could you flip back to 10 and then? So looking at 10 NN, officer, you said it was consistent. What happened to that line of bushes?
They're not there.
Okay, what happened to the AC unit?
It's not there.
So how is that possible?
Well, when I got the information from the officer, I memorialized what he told me, what he found. He said it's by the Y building. I was assuming that Y building was where I indicated right there.
Oh, okay, so
on
you
the
just
map.
assumed that.
I did, yeah.
Okay.
It's in the same complex. The picture with the shell casings is in the same complex. I think it's in the next building back in that little courtyard.
Okay. But so you didn't go out to the scene and see where those 7.62 casings were, right?
I've said that a couple times.
So you can't say for sure actually that 10 NN is even where those were found, right?
That's correct.
Okay.
Oh, he said
I can
yes,
say they
that's
came from the
correct.
complex, but
Fair.
exactly where in the complex, I don't know.
Fair. And with this image, I'm going to point you to, I guess I can't really point to it. That corner right there, right?
Yes.
That's where Ms. Smith indicated one of the shooters would be, correct?
Stickers.
I don't recall that.
Where do you recall she said the shooters were?
She said, if my recollection is correct, she saw somebody walking out of the breezeway.
Here?
Yes. I believe, yes.
Okay. So all those casings should be right there.
Yeah, but the buildings are
They were shooting through the
very
building.
similar
Oh.
in design, and there's two sets. So there's breezeway that goes through both sets of buildings.
Okay. So they're very similar. So
So it's easily confused, is what I'm saying, as far as locations, because the buildings look very similar.
okay. Good. So you may have been easily confused, right?
I was confused, yes.
Okay.
You were confused, but you're using
And
what you said to get someone to change
Miss
their
Smith-
story.
During the earlier parts of her interview, she had only talked about one shooter, right?
I recall she said she saw someone with a long gun, and she heard shots. I don't recall if she indicated whether there's more than one shooter or not. I don't remember that. Should I refer
Okay.
to something?
So earlier on in the interview, or when in her interview, I think you talked about, she said some things which weren't consistent.
Yep.
And then you consoled her.
Yes.
And then she was more consistent after that, right?
Yes.
So when was it that she began telling you, back this up. At what point between those did she go from one shooter to two shooters?
I know when she described to me, she said she described the two guys that she was with, and she described each one of them having a different kind of weapon. I recall that, but I don't recall if she stated that she saw anybody shooting. She just stated that she heard shots and ran.
Okay.
Saw both of them with guns, but I don't recall if she said she saw them shooting.
I guess my question was, when in her interview, before or after the consoling?
It was after the consoling.
Okay. Because before that, it was only one shooter, right?
I knew that story she was telling me was crap, so I really wasn't paying much attention to it.
Okay.
So I don't remember what she said.
And it was between what was the consoling? We'll go there.
What was what?
When you consoled her.
Hmm?
What do you mean by that?
Well, I'm a husband and a father. I've got a daughter. I just spoke to her in a fatherly tone, assured her of her safety, and calmed her down and encouraged her to tell the truth.
Okay. But she didn't start doing that until after she was told to, I think, sing her ass off, right?
I don't recall if that was said or who said it.
You don't recall that.
I'm not saying
Play
it
the
wasn't said,
interview.
I just don't remember.
Play
who
the
said it.
tape.
Yeah.
Okay.
Play the tape.
And there were discussions during that interview about whether she was implicating herself, right?
I don't recall.
Whether she could be going home or not?
I don't remember that.
She wasn't concerned with, or didn't seem as though she was concerned about getting in trouble?
She was concerned about getting in trouble, yeah.
Okay. And so I want to back it up. She came in, she's telling you a bunch of things, they're not adding up. You console her, and then she is telling you something consistent with the evidence, right?
Yes.
Okay. But that part didn't happen until you were the first one to bring up that someone had a rifle, right? As opposed to just a small gun, right?
I indicated that there were two types of shell casings, a rifle round and a small caliber.
Okay. Before that, she had not described two types of rounds, correct?
Like I said, I haven't seen that interview in quite a while. I do not recall.
Okay. You're the one who brought up a second person there to ambush, right?
I described two types of shell casings indicating that it was two shooters, yes. Implication there is two shooters.
Okay. So you made that implication, and then we had two shooters, right?
Yes.
Okay. What more did you do to confirm what she was telling you?
And what, do you have an example that you'd like me to
Kind of look
answer?
at her
'Cause there's-
records.
She told me a lot.
Right. She told you about different things that Mr. Mitchell did or Mr. Ooten did, right?
Yes.
And those weren't consistent with what you learned from them, right?
Yeah, they were fairly consistent.
Okay. So when you spoke to Mr. Mitchell, that's when you learned about him putting a gun to her head?
Oh, yeah, she did say that about him, yeah.
Yeah.
Again, that's the story and it was, I didn't believe her, so I
Right.
forgot about it, yeah.
So it would make sense if she's telling you these stories that you would want to confirm them, right?
If it's the truth, yes.
Right. And she told you things about, well, let me ask you. You never went back to Mr. Ooten or Mr. Mitchell and asked about whether everyone had been chatting together, like she told you, right?
Oh, no, they described in their interview that they had been texting with the girls.
Oh, I'm sorry. I meant that everyone, the defendants, everyone came out and was chatting together before this happened.
I don't think that came out with Mitchell and,
Okay.
yes.
All right. So they didn't say it, she did, but you didn't go back and say, hey, this witness told me this. No?
No.
Okay. And you didn't go back and look at her Instagram records, right?
I don't think so, no.
So you couldn't confirm whether she said she'd been talking to the victim every day, right?
Bless you, the victim. No, I didn't.
Okay. You could have though, right? Because you said you got a record, or you ordered them, did a warrant for them?
Yes.
Okay. And she told you about a specific type of van that Mr. Ryan's mother drove, correct?
Yes.
You didn't go check and see if she actually had a van like that, did you?
Yes.
You did?
Yes.
And that's in your report?
I don't think so, but I did do it. I noticed it. Let me look see. It might be in the report. We went to go talk to his mother.
Mm-hmm. She was cooperative, right?
She was.
You didn't ask to search the van, did you?
No.
And that van would have been, based on what you were told, used basically as a getaway vehicle, right?
Yes.
So it could have a murder weapon in it, right?
Yes.
Could have gunshot residue all over the steering wheel, right?
No, unless it was shot from the car.
Okay. Those wouldn't transfer from someone's hands?
I don't know, maybe.
Maybe. But you didn't get a search warrant to check either of those things, did you?
No.
And within just a few hours, you had an address for Mr. Blaylock, correct?
I did.
And you didn't get a search warrant for that apartment either.
No.
So you made no effort to look for what would have been the alleged murder weapon, right?
That's correct.
Okay. That would have been useful, right? If you had that, that's great evidence.
I've worked 100 murders. I never got one.
Never.
Ms. Abbasi, let's pause for a minute and take our morning break. And if you, do you want
we're
him to
taking a
look
break.
at whatever that
Oh, sure.
portion was while we break?
Sure. He's welcome to, and Officer, I'll hand you your other transcripts and you can look at whatever you need to.
Interesting, he says 100 and he's never gotten a search warrant, and he makes it seem like they don't ever get to search for these things. But we have that Water Street incident in this trial where Schardt has said, you know, there may have been something improper about that search warrant, or the state has misrepresented what was actually found during that search warrant. So these search warrants after a shooting are obtainable, and he just gave something maybe hyperbolic, or he's an extreme rarity, an exception, where for whatever reason he's never
Can I ask you to
gotten one of
actually
these
step
search warrants.
outside, if you don't mind?
Oh, sure.
Thanks. I've just got to deal with another matter. How about you start with whatever it is that you wanted him to actually, that you asked him on the stand about? Okay. I mean, you can give him all of them, but I'd like for him to start with the one that you specifically asked about.
They'll be here.
All right. Okay, so there's been some back and forth about the whole Mitchell, that's his last name, right, thing.
Did she review it?
Ms. Abbasi, you said that you kind of gestured in a vague direction towards the holding cell door at the end of the day without mentioning anybody's name, and asked who the witnesses would be tomorrow, which is now today. And the state's answer did not include either of those people. And then, of course, there was some point in time in which the state was maybe going to get Mr. Mitchell, and I don't know what they were going to do, put him on the stand, just, I don't know, as a concession to Ms. Abbasi, maybe? I don't know. Anyway, just FYI, Mr. Mitchell is here and available. I'm just letting y'all know that. And I kind of need to know before the lunch hour, or whenever this next, the witness that's on the stand right now is over with, if he's going to be called, let's go ahead and call him next so that he can be whatever's going to happen, and then transported away back to where he
Right,
has
so we're
been
getting Mitchell.
staying before this time.
The issue raised on the defense is his messages would kind of affect what sort of road we went down with the defense. We've already gone down that road.
All right.
The mistrial has been denied. There's no further, I'm no longer insisting at this point he be called. Whatever damage has been done has been done. So working
All
with
right.
what we have.
Just wanted to let y'all know. Okay, so then, eh, does the state want to call him? If not, tell me now and I'll have him shipped back.
No, I think this line of hearsay questions has cured any sort of
He's so snarky.
issue as it relates to a mistrial and confronting Mr. Mitchell, since she's been able to do it without Mr. Mitchell even testifying.
All right. Thank you. Let's take our break.
So I guess Abbasi said, I'm cooking so much, I don't need to do that anymore. And apparently, based by, if we judge the tone that Adam is giving there, he agrees. Reluctantly. So there we go. But yeah, that was the judge's way of acknowledging that Leah was right this morning. Leah was right. So on that note, Bridgetta had said, this judge is just as messy as the DA. There you go. Thank you for being a member for 2 months. Orlando Antonio, same vein. Yeah, let's just trust the habitual liars. Got it. Okay. Right at the state. And that snark, you guys, like, one of the first time we've seen Adam on the stand in, was that August? Maybe July? Giving testimony. He didn't want to be sworn in, right? He didn't want to actually be sworn in. But he was on the stand talking about Melnick. And he had this whole attitude about John Melnick, Attorney John Melnick, while he was on the state. Just adding in all these adjectives to describe things that Melnick was or was not doing. So we get that same snark from him right there. When really, he didn't add that snark when he was telling the court, no, we told the defense. We told the defense. He's adding the snark now after the judge mildly hints that he made a misrepresentation. So I'm with you, Orlando. State seems like a bit of a habitual liar as a collective. Not really good for the court to be okay with just trusting them, to have candor to the court. Army Nurse says, good morning, Kat, chat, and mods. Glad to be back. Went to North Carolina to take some supplies and donations. That's amazing. Shout out to Army Nurse. Let's drop some love in the chat for Army Nurse. Love that. And last night got caught up with everything. Hope y'all have a good day. You too, Army Nurse. I think it's hilarious people were like trying to catch up with yesterday. It was such a drag. Hope you got through it okay. That was pretty tiresome for us. A lot of yawns yesterday. Good to see you here with us in real time, Army Nurse. FFS says, I'm telling you the honest to God's truth. What's the difference between a lie and lying? Well, it's apparently whatever a detective determines is the truth before they actually investigate, right? There's a bit of a sticky web going there. He says, well, I looked at the scene and I determined that what somebody was telling me couldn't have been true. Fair enough, right? But then Leah Abbasi, I think, does a really good job breaking that down. He didn't really look at stuff. He didn't really know the stuff that he said he knew at the time he was already confronting Mariah Smith with certain things. So you said you knew, you had a better idea of what the truth was and that somebody wasn't being truthful. And you just wanted them to get comfortable telling the truth. But then Leah paints this picture where you weren't just consoling Mariah Smith. You were in a room with somebody yelling at her, berating her, sing your ass off. You might not be going home. You might be implicating yourself. Doesn't really seem like you're consoling somebody or sitting in a room with somebody who's consoling this person you're interviewing. And then we find out you didn't really have all the context together. You admit yourself you didn't know at the time. So how did you already know the truth? I think Leah is doing a great job creating the doubt there. And FFS, I always love the God's honest truth and then a lie comes out. Good to see you. Hope you're doing well. Black Butterfly says, Kat, the writing is on the wall. They canceled him because Leah brought up BJ, that's Bernard Mitchell Jr.'s Instagram, that they never researched. They don't want that Instagram info in. And I don't really think it's necessary. I do want to see it I want to see the testimony just because I want to see it. At the same time, I do believe that he could get up there and just say, I don't know. And what are you really going to do? Hold him in contempt when he's already incarcerated? I don't really think that that does much of anything. So you'd really just be putting someone on the stand to get a bunch of I don't knows. And maybe that could look a certain way for the jury. But I think the jury wondering, who's Bernard Mitchell? Why isn't the state calling Bernard Mitchell? Could be just as effective. Big shout out here to STS gifting 10 memberships. That's a ton of new slimes. All right, I better see some STS spammed in the chat. And in a way, you get to use all caps when you say STS, because it's all initials. So there we go. Super, super generous. Thank you so much, Steven. And if you guys, especially if you got a gifted membership, make sure you're saying thank you. Let's see. So I'm not really sure why. So Ooten and Mitchell are both in jail. I don't really know why. Or I think one's in prison maybe. One's in jail. One's at the Fulton County Jail. I forget. But I don't really know. Fashionably Fit Life says state sent Mitchell and Ooten back because they weren't going to cooperate and testify the way the state wants them. They didn't want a Miss Bennett or D'Angelo White on their hands. Take me back! Well, what's one more witness doing that? What's one more? So, yeah, right? Being transported for nothing, all that. For a second day in the row. There we go. STS Mlat. Lots of love here. Thank you guys in the chat. That's what Lay says. You can tell who the war on drugs narcs are. Yeah, right? He mentioned like he was doing DEA at the airport for a while. Listen to how he talks to people. A good old boy, smarter than everyone, ordained by God and Ronald Reagan. I don't think Ronald Reagan can ordain people. But yeah, he did mention, I didn't catch the time frame, but he said he worked as DEA at the airport. So, and that was before he got to where he is now. So coming into his work with the APD as a detective with that background context, you might be on the lookout to sniff certain things out. So that's a good point. Bella Moon says, I'm so angry for the defense. And now revisiting this, Whitaker calls a break in the middle of that testimony. And I think what Whitaker was trying to do was, let me call a break now before these questions get too far out and let the state and the defense have a chance to decide if they want to call Mitchell to the stand or not, rather than exhaust it. But Abbasi said, we've gone over it, we're good. So big shout out here to Simon Beebe gifting 5. Get some W's in the chat for Simon. I've got to get this banner up. Probably have to update it. We'll update it in a second. Thank you guys for sponsoring so many new slimes today. We are growing. We'll get that to 28 new slimes. And Lottie B, I don't know if there's been a date set for Merchant's client, but they're supposed to have sent one. So, and thank you for all the W's here for Simon. Appreciate you guys. Connie B says, love it. When caught in a lie, they always scream context. Yep. So we have Hogan refreshing his recollection, looking through this transcript of his interview with Mariah. And then suddenly we get the mention of the word context. And I mean, you look at it, you get the context, you're reading the transcript for a while, and then when it comes back to this question about when Miss Smith started talking about 2 shooters, was it only her? He says, according to the transcript, which to me is just a tell you're still trying to wiggle out of giving a clear-cut answer. You either don't want to give the answer, or you don't want to contradict yourself, but there's something inconsistent about it. So, yeah, always interesting wording, and again, very different between the direct examination demeanor and the cross-examination demeanor of this witness. And yeah, trench coats, huh? Who knows, STS? Who knows? Thank you for the 2. My name, Jeff, says they really are all squirrel brain, the whole APD. Right, and it's so funny every time because for a while we're like, it was Thorpe, it was Thorpe. Woody said it was Thorpe. And every time a new detective would come up, they'd be like, is this squirrel brain? Like a bunch of people would say, is this squirrel brain? And it'd be like, well, that was Thorpe. But now it's just like, all right, they can just all be squirrel brain. All of them. Especially on cross-examination, they go a little squirrel-brained. Oh, man. Leah's dad just says, go Leah, go, with amphibious emojis, green hearts, and the yelling emoji. Thank you for the 2, Leah's dad. Oh, great name. I just clicked that. Love that. Kristen Vasquez says, did he not take this case seriously because Zone 3? I don't know. Like, is it only Zone 3 investigations that get botched like this, or we figured out the truth even though we didn't look at everything at the time we were already saying we determined the truth? Like, I mean, Zone 3, that's really where all of this is happening, right? Dunbar Rec Center, TIG Studios, all of this stuff falls into Zone 3. We have no reports. We have no surveillance video from the key places that the gang members got together to conspire. Like, what did we investigate? Who did we talk to? Even with TIG Studios. Oh, we didn't talk to anyone. Okay. We didn't look up what vehicle, who owned the purple truck. Okay, good job. Good investigation. You didn't even try. So yeah, I think there might be something there to the Zone 3, but I'm also wondering, is Zone 3 just something they don't care about? Is it bigger than that? Is it bigger than that? So good to see you, Kristen. Touche says, morning all, I'm catching up, but man, Pouty Paige is at it again. Not Pouty Paige. Oh man, I love that. And yeah, I think she was, and I wonder when she kind of like clicked and revisited that. Because I really do feel like she was being sympathetic with, I think she properly overruled one of the objections, but she like lingered, like she was looking for, and then finally said, all right, I'm going to overrule that. And I paused to say, is this like sympathy from Whitaker for this morning's response to the motion for a mistrial? And I'm wondering when she got this news. But yeah, definitely Pouty Paige. She's got that birthday lunch to go to, you guys. Don't forget. Peter Ortiz says, never make a woman mad. Right? Just lighting the match. Scorched earth. This is decent advice. This is good advice. Legally Brown Girl says, been too spoiled with engaging Cross. Direct examination of Detective Hogan has me somewhere else. Yeah, and that was a little bit lengthy. And I think it's because he was the lead detective on this case. So when all was said and done, I think it was kind of nice that it was only 49 minutes or so of direct. But at the same time, I think the reason it was only that length was because he himself and the state, either he didn't investigate certain things that could have been testified to, and or the state didn't want to question him on certain aspects. So I think they kept it shorter, but not necessarily for the right reasons. But you're right. Cross is definitely much more exciting and fiery. I'm with you there. Jennifer Devine says, bet Abbate is thrilled he called this guy instead of BJ, right? Oops. Yeah, his tone gave that away. I think you saw the future here, Jennifer Devine. I agree with you. Definitely thrilled. Definitely thrilled. Thank you so much for the super. You making a, is it a donkey emoji? Sorry, it's really tiny on the screen. Let me zoom in. Yeah. You're making a donkey out of yourself when you assume. Yep. And then when he reads the transcript, instead of assuming, it's only according to the transcript, as if we got to cast some doubt on what's in the transcript there. Good to see you, Survivor Speaks. Hope you're doing well today. Chloe Albert's Revenge says, as Samuel L. Jackson put it, we all know what happens with assumptions. You make a donkey out of you and umption. All right, we can drop some donkey emojis in the chat and have a 60-second all caps. Sponsored by Survivor Speaks and Chloe Albert's Revenge. If you don't have anything to say, you could just throw some donkeys, whatever emoji you want. And also, okay, we are up to speed. You know, sometimes the stream is behind and I'm like, oh, I could skip this break, but we are all the way caught up. There we go. Is Earless Donkey in the chat today? Always love to see Earless Donkey. Because these donkey emojis, I know they're tiny, but they probably have ears. Oh, man. Also, shout out here to Heart of Inspiration. Guys, we are speaking about North Carolina. Army Nurse was doing some good work out there. Heart of Inspiration was also not just raising money, but also feet on the ground, boots on the ground, buying supplies, making deliveries. And that stuff is so important. There are also a few programs I've seen where you can adopt a family, right? And sort of sponsor them while they recover and get through everything that they're getting through. I've got to get some names because the person I'm familiar with, she's a real estate agent and has some properties in the area, so she's kind of just doing it when she takes trips. She's bringing some supplies. But she mentioned, I don't think it was Samaritan's Purse doing the Adopt a Family, but an organization similar. So I'm going to try to get some names of the organizations that are doing Adopt a Family type programs. Because I think that's really something important, right? You know, we get all this initial relief for cleanup and all of that, but the Adopt a Family program can help for the longer haul get somebody back on their feet. So let me get some organization names, and if you know any, drop them in the chat. And also make sure you are following Heart of Inspiration. Great friend of the channel. Talks about some of the stuff that we talk about here, like the YSL trial, but also great advice, life coaching, small business advice, lots of courses, great educator. So always good to see you. She says, love cat, mlat, chat, and KNW slat. That's a lot of rhymes. Free YSL. At least give some bond. Oh, and this is great too. So Judy, yeah, we got the holidays coming up. I do that in Massachusetts for Christmas. And there is that also, the Adopt a Family, where you help them with the meals and the Christmas gifts and I think decorations, right? What's it called? Like getting the ornaments and a Christmas tree to make sure families can have the holiday spirit. Also great. I think those are great programs too, in the same Adopt a Family sense. And let's see. Yeah, and that's the thing, like finding a good organization to donate to. I feel like it's a little rough. You don't want to just donate to something that ends up going like 85% to admin costs, 90% to admin costs. So when we get back, I'm going to go try to find her post where she talked about the other organization so we can get that name. And I have heard good things about Samaritan's Purse. Again, it just wasn't something that was offering. I don't think that was doing a Adopt a Family, but they're still out there bringing a ton of help and aid. Not just in North Carolina, but I think Tennessee and some of the Georgia flood victims. I think they're widespread where they help. So And I'm going to go with Shaw Diggy here. Says all zones garbage. They knew and had no evidence and wanted to be part of nothing. Yeah, I think it's beyond a zone 3. But certainly zone 3 seems like, oh, I had a lot of work on my plate, but I was also too busy to investigate this Jamari Holmes murder. Like, kind of doesn't make sense. And then Cutthroat Radio Podcast. Hey, good to see you. Gifting a membership here. And I know earlier in the stream, I think you said you were just getting caught up. So glad to have you watching with us in real time. And now, have you been doing any live streams? Let's see. Or was it a video that you did? Let's see. Okay, it's making my stuff freeze. Well, in any case. Now, Cutthroat Radio Podcast is another channel that we talk about YSL sometimes. I know you did something on Rich Homie Quan as well. That's what I was thinking of. But you go beyond just the trial commentary. You do like culture commentary, the crossroads between entertainment and legal news a bit, and get into all the hot takes. So, great channel to follow. And there's a link in the chat there. Great to see you. Connie B says, yeah, well, we got this. But yeah, when they're caught in a lie, they always scream context. David Leibold says, clat clat, what about a Miss Persefield emoji? We could do that, but it's gonna look horrible because she's mostly at a sideways angle and it's gonna be blurry zoomed all the way in. So there are some pragmatic considerations when trying to put a tiny emoji on YouTube. So it's possible. And shout out to Miss Persefield. I think she does a lot in that courtroom. You know, kind of like she's been referred to as like the IT person in the courtroom. So she's out there holding it down. So all respect to her. I'm just not sure that grabbing an emoji of her would be the most visible or apparent once it's in the tiny YouTube box. And plus, I'm capped at how many I can actually upload. So it's on the table. If you guys like revolt in the chat for it, we can do it, but we'll probably have to kick an emoji out. So thank you so much, David, for being a member. Heart of Inspiration says, you know it's going to be a spicy day when Paige comes in with her hair pulled back. Let's see. Because sometimes she'll come back from a break and it'll be back down or it'll be up. So we'll have to see if she changes her mood. And don't forget, she's got that lunch today, you guys. She's got that lunch. Thank you so much for the 5 Heart of Inspiration. KC Dog says, this is why Mungtuk's sentencing upsets me. Detectives, DAs, etc. lie and send people to prison and then go home. No disciplinary action when they change lives. And even if there is some type of disciplinary action, it's like maybe a slap on the wrist and it's like 3-4 years down the road from when something actually happens. So, not really a deterrent in the name of justice to prevent the same type of thing from happening in the future. I'm really curious. I still think it's weird. Not weird, but I think it's another eyebrow raiser that suddenly there's a probation violation for Antonio Sumlin for something with a date of occurrence back in August. Like, is it really usually like a 2.5 month window when you do something to violate your probation that you wait to file something like that? Too much on the plate? Like, is there an excuse that might not be a great excuse, but at least it's not coincidental timing when Antonio Sumlin's supposed to be called soon? I don't know. It just made me scratch my head a little bit yesterday. So Yeah, and I don't know. Good question. How long is this break? I don't know. It seemed like a morning break. How long have they, after they did their conversation? About just under 25 minutes at this point. So, oh, and I think the camera just wiggled. You guys are speaking it into existence. Also, very kind here, and thank you again, KC Dog here. Marlena Mack, very kind of you, gifting 5 memberships. Let's put double M's in the chat. Shout out to Marlena. That's super generous of you. You're going to be one of our slime sponsors. Yeah. Yeah, I mean, that guy Nick says the breaks will last until Abbasi completely loses her rhythm. And thank you for showing all the love to Marlena in the chat, you guys. Oh yeah, sorry, MM with the pumpkin. We love you too, MM with the pumpkin. Nick Johnson, thanks for the 2, says, remember Whitaker wants the court respected. Sometimes, selectively. Selectively a little bit. And I think she's setting up a catch-22 here this morning. If she wants the defense to put summaries of what was stipulated to on the record, she's gonna then get annoyed if they're putting stuff on the record and taking up too much time. So she says she wants the courts respected, the jury's time respected, and then she's creating a scenario where she's gonna get annoyed by the very situation she is setting up. So have to see how that plays out. Thank you for the 2 and food for thought. Elemental says, I feel like I'm watching a TV attorney with this defense lawyer. I'm loving it. It is like very spicy. What you'd expect to be scripted. Court audio still, there you go.
For murder.
The only person who ever gave you any indication that Mr. Ryan knew Mitchell, Mr. Ooten, the victim, anyone in the car, was Mariah. She's the only person who said they knew one another, right?
That you confused me a little bit. Say that again. Say it again.
The only person who said that Mr. Ryan knew Mr. Ooten, the victim, Mr. Holmes, Mr. Mitchell, only person who said they knew each other was Mariah, correct?
I don't recall that.
Did you look at your interview?
Well, I'll be honest with you, I did, but I forgot what you asked me for to be looking for in there.
Okay.
Maybe it's a question. Ask me each person at a time. So, Mariah, you're saying Mariah said she knew Mitchell.
Mariah told you, was the only Mariah indicated, whether through this or something else, Mr. Ryan had some contact, knew the existence of Mr. Ooten, Mr. Mitchell, Mr. Holmes, right? You never went to any of them and said, hey, do you know this guy?
No.
Okay. And they never, gave you any names saying, I think it was this person or I have a problem with this, nothing.
They who?
Mr. Mitchell and Mr. Ooten.
They said they did not know who shot at them.
Had no idea.
That's correct.
And didn't ask them if they, had any problems with Mr. Ryan or Mr. Blaylock, right?
Yeah, they're correct, yeah.
Okay. And Mariah, she never told you anything about being locked in a basement, did she?
Oh,
I don't recall that, no.
Okay. And she didn't tell you anything about Mr. Blaylock attacking her, did she?
Other than when Mr. Blaylock. Oh, no.
Okay.
No, not that I
BJ that held the gun.
All right. And so based on the evidence you had, the person who fired the 7.62 was tall, right?
I was described, he was described as being tall, I believe.
All
Just
right.
a second, let me double check it. Just a second.
And I can get you a transcript of your interview with Mr. Ooten if that further helps. too,
I
right?
bet you can. Let's see. Yes.
Okay. So Mr. 762 is tall, and based on all of that evidence, was your conclusion that Mr. Blaylock was the one with the 762, right? Page
no,
18?
Page 18. Of what? Which one am I looking at?
Your report.
Well, if you got a page 18, you're doing better than me. I got 17 pages.
Oh.
Okay, wow. You got more than me. Okay, I see what you're referring to, yes.
Yep. So final conclusion you came to based on everything you reviewed was that Mr. Blaylock had the rifle.
That's what I wrote, yes.
Gotcha. All right. So we have rifle rounds, and then we have all these other casings from a smaller gun, from a 9mm, correct?
Yes,
All right. And those casings were found very, very close to the vehicle where the victim was, correct?
there were casings on top of the car, yes.
Okay. And casings on top of the car, you don't know how they got there, did you? Or do you?
I didn't see them be placed there or fall there, no.
Okay. Did you speak to the EMS, the emergency services people who would have been there responding?
They were gone when I got there.
Okay. So you're not sure whether they had to move anything to get to Mr. Holmes?
It was obvious that the hat we found on top of the car was placed there by someone.
Right.
I don't know who. But I guess it's plausible that somebody would say, hey, there's a shell casing, let's put it on top of the car.
Yeah. So they wouldn't want to lose it.
Don't know why they do that, but yeah.
Okay. So you discussed with Mr. Mitchell and Mr. Ooten whether they had guns, correct?
Yes,
They both had guns, right?
yes.
And you never asked them if they shot, did you?
Mitchell said his gun was empty.
Okay.
Ooten, I don't recall ever asking that specific question.
All right. You didn't ask him what kind of a gun he had, right?
I don't recall
Okay.
asking him.
You asked him what happened to it, though, later, right?
Yes.
And he indicated to you that you should...
All of this is hearsay. What whoever indicated to whoever.
Sustained.
Okay. Did you have an occasion to either you yourself or have somebody go looking in the woods for a firearm?
Wasn't me, but yes.
Okay. And beyond that, you did not have any follow-up to tracking down those guns, right?
That's correct.
All right. And your reason for that, you previously testified, was you had no reason to, right?
I had no further leads. Once we tried to find them and couldn't, based on where they said they put them,
Okay.
there was nowhere else to go.
So you had no reason to try and find out whether Mr. Ooten was the one who fired all those 9mm.
Say that again?
So you had no reason to try and figure out if Mr. Ooten is the person who fired all those 9mm.
Right, I didn't try.
Because if he did, that would be your second shooter, right?
Your Honor, objection calls for speculation.
Sustained.
You, at some point, had an occasion to review Mr. Mitchell's Instagram records, correct?
Again, I'm not a computer guy.
Far later.
I allow other people on the team examine those. I trust them in what they can do because they're a teenager is better than me on that stuff.
Yep.
So I looked at the report or what was given to me. Did not do a deep dive. No, ma'am.
No. No deep dive. You didn't look at them.
Say it again?
No deep dive. I mean, you did not look at them, right?
I don't recall if I did. Yeah.
Okay. So you never did any follow-up with Mr. Mitchell about him shooting back, did you?
No.
But you learned that at some point he said he did, right? Or they did.
Yes, I did hear that. Yes.
Thank you, Detective.
Oh, you're welcome.
All right, so that's the
You need
end
yourself
of
back?
cross. Or maybe, right? All right, end of
Are
cross.
there
That's all yours.
Of course, there's going to be
other defense
redirects.
counsel with questions for this witness?
Is it Steele? No, Schardt. We're the reports.
Good morning, Detective Hogan.
Take the time. Good morning. Good morning.
We've met before, but my name's Max Schardt. I represent Shannon Stillwell, okay?
Okay.
All right, and the case that we're talking today does not involve Shannon Stillwell at all, does it?
Not that I know of. No.
Okay. I just wanted to ask you one question on cross. You were asked about testing a car, the inside of a car for gunshot residue.
Right. Yeah.
And you responded that it would not make any sense to do so unless a gun was shot from that car, correct?
That would be the most obvious reason to do so. Yes.
Okay,
Test
so
for that.
if a gun is shot from inside a car, if your investigation leads you to believe that a gun was shot from inside a car, you certainly would test for gunshot residue, correct?
If there was any question that a gun was used inside the car, so if there was an allegation that it was, and
Yep.
there was reason to believe that it wasn't, we needed to prove that a gun was used in the car, then certainly we should process it inside the car for gunshot residue.
Okay, when you say process inside the car for gunshot residue, what does that mean?
Well, we asked the ID unit. I've watched them do it several times. They have a Q-tip, and they swab areas, and they preserve that Q-tip, which gets sent to the GPI crime lab. And then they do their analysis, their whiz bang stuff over there to say if there's any presence of gunpowder, I guess is what it is.
And we're talking about microscopic particles,
Yeah,
right?
if you shoot a weapon anywhere, if somebody shot in here, the residue would be however tiny, microscopic, but it would be here on everybody, everywhere. Yeah,
It would go all over.
yeah, it goes everywhere.
Okay, and you would ask the collection team, we'll say, to the crime scene technicians, I guess is the formal term, correct?
Yes.
You would ask them to collect from the different areas within the car.
That's correct.
Are there any specific areas that you would have them focus on?
Generally let them do their job. They know more about that stuff than me. I ask them to process it and I allow them to do it.
Okay.
So wherever areas they are. Another's, the GBI has been a little more stringent on their testing of that. They're getting away from gunshot residue because of the fact it goes everywhere. It doesn't really prove anything.
Okay, so the concern when they're going away from it is not that it gives false negatives, but it gives false positives.
Right. So, for example, if you're a gunshot victim, you're obviously a gunshot victim. Guys that in the past I know have tried to test them for gunshot residue. Well, that's kind of silly because they are a gunshot victim. They're going to have gunshot residue on them. Also, the fact that if they're in a room such as this or other people, and somebody shoots and then that person gets away, but somebody else is alleged to be the shooter. Well, if he was in the same room, he's going to have gunshot residue on him as well because it goes everywhere.
So it sounds like what you're saying, if you get a positive result from gunshot residue, it may be unreliable for proving what you're intending it to prove.
You don't necessarily have to be the shooter if you were in the room when the shot went off.
But if you get it, but from what I'm understanding, if you get a negative, that's still a reliable result. It's just the positives can mean different things.
Yes.
All right, great. And in your experience at times, you said you defer to the experts on the collection method. Have you known them to remove different parts of a car for further testing for gunshot residue?
Yes. Oh.
Sustained.
I can approach it. It is going to be relevant.
All right, I'll give you.
And I'm just going to ask one more question. Is one of those parts that the experts remove at times the headliner of the car?
Yes.
Okay. Thank you. No further questions.
You're welcome.
Any other defense? Go ahead.
Good morning.
Good morning, Mr. Steele.
How are you?
I'm great. Thank you.
I'd like to ask you, in your work, have you ever had the need or the opportunity to ask for and secure surveillance cameras from businesses?
Several occasions, yes.
Okay. Can you tell the ladies and gentlemen jury, in your experience, have you ever had a surveillance camera operation where it would be a specific period of time that was captured, the images were captured by the surveillance camera?
Sure. Every system's different. There are some, from my experience, some common denominators. Most surveillance systems capture a certain period of time that's generally around 2 weeks. And after those 2 weeks time period, it stops. You can kind of imagine that you're shoving the video into a tube, and as it comes out, there's just so much space to capture and to maintain. So as you capture more video, it starts falling off the backside after 2 weeks. So for example, if 3 weeks ago there was a crime that we became aware of, and we needed to try to get the video, we call if it's past that 2 week time period, the video is no longer accessible. It's been deleted. It's been overwritten and it's gone.
So in your example about the 3 weeks, so a video can hold up to 2 weeks of information, is what you're telling the jurors in our example.
It's kind of a general rule, Brian. But there are systems that capture and they keep them for longer periods of time, but those are expensive to maintain, and that's pretty rare that we have, but they're out there.
So if, just hypothetically, if we start on day one and the surveillance equipment can hold 2 weeks, so on day 14, from day 1 to day 14, it's all there if it's all working correctly. That's what I hear you say.
Yes.
I'm going to object to relevance.
It goes back.
Overruled.
Now, on day 15, so day 14 ends, now it's day 15. Are you telling the jury that in your experience, day 1 is now gone, so now we'd have from day 2 to day 15?
That's my experience, yes.
Okay. Have you ever, tell the ladies and gentlemen jury, on day 15, so day 15 starts, all day 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 are gone?
Without a catastrophic failure of the system, I have never heard of that. No.
Thank you. Thank you, Your Honor.
Anybody else? All right, redirect.
Oh my gosh, that was just great. That was everything I wanted.
Recall Ms. Abbasi asking you about your interview with Ms. Smith and how she, I guess, about how she described the long gun. Remember her asking you about that?
Yes.
Do you remember her specifically asking you about the use of the term rifle?
Yes.
And do you recall, based on your interview, Ms. Smith was only able to describe the gun as a long gun, correct?
Yes, she was not well versed in.
Overruled.
You can answer the
She
question.
was not well versed in guns. She was using pretty generic terms. Yes.
Now, I want to bring your attention to something that Ms. Abbasi just, one of her last questions, she talked to you about how Ms. Smith just kind of described or said how Mr. Ryan or somebody would know any other parties. Remember her asking you about that?
Yes.
And do you remember what Ms. Smith's response was, or conversation with you was about how Mr. Ryan knew Mr. Mitchell?
Your Honor, I'm going to object to this. It's not the question. The question was whether anyone besides Ms. Smith described them knowing one another.
I think she opened the door as to how.
Go ahead.
Do you recall?
Of how Ms. Smith knew Mr. Mitchell?
No, about how the question that Ms. Abbasi asked you was about how Ms. Smith described to you and talked to you about how Mr. Ryan knew Mr. Mitchell. Do you remember her having that conversation with you? And if looking at a copy of the transcript would help refresh your recollection of your interview with Ms. Smith.
Sure, man.
Like, not another transcript.
Page 93, where the minute marker is 2:18:21.
And Your Honor, I'm going to object to this being hearsay. We're not impeaching her.
What are you going to ask?
What she said. I mean, that counsel opened the doors when she asked the question as it related to the conversation that the
I
detective
don't know if
had
that's a hearsay exception.
with Ms. Smith about how the parties knew each other.
So are you refreshing his recollection as to what she said
That's
about it?
that's correct, Judge.
I'm going to permit it.
Your Honor, the question was about whether anyone else described them knowing one another, not what she said, how they knew each other.
All right, I'm going to allow it.
Stop trusting the state.
I can ask the question again, Detective, after you've reviewed.
Yeah, you're going to have to. Give me a second. Okay, I'm with you.
Okay, so in reviewing page 93 of the transcript of the interview with Ms. Smith, can you tell the jurors, is your recollection refreshed as to what Ms. Smith indicated or told you about how Lil Rod or Rod and Mr. Mitchell were familiar or knew each other?
Yes.
And can you tell the jurors, what did she tell you?
She said that little Rod told her that BJ took his gun, Mitchell took his gun.
Now, I also want to talk to you about a question that Ms. Abbasi asked you as it related to describing, as you spoke with Ms. Smith, that this was an ambush. Do you remember her asking you about that, using the term ambush?
I remember using that term. Can you tell me where to look? I don't recall it in the interview.
No, what I'm asking you is during your cross-examination, Ms. Abbasi had asked you some questions as it related to you describing or using the term ambush. Do you remember that?
Yes.
And can you tell the jurors or describe to the jurors why your investigation and through your investigation, tell the jurors why you called it an ambush?
It wasn't a robbery. The shooters never approached the vehicle. They were lured to a certain spot.
Your Honor, I'm going to object to him testifying as these are actual facts. He can say what he investigated, what he did or did not.
Sustained.
So I'll rephrase the question. Can you tell the jurors what in your investigation drew you to characterize or classify this shooting as an ambush?
It wasn't telegraphed. It was sudden. They snuck up from behind and
I'm going to object again.
Sustained.
Same thing.
I'll move on. I want to put up State's Exhibit 10 NN. Well, before I move on, and as she's putting up the photograph, based on you said you were in homicide for how many years?
10 years.
And you said you've worked in law enforcement since you said 1987.
Yes.
How many years is that?
A lot. 36, 37.
Okay. And can you tell the jurors, based on your training and your number of years of experience, have you, well, let me ask you this. Before you worked in homicide, did you work cases that also involved shootings, but no deaths?
Yes.
And can you tell the jurors, based on your number of years of experience and your number of cases that you've worked that involve shootings, what the term ambush means in relation to your investigations?
This is bolstering
Something
his
sudden.
conclusion.
Unexpected. Where the victim in that situation is pinched in or in a small area that he's hard to get out of or he can't get out of. Sit and duck kind of a thing.
I hope there's recross.
Now, you see the photograph in State's Exhibit 10 NN.
Yes.
Can you tell the jurors, is that drawn to scale?
No.
And can you tell the jurors, did you intend that photograph to, or that drawing to be an exact replica of the scene?
No.
What was the purpose of using State's Exhibit, or drawing State's Exhibit 10 NN?
It was just a way to kind of demonstrate what my theory was at the time when I created it.
And in your drawing, can you, well, I want to take you to State's Exhibit. 18 and N. Now, in State's Exhibit 18 and N, can you tell the jurors in this photo and you're actually being at the scene, can you tell the jurors how many breezeways are in the building that we're looking in front of right there?
Just one.
Okay. And in your drawing, how many breezeways were depicted in your not to scale drawing?
One.
Okay. And I want to show you State's Exhibit, I think it's 17 NN. Yes. So do you see 17 NN?
Yes.
Can you point to the jurors in this different angle of the building, where on this exhibit would the breezeway be? Would it be on the left-hand side, the right-hand side?
The sidewalk leads to it. It's off camera right here.
Okay, and then you see where on the right-hand side it states that it's 17th and the building kind of intersects or meets with another building. You see that?
This here?
Yes.
Yes.
And I want to show you State's Exhibit 59 NN. Now, in this exhibit's 59 NN, can you show the jurors where in that exhibit are the shell casings that you described previously that were found in that area of the crime scene?
They're indicated with the yellow placards.
Okay. And in comparison to or in relation to your not to scale drawing in State's Exhibit 10 NN, did you place red dots on that photograph to depict something similar?
Yes.
Okay. And when you were putting the red dots on State's Exhibit 10 NN, did you put exactly 15, or what were the dots there to represent?
They were there to represent the shell casings.
Okay. And were they there to represent the shell casings, the general area where they were found?
That's correct.
And was in reviewing your drawing, State's Exhibit 10 NN, is where you generally put the red dots consistent with where we saw the actual shell casings found on the crime scene?
When I created the drawing, that's where I thought they were, yes.
Now, while on scene, let me ask you this question. How long was law enforcement generally, if you know, on scene that night or that early morning at the scene of the shooting?
3 to 4 hours, maybe a little longer, I guess.
And in the time that you were there, did anyone approach you who had called 911 to speak?
No.
Now, Ms. Abbasi asked you some questions as it relates to how many shooters Ms. Smith described. You remember that?
Yes.
Can you tell the jurors, after the initial part of your interview that you described earlier with Ms. Smith, did she consistently, when she began, after you confronted her with the physical evidence, describe the fact that there were always two shooters?
Yes.
And can you tell the jurors, during that interview, was it you or was it her who placed nicknames in relations to those two shooters?
It was her.
And before Miss Smith told you that, did you have any idea of the nicknames of who she said the two shooters were?
I did not.
And do you remember during that interview, Miss Smith describing Mr. Ooten and Mr. Mitchell running from the blue Charger?
Yes.
And can you tell the jurors, at any point during her interview, did she describe to you that as they were running?
Your Honor, I'm going to object to this as leading.
Sustained.
I'll withdraw the question. But I do want to ask you, Ms. Abbasi asked you about, let me ask you this question. Through your number of years as a law enforcement officer, have you received a number of trainings as it relates to firearms?
Yes.
And through your work with the Atlanta Police Department and the other law enforcement agencies you worked with before that, can you tell the jurors, are you familiar with a revolver?
Yes.
Okay. Can you tell the jurors, how is a revolver different from, let's say, a 9mm handgun or pistol?
Namely, there's several big differences between a 9mm semi-automatic handgun and a revolver. Revolver is self-contained. It has a cylinder. It's in the middle of the gun. When you, it's either double or single action. If it's a double action, when you pull the trigger, it rotates the cylinder and at the same time pulls the hammer back. When the hammer falls as the next shell casing comes up into the barrel, it hits the firing pin and it shoots the projectile out of the front of the weapon. Biggest difference there is there's no shell casings that come out. The operator can open the weapon and dump the shell casings out, but it doesn't automatically eject them. Semi-automatic, 9mm, when you pull the trigger, it's a very similar action, except there's no cylinder. There's a spring that when you pull the slide back, a shell or a projectile with a shell is lifted slightly up from the clip. There's a clip that catches the projectile and puts it in the barrel ready to shoot. And then when you pull the trigger, a firing pin goes forward, projectile goes out the front, the slide automatically from gas pressure gets pushed backwards. The next shell casing is lifted up by a spring. It ejects the shell casing out, usually to the right, and then it goes forward, picks up the next projectile and shell casing to go into the barrel, ready to shoot again.
Okay. Now, in the vehicle, the blue Charger, can you tell the jurors, were the defects that you observed in the car in the front or in the back of the vehicle?
Back and side.
Okay. And were there any, I guess, defects in the front of the vehicle?
Don't think so, no, sir.
And is the defects being found in the back of the vehicle consistent with the vehicle being backed in or parked with the back end closest to the breezeway and the front end kind of closest to the access road?
Your Honor, I'm objecting to this as speculation.
Well, he said consistent with, overruled.
The damage that I saw was consistent with it being attacked from the rear and from the driver's side.
One moment, Your Honor. No, I'm further at this time.
Be very quick, Your Honor.
Go ahead.
Detective, when you were speaking with Mr. Mitchell and Mr. Ooten, you were trying to figure out if they had any idea why this shooting would have occurred, correct?
Yes.
And you addressed with them whether either of them had stolen anything, right?
Overruled.
I did.
Okay. And you had no indication that that would have been the reason here, right?
I tried to figure out with Mr. Mitchell, especially of the motive for what happened. Wasn't successful in speaking to him about that.
And Ms. Smith's statement about Mr. Ryan having stolen a gun, what did you do to vet that statement?
Mr. Mitchell stole a gun.
I'm sorry. My apologies. What did you do to vet that statement?
Nothing.
You said no?
Nothing?
I didn't vet it.
Nothing.
Just took it.
Mr. Abbate asked you about whether after Ms. Smith began talking about two shooters, whether she remained consistent about that. And you had no reason to press her and suggest otherwise, right? Because that was your theory, right?
That's correct, yes.
Okay, thank you.
All right, thank you for your time. Well, I guess I shouldn't have assumed that no other defense attorneys had recross. All right. I just happened to be correct. Okay. All right. Thank you for your time. You're excused.
Thank you, Judge.
And this seems like a good time to break for lunch. So we will break for lunch until, I think we've probably got some work to do during lunch. So I'm going to give the jurors until 1:30.
All right, so what do you guys think of Detective Hogan's testimony? All right, and they are muting us out. Floppy investigation. Yeah, that should have been done on direct. Weak. Spotty at best. King JR says, I really don't think Evil Santa is lying on purpose. I think that he remembers what he remembers because what the state prepped him with. Good point. I really think he doesn't remember what the hell he did. Or like said too, right? Until he looks at the transcript and then he doesn't seem to trust the transcript. Trey Lee says, Hogan was inconsistently consistent, unfactual, not good at all. Awesome witness for the defense. Looks good on cross.
All right.
Poor
we
investigation.
need to deal with the Wunnie Lee evidence. How long do you think that's going to take?
It should only take about 15.
All right, why don't we just do that before we break then? And I'm sorry, did y'all get to the point of forwarding
Yes.
the document
Did I forward it to you, Ms. Percival? Yes.
this morning? Yep, there it is. Okay. All right, so I've got that open. So if you can start directing me to which items are at issue. This is in, okay, Instagram. Is that right?
Yes, sir. And I'll say most of the items in this packet will probably only come in if I have to impeach Mr. Lee. So we can
You know
definitely
you're
go
gonna
through
try.
it, but just to set the stage, Your Honor, about what the items in here are.
how many times we don't expect to have to use this unless we decide to impeach somebody. Just go forward expecting that you are going to try to impeach this person.
Okay, so is everything that's in here we need to litigate? Is that what it is?
Yes.
Okay.
I'll begin pages 1 and 2. So let's start with 1. Page 1 appears to be a conversation. Mr. Lee is the slimelife.shoddy. This is a conversation where he says, get somebody to buy my Switch. The next page is a photo of a firearm. I'm not sure how that suggests any sort of illegal activity whatsoever.
Your Honor, the fact that he has access to a switch in and of itself is illegal to have a switch for a firearm, Your Honor.
Have y'all charged him with that?
No, Your Honor. And for the first page, he has not been charged with the switch. And so we won't enter in page 1. Page 2 or page 3, Your Honor, which is Mr. Lee with a firearm, Your Honor.
Are you talking about the hand?
The hand, yes.
Can you establish that that's him?
It's his Instagram record, Your Honor, and it's something that I would ask.
No. If that's the best you can do, that's just a picture of somebody's hand holding a firearm, so that is not going to be permitted. Unless you ask him, is that your hand? And he says yes.
And that's why I started around that most of this is for impeachment, because it would depend on the questions that I ask of him, whether or not this becomes relevant. So that's why I started.
I mean, I guess you can present him with it if he said, if you for some reason are able to ask him, did he ever have a switch? And he says no, you can, without showing the jury, present this. And if he says, oh yeah, that's me, then we've got one thing, but okay. Moving on to the next item.
Page 3, Your Honor. I don't know how Mr. Lee is involved in this. I don't see his screen name on here, so.
I'm not sure which page you're calling page 3. Page
Well,
3 I
the
have
third
is the
page of this document, which
I'm
is
Page
page
4.
17 and or page 2313.
Yeah, we're withdrawing this page.
Okay.
Page 2314 is a photo of, this time it's a leg with a gun.
Your Honor, it would be the same position as the
All
first
right.
one.
Next.
The next one, page 5, which is the top Instagram page number 24836. The majority of this conversation is from author Foevakt. That would be hearsay. I'm not sure under what theory it would be admissible. It seems to be talking about business and a song.
Your Honor, we're going to withdraw this one.
All right. How about page 6?
I would defer to other attorneys if they have any objection to page 6.
Your Honor, I object unless there's a better, or some foundation. I heard what the prosecutor said, that they would not attempt to use it unless they lay a foundation or impeachment, but I don't know who these speakers are, except I assume that slimelife.shawty, S-H-A-W-T-Y, is the witness. But other than that,
Right.
I would object. I don't know if it falls under any type of hearsay exception.
The first post on June 4th of 2019, the witness who's testifying says the YFN expletives are at your house And then a couple lines later, he says, just stay out of their way, bro. Too much going on. I'll come light that bitch up if they play with you. So considering that we put testimony in about the mother of Mr. Bennett's home, who is a member of that same YFN group that was shot twice, we've been discussing this back and forth rivalry quite extensively. So the fact that he's talking about explicitly stating the YFN group and he's going to come light it up in reference to shooting either at or towards those people, I think it's quite relevant, and he's testifying in the stand. So any questions or explanation he wants to give for that, he most certainly can.
So what about the other part of the conversation, though? Are you not offering that part? Gonna redact that part?
So, Your Honor, this is a back and forth conversation that he has with this other individual. And so I don't know what specifically, I mean, the bottom three, I don't know what specific line that defense is stating is not needed for the context of what Mr. Lee stated here.
Well, certainly the last bit of it isn't needed, but I mean, not since all that X has been happening, we don't know who this is, and that is indicative that stuff's been going down.
Yes, Your Honor. And the state, what I just read and what's highlighted is what the state, that's why we included this.
Okay, and I'm asking if you're going to redact it, because if you throw that up on the screen, I know that the highlighted part is what you're highlighting, but the rest of it is easily visible.
Yes,
So
Your
are you
Honor.
going to redact?
We can redact it and keep that just the username so it doesn't appear that he's just speaking to himself.
Okay.
And we will take out where he says, everything else he says, that's perfectly fine, Your Honor.
All right. Page 7.
Yes, Your Honor, page 7, this is going to be a combination. We have a hearsay within hearsay. We have Mr. Lee asking who Fat was talking to. Not sure the relevance because I don't know who Fat is. They might ask questions which make it relevant, different conversation. But the response from someone who's not testifying is what that person heard. So we have hearsay within hearsay. The next statement is also from this other person who I'm not familiar with who the speaker is. Mr. Lee's response is ambivalent, just say no more. And there's not any further conversation that I see would be relevant.
What's the state's response?
So, Your Honor, this specific exchange, it's very predicated on what Mr. Lee his response is on the stand. If he says, just like the post I just referenced before, if he says, I've never heard of YFN, I have no problems with them, I'm actually quite friendly with them, they're not opposition to me, I hang out with them weekly, then these kind of threads could become relevant, where they're saying, I just heard he was with Slime, he told him he was with YFN, and then the person, again, not Mr. Lee testifying, says that those people are ops, and then he responds, say no more. That in conjunction with like the one we just spoke about, I don't know the exact question we would ask Mr. Lee, but none of these conversations, if an improper question is asked and the court sustains the objection, you will never have the predicate foundation to introduce this. And so I do think it hinges very much on how his testimony
I think
is,
that
Your
before
Honor.
you think it's appropriate to use this, y'all need to approach, because I am having a hard time envisioning how
Yes, Your
this
Honor.
would be appropriately used.
Yes, Your Honor.
Okay.
The next page, Your Honor, is going to be page 8, and a conversation between Quay and Mr. Lee. Again, I think we have hearsay. We don't know who Quay is or what his possible involvement could be. They're talking, it sounds like, about something which happened in the past. I'm not sure how that would come in as any hearsay. would be, if anything, spilling the beans, not furthering the interests of a gang, if that's even the exception they're trying to use, I don't know.
You're right. I think that falls in the same line of argument that this conversation will fall into that same line of what Mr. Atkins just articulated. Your Honor. Page 29, Your Honor, would be, I think, in line with the same articulation that Mr. Atkins just did for the page before. It's the same individual. It's the same conversation. The same two people in conversation.
It would be to potentially establish that, yes, he did know who YFN were, and that was significant to him in some way.
Yes, Your Honor.
That's potentially a better example of it than the one above. Talk into your mic. Talk into your mic and talk to me.
Was talking to you, Your Honor.
Okay. Because you're gesturing over at them.
I know, but I believe this is what I referred to the other day with regard to the person that is identified as Slat Qua, not Quay, but it's Slat Qua. One has not been identified, but it is certainly no one in this courtroom, and I believe that the state will elicit that. This is my understanding, and I'm looking at you, Judge. It's my understanding that that would be the testimony. If there's anything else, I want an opportunity to.
It was my understanding that the state and the defense were going to enter into a stipulation that any reference to a qua here or wherever it comes in this Instagram, there was a stipulation that it wasn't any of the people nicknamed Qua or Quay in this courtroom. Have y'all not done that?
Judge, that's been my understanding as well. However,
we're still working on that.
All right, well, sounds like we might need to get to it before Wunnie Lee testifies.
I agree.
Your Honor, myself and Mr. Harvey had spoken a short while ago where asking this witness, I mean, this is his thread of who is this? And then I do not know what his response will be at this moment, but I do not expect him to say it is Mr. Nichols or Mr. Huey. And whoever he says, if he says, I don't know who that is, you can ask him, is there anyone in this courtroom here today? And if he says no, I think it will be crystal clear that that was what me and Harvey we hadn't finalized it, but that was what we were discussing. The state's not trying to insinuate.
Discuss it with Mr. Matthews also.
Yes, yes, Your Honor.
If y'all come to an agreement, that's fine.
Your Honor, I will.
And why don't you let me know what that agreement is before Mr. Lee testifies?
Your Honor, Mr. Rubin, Mr. Lee's attorney is here. I will ask Mr. Rubin, and we'll have that answer before lunch, by the time we come back from lunch.
And Your Honor,
Going to ask the attorney what the answer to that question is.
So he
gonna
can
be?
ask his client, that's Mr. Lee's attorney, so we can get the answer of who Slat Quay is over the break.
Okay, and then what if he says one thing to his attorney now and then he says another thing on the stand? Are we going to have another specter of putting an attorney on the stand?
No, no, Your Honor. I believe that we have been in communication with each other. So I don't think that result
I'm not
will
sure
occur.
that that's going to resolve it, but if the state and Mr. Matthews and Mr. Harvey come to an agreement about that, that's fine. Y'all let me know.
We will.
Okay, next.
Your Honor.
So is there another objection besides we need to make sure that everybody knows who this is or isn't the Slat Qua?
I do, unless it's
Okay.
coming in under 248807 D2E. All that Mr. Lee, according to this document on page, all he says is you all got into it with them. Everything else would come from this other person. So that's my objection as well. That page really is not very illuminating on what Mr. Lee is doing to further the interests of the alleged conspiracy.
So it would be, as I understand the state's position, it would come into impeach Mr. Lee if he claims not to know who YFN is. Is that correct?
Yes, Your Honor.
Okay. And so do you need the entirety of it?
On a different page anyway.
This is, I'm looking at page 1397, the highlighted portions of 1397.
To the court on page 854, which I think is 2 pages forward or above. It's Mr. Lee, it's identified as Mr. Lee's Instagram account, and it says YFN ends be by you house. So I don't see why we would need it set, on another page.
A different one. Oh, that's true. Okay, so.
The state's position remains the same. This will become relevant depending upon the question. So this might not come in at all. And so what would the court like for us to answer?
So if there is already something in, Mr. Steele makes the point that you actually have Mr. Lee on page 854 of the Instagram record talking about them YFN ends. And so that would establish that he knows who they are, and so you don't need the others. So that's true. All right. And if you think for some reason one of those others is going to be relevant, again, you're going to need to approach before you use it.
Yes, Your Honor.
Because it shouldn't be needed for the reason that y'all just offered, considering page, whatever it was, 854. Okay? All right. And then what is this? What's on page 9?
I'll defer to Mr. Steele for the remainder.
All right.
It looks like there are notes, internal notes written over the document. I would not want that shown to the jury.
Yes.
We don't intend to introduce these notes. We're actually going to pull the actual thread, and I believe that was communicated in the email that we sent. But for brevity's sake, we wanted to show defense counsel where the language we're speaking of, but this is actually in Mr. Lee's Instagram return, so we'll find the actual, we'll have the actual pages of.
But what we need to be looking at is just the thread.
Yes, Your Honor.
Okay. And is there objection to the thread?
No.
Okay. All right.
If a proper foundation could be laid, which I believe it will.
Why didn't they just prepare that ahead of
All right.
time?
And then I just got another email forwarded about Wunnie Lee exhibits. These are pictures, maybe posts from somewhere. Is there issue about these? Do we need to litigate these? Do y'all know what I'm talking about? States 36, 37 through, I don't know.
This is just a PowerPoint of the exhibits we plan to introduce during Mr. Lee's testimony, Your Honor.
All right. Is there an issue? Is there an evidentiary objection to 36 through 46? NN and then 4Y.
And most of these, Your Honor, were in the Wunnie Lee folder that we went over a few weeks ago.
Yeah, I mean, if we've already litigated it, great. I'm just asking so we don't.
We did litigate it a few weeks ago, but as far as 36 NN, 37 NN, and 47 NN, those are the issues that I brought up on behalf of Mr. Stillwell. Those involve Mr. Stillwell, and I brought them up yesterday morning.
Okay.
But as far as anyone else is concerned, these are not things that have been litigated, except the ones that I brought up yesterday.
Okay. So does anybody else have any objection to any of these items?
Your Honor, I was proceeding on the state's email, which was sent two days ago. This is what we need to review for Wunnie Lee. So I've not had a chance to go through all of these.
Y'all are just too much, honestly, all of you, or most of you, not all of you, but a lot of you.
Your Honor, to be clear, so when we made the witness boxes from 1 through 30, 31 through 60, and 61 through 100, for the, there may be a photo here that, you forgot to put into this witnesses folder, but all from discovery. So when we're creating these, like the exhibit PowerPoint, some of it includes exhibits that are already admitted in the trial itself. It's literally the PowerPoint in order of how the state's going to ask direct questions of this witness. So there shouldn't be any surprises with what's in this PowerPoint in terms of, I don't know what day or week it was that we went through, but I know that there was a moment where we got through all of them, where the court would say, does anyone have any objections with this witness? Does anyone have any objections with Mr. Sprinkle, with Agent Burney? And we went through number by number. And of course, if an objection is raised, this honorable court will hear it from any party. But, when we say we haven't litigated or have litigated, in the state's minds, when these issues are brought up of does anyone have an objection on the floor for this witness and the exhibits the state has indicated that they may use with that witness, if there's no response.
All right, well, take the lunch break and look and see if you have objection, and can come back at 1:15. Yes.
And I can speak to one, just so everyone knows. I know I have an objection now. I didn't realize it was in this PowerPoint, but it was something that was recently, the state recently indicated that they plan to use, which is number 12. That's a screenshot.
I don't know what you mean by number 12.
Number 12 on the PowerPoint. It's
46,
slide 12,
okay.
46
NN.
And that's just a screenshot. I believe that to be a screenshot of the beginning of a 15-minute video. And I believe that video is titled something like A Night with YSL and 4L. I've watched that video. I've reviewed the video. It's basically a group of young men at a music studio and in the parking lot outside the music studio, and they're kind of interviewing each other, and I guess it was released as a promotional type thing. But I don't know why that 15-minute video would be relevant or admissible.
I can email over the different timestamps that are the most relevant portions of this video. It's not the entirety of the 15 minutes, and I'll do that before I leave court.
So are you saying you are only planning to play
Certain portions of the video.
certain little distinct parts of it?
Yes, and I'll send that over right now.
Okay, do that right now, and then when we come back at 1:10, now we can take it up. No, I'm not. No. All right, so anything else we're gonna need to deal with? Oh, so the limiting instruction, if nobody has anything else to add, does anybody have anything else to add on that limiting instruction that I'll read before Mr. Ryan's conviction is entered?
Well, I don't know as to whether we made a number 1 or number 2 decision.
Yeah, I decided it on my own because nobody got back to me. I picked number 1.
That probably
So,
would have been my pick, but I just,
all right.
I
good.
want to reiterate, though, that I agree with Mr. Steele's position that ultimately neither one of them eliminate the confusion from, boy, we can use some of this against some of the people, but we can't use some of this against some of the people. So I want to reiterate that
Okay.
and just reinforce that as well.
All right, so I have, at this point, I mean, I can send it back out, but let me just do that. Let me just do that real fast. And I haven't changed anything with regard to, let's at this point just focus on the Mr. Ryan one. Let me get that over to Ms. Pursfield so she can get it over to y'all. But I've taken out the reference to overt acts numbers or overt acts at all. Because when I started trying to craft something that would explain, hey, this is to overt acts, but that's not all you have to, find if you're going to find, when you're making your determination on count one, I realized that it is not really just to overt acts anyway, that it could be taken into consideration in their determination of whether they think anybody was conspiring to engage in a pattern of racketeering activity. And that just goes down a whole, I don't know, wormhole, black hole, I don't know what, of having to stop and give the final jury instructions now, which I'm not going to do. So I'm just saying, count one. Yes,
Your
sir.
Honor, on behalf of Mr. Stillwell, we appreciate the court's efforts. And this is a difficult situation, and we are just, for the record, joining with the thoughts of Mr. Steele and with Mr. Harvey, that a jury instruction is not going to be
enough.
not enough. But I just wanted to place that on the record.
I mean, I assume everybody's joining in that objection, and that's fine. I've looked at a lot of different federal circuit case law involving RICO cases, and it appears that even when a conviction of a co-conspirator comes in, as long as a limiting instruction is given, there's not a confrontation clause problem.
And I just feel the need to bring this up at some point sooner rather than later. There are convictions of Mr. Jimmy Winfrey, my client, Mr. Stillwell, and I believe Mr. Nichols that have come into evidence.
Right.
We brought up these issues previously with the prior judge, and we were not given. We asked for them not to come in. We asked for limiting instruction, and we were not granted those things. So I don't know how we're going to cure that for those.
So I mean, I thought that we had discussed the Winfrey one, and I said I would just, at the end, when I remind them of all of the things that are only for certain purposes, do that. I didn't know that anything of Mr. Stillwell's had already come in without a limiter.
They have, and I believe Mr. Nichols.
Okay. All right. Well, then I will add those two to the limiter I'll get at the end. And again, they're not supposed to be deliberating until the end anyway.
Okay, so when you're saying at the end, you're talking about jury instructions.
My jury instructions, yes. All right. See y'all in a fairly short amount of time.
Oops. Did Steele just say Your Honor? Or thank you, Your Honor. All right. So it seems like they're finally going to the lunch. Guys, if you missed it this morning, I do think the cross-examination with Detective Hogan was a really interesting watch. So definitely check that out if you had missed it. If you just joined in, they were doing some evidentiary arguments about Wunnie Lee, who there's one more witness being called today. I think it's a medical examiner. And then they're going to, I guess, put Wunnie Lee on the stand. So see how that goes. His attorney's here and ready. And I think that will be a very interesting chunk of testimony there. Wunnie Lee has an Alford plea, just so you guys know. And hopefully Love doesn't get up there and read the factual basis out loud again like she did with Mungtung. As an update there, I did go and look, and the adopt a family thing that I saw, it's actually my friend doing it like in person in a close-knit circle, so I don't have anything to share in that regard. But Army Nurse had also gave a shout out to the organization Inota, I'm probably saying things wrong, CASA in North GA. Now that stands for Court Appointed Special Advocates. It's a program for children. So I grabbed that link and dropped it in the chat. at the recommendation of Army Nurse here. Army Nurse says the organization I endorse is Inota Casas in North GA. Their mission is to mobilize community volunteers to advocate for abused and neglected children. So, sounds like a great program to me, and I'm hidden here. Say hearts up here for an endorsement of Vouch from Army Nurse. So thank you for that shout. Link is in the chat there for you guys, and also add it in the description of this video. So that'll be there pinned for you guys. Thank you so much for pinging that. And I also did see a bunch of vouchers in the chat for a Samaritan's Purse. I did see that they do an adopt a family program for the holiday season as well. I just didn't see anything specific as far as adopting a family for, flood relief. So that was my update there on that, since I had deferred that earlier. Shout out to Toothless Tiger, who says, Kat, isn't it amazing how the experts/professionals remember nothing from 2 years ago, but they want these drug users at the time to remember it all? And it is really interesting. It's like they give no consideration or just want to barrel roll over how somebody's memory could be impacted by a substance or, whatever they may have been doing during the incident that they're being asked to recall, especially years later. But, we'll prep these other witnesses, we'll prep particular witnesses, we'll show them what we want them to be able to remember fresh when they get on the stand. And it'll be a very good direct for someone like Detective Hogan. You guys were saying he caught cross amnesia. On direct, he was able to answer questions with details. Then on cross, well, I'm sure you're going to have a transcript to refresh my recollection. Or at least according to the transcript. So, it seems like a cliche, and this is not unique to this trial at all, but it is a great reminder. Good to see you, Toothless Tiger. Toothless Tiger also does a ton of content, you guys, so I'm going to drop Toothless Tiger's channel link in the chat. If you want to go and check out more content, make sure you do that. Jennifer Devine might be right here. Leah needs an emoji. And I think I saw in my notification someone had tagged me in a picture, but it's like a side profile and it's so blurry. So maybe we'll Google one and get one up for her. I imagine we're going to see more of her and or Mr. Williams today with the medical examiner and Wunnie Lee on the stand. So I'll try to do that one. At least a special limited edition Leah Abbasi emoji here. I tried to actually find one for Mr. Williams yesterday, and I only really had an old picture of her come up, so trying to figure that one out too. It just sucks when they're at the lectern, like they're not facing the camera. Thank you for the 2. I think we'll get on that one. And then YouTube Watcher says, or maybe it's White Watcher, YT gets used in 2 ways here. Says we don't want to call anyone to help them any further. Yeah, right? I still think it's very interesting they did not want to call the other 2. But I do think the point came across. The detectives either took them at their word without verifying, didn't call them to confront them with the things they felt as they learned more didn't add up. So I think the point was made without having to put them on the stand. Elemental Neon says, I feel like I'm watching, we read this one, but a TV attorney with Miss Abbasi. I'm loving it. That was a really nice, exciting cross-examination. One happy white girl says, I was born and raised in Zone 3, Browns Mill Road. The policing has been this way since I was a little girl back in the 70s, especially back with the Red Dog Squad. Oh boy, I can imagine. Thank you for sharing your insight there. We were talking a bit about Zone 3. And, the same type of policing and or lack of investigative work, proper investigative work, work that seems like there's actual care for the pursuit of truth, justice, keeping the community safe, might be lacking. And it could expand beyond Zone 3. But really great to have your insight here. Thank you so much, and always good to see you in the chat. Chloe Albert's Revenge says, when witnesses say transcript on the stand, it's a symptom of a condition called Jen McCabeosis, not Jen McCabe. Oh, put a 1 in the chat if you know what Jen McCabeosis is referring to. Oh boy. That was a heck of a cross-examination, cross-amnesia. There's no cure, but going to confession helps. Shout out to Chloe Albert's Revenge. And side note, Chloe, have you caught any of the Sarah Boone stuff? Did you catch her testifying? Curious what you thought about it. KL says, everyone please hit that like button. Appreciate you, KL, for the reminder. Thank you so much. If you guys could hit that like button while we're on lunch, that'd be awesome. Yeah, a bunch of ones in the chat from people that, and I guess I didn't give a 2, so I won't see a 2. But, you know. All she seemed to remember, we made peanut butter and jelly sandwiches in the back of the car, and, we listened to It's Raining Men. It's Raining Men was playing on the Bluetooth speaker in the kitchen. And everything else we forgot, or just said it was a butt dial. That was Jen McCabe's cross-examination testimony in the Karen Reed trial. And what a trial that was. David Newth says, I feel like the judge has reached a point of being just done with everything and not willing to deal with the consequences of the state's sprawling case. It only took her 50 days to get there. And it's like, this case is just a monster, and I'm still a little bit surprised that the defense attorney didn't make the argument that, hey, you know, these jury instructions, we get that they normally work, but when this is a case of 150 days, the jury's ability to remember what they're instructed to do is one thing, but the implication, you know, if we instruct them one time to not consider this against somebody else, the reverse implication is, okay, we consider everything else about everybody else all the time. So that might not be that significant when there's only 2 instances that we're talking about. But when we have 150 days of trial, a ton of stuff that besides count 1, it doesn't really relate to all that much else for the other co-defendants. Like we've seen entire testimony where the act itself is supposed to fall on the shoulders of somebody that's not sitting in that courtroom. And so Steele is arguing, you know, it's going to give the reverse psychology to these jurors that, all right, well, we can use everything else against everybody if we instruct them specifically on one thing. But I didn't really hear a specific argument be made that I think this is a unique circumstance because we have 150 days so far. He did mention going through December for a case in chief. But I think if you argued that a little bit more strongly, maybe it would stick. So, oh man. Right, I'm her, says, we forget about what happened from day to day. You can't think the jury will be able to deliberate this. It will be in the chat and we'll be like, wait, didn't someone say that? Didn't that happen? And they don't really have that same type of like crowdsourced resource access, so. Oh boy. But David New, thank you so much for the 10. I agree. Always love to see the hedgehog. Peter Ortiz gifting 10 memberships here. Peter Ortiz, I hope you are feeling better. We have an injured index finger, so Peter Ortiz unfortunately can't make all the gang signs. Gotta use different fingers now to do the nose wipes. Great to see you, Peter. I hope you are doing well today. And you guys know the drill. If you could drop some boom emojis in the chat, we throw those for Peter when he gives us gifts. So big thank you, Peter, for your support and for generously gifting 10 memberships. And then SDS says, thank you to the chat. Leah Abbasi is the lady's name. Yeah, we definitely need to know her name. If you didn't know it already, definitely got to know it after today. Thank you so much, Stephen. Touche says, Abbasi proved once again that the defense attorneys are just better. They can take an L from the judge, pivot, and still fry the witness and serve them on a platter. And this is a really big deal for Ryan's counsel, right? We don't get to see too much of them because he's like stuck in here because of this Jamari Holmes murder and the state's theory that it was done as a conspiracy and, you know, as part of the RICO. So now this is their time to really shine, and they've got this appeal coming up for him. So any statements they can lock in from somebody under oath can really be a big play in this appeal. Same for the state. They should really have that on their mind as well if they care about, you know, keeping that conviction in place. So really big day, you know, medical examiner. I think that's where we'll see some of the autopsy photos and stuff. But I think Wunnie Lee is going to be very important testimony for a lot of reasons. So good to see you, Touche. Always love your food for thought. Shadiggy says, prayers to the people planning to protest at Rice Street. Fresh meat, sorry. And that can be true too. So I guess the protest is going to be at Rice Street and not at the courthouse. I think I asked earlier if it was the courthouse. So, but that's something to watch out for too, you know. Looking for fresh meat, looking for an excuse. And I don't necessarily agree with people getting in the way of somebody's right to peacefully protest. I don't agree with that. But at the same time, I don't trust people to, not people, I don't trust the government to just say, hey, people were gathering peacefully, so it's fine. I can picture very often someone going, they weren't protesting peacefully, so we had the right to arrest them, detain them. So, unfortunate, but that is a concern. I think you're right. And thank you for the context that it's at Rice Street. She Sells Seashells became a member. Thank you so much. The Honorable, yeah, that says, if a tall shooter never approached the vehicle, then how were bullets on/around the car? 2 shooters and neither were Rod. BJ or the other friend shot back. And, you know, that's still unclear to me. And I think the defense's job was to create some doubt. And I think they created that doubt. I think there's a possibility, there's still a possible storyline that the way the detective thinks things happen could have been how it happened, but I don't have the most confidence that that's the most reasonable conclusion after that cross-examination. So I think the defense attorneys did their job. I think they really did their job. Thank you so much. The Honorable, yeah, that. You know, I love these name changes. David Newt says, am I the only one who thinks the witness sounds/looks like the actor Jim Beaver of Deadwood and other Westerns fame? Hold on. Jim Beaver, Deadwood. All right, guys, let's do a comparison. Oh, I can see it. Okay, let me pull this up. No, wait, the other picture was better. Why'd it go away? We'll just do the image gallery. I can see it. I can see it. Oh, man. I agree. I don't know the show, but I agree with this comparison here. And then David Newth says, state needing to hire actors to play witnesses now? It might be a little bit more consistent. Thank you. That's a really good comparison. Chloe Albert's Revenge says, it looks like Detective Cowboy Santa attended Lil Woody's Testimony University of Mechanicsville too. I don't recall. I didn't think they would accept his enrollment. Yeah. Just showing up there, kicking his feet up, sitting in one of those little old school desks, learning how to say, I don't recall. Shout out to Chloe. Thank you so much for all your support. And not just here, but also, you know, other channels as well. You always bring great commentary, no matter the subject, which is just incredible how much stuff can fit in your brain. The Fashionably Fit Life, thanks so much for the super sticker. It's a mic drop. There we go. Love it. And Fashionably Fit Life also says, I feel the state did a short direct so they can see what will come up in cross. And then on redirect, they'll ask more questions. I'm sure Steele is taking notes since he's the attorney for appeal. And we've had some commentary and even some sustained objections about, you know, going beyond the scope of what was in direct. And I think even redirect sometimes we've had some beyond the scope. It just kept happening. They kept trying to expand it. So good point. Possibly an argument for appeal. I don't really know how strong of an argument compared to some of the others I think they're going to argue. But man, Steele's notes for an appeal, his whole team, really all of these attorneys, the amount of stuff they have to put together for this appeal is just probably awe-striking. Like, just crazy. And thank you so much for this is a generous super chat. Thank you so much, Fashionably Fit Life. Tofo, or maybe it's TOFO, says, we all know you're going to use it, Hilton, though we don't intend to use this unless we impeach the witness. We might need a we don't intend emoji. If we can fit it. We don't intend. That might fit. Because that is a common one. That is a cliche of this trial. Thank you so much for the 2, Tofo. Lisa Waller says, prosecutors have been showing the videos to all their witnesses before they take the stand. So why didn't the prosecutors show this detective? Right? Seems like they prepped him. He said he reviewed, I don't know specifically if it was just transcripts or whatever, but he did review some stuff in preparation for his testimony. So why not refresh on certain things? Is it a question of pragmatics or is it a question of strategy? We don't want to have this at the forefront of your memory. Great point, Lisa. And I think a lot of the chat was asking the same thing. Peter Ortiz says, it would be nice if the government would do half as much as the volunteers do to help people in need. Well, and I think at the end of the day, change really does come down to people, and it sucks that sometimes people have to get through some red tape to be able to bring help forward. I always think back to the example of, if someone's homeless, needs food to eat, restaurants could be afraid of lawsuits, right? So they don't want to give away extra food to the homeless because of potential lawsuits and liabilities and insurance risks and all of that. And it just kind of seems like... So I agree, Peter, this is a great message. And shout out to the people out here doing it. Hold on, what am I saying? Not you two. I don't know what I'm missing. Could be anything. But yeah, again, especially with these disasters, I mean, a lot of people are still talking about flood, hurricane victims. There's also been some fires, some wildfires that have been an issue. And when I go to a news ticker, that stuff doesn't pop up on the screen. I hear continued coverage about that stuff from you guys here in YouTube chats and other chats. And then I open up X and see people talking, combining resources. And I really love crowdsourcing in that way. So always, if something's going on, feel free to drop it in the chat. We do try to keep politics limited, but you can talk about the causes and the helpful things. As long as we don't end up biting each other's heads off. That's all I ask for. Make the mods' jobs easy. Lightning Flow says, Wunnie the slime, Wunnie the slime. Yeah, and that's like, it's in his username, right? So I think he's a little bit, in his name, he inherently seems like he's slime, even though you can self-claim and make any name you want. But I would imagine if you're hanging around affiliated with people and nobody yells at you for using slime, if you're not supposed to be claiming or false claiming, maybe the jury will infer that you are in fact slime. But if I was a defense attorney, I would say he does music. So he could be slime because he's YSL, the music label. And we're going to see these plea terms. As part of his plea, he had to say YSL was a gang. And he's made public statements saying that it's not illegal to be part of a gang. And that kind of reinforces, yeah, I said they were a gang. And then out of court, if I'm saying it's not illegal to be in a gang, kind of seems like I'm telling the truth when I signed my plea deal. But it's still a plea deal. Wunnie Lee had a murder charge and he got this Alfred plea, right? So I think we're going to see some very interesting cross in terms of this plea deal. We'll have to see what they do. We'll have to see. But yeah, Wunnie the slime, and I love that you put the bear emoji in here. Violet says, Abbasi is an impressive litigator. I agree. Very nice to see Ryan's counsel in action. It's rare in this case because they're not tied into all that much. But it's been really interesting to watch. Lightning Flow says we need an in as much as emoji. We might need it to be like one word, in as much as, and it just like runs and connects. That could be a good one. Although love hasn't been around as much, she loves to use in as much as. Also, big shout out to Kendrick for the 2 on Cash App. Very nice of you. And Rodney also sent over a 20. Thank you so much, Rodney. And no comment, just appreciate you guys. Chloe Albert's Revenge says Sarah Boone wouldn't have happened if she'd gotten the Polly Pocket she wanted for Christmas as a kid. Maybe Cowboy Santa can help with that. Her testimony better than expected, but she thinks it's in the bag. Yeah, I think she's overconfident. And I really liked the way Excited Utterance put it. In Dolly, they had a whole panel with MLS, Dolly, and Excited Utterance. You know, everybody thought Excited Utterance was crazy for saying that Attorney Owens could be Sarah Boone's Jose Baez. But yesterday, the consensus is no chance in hell for an acquittal for Sarah Boone, to maybe some chance at all. Not a very good chance, but from 0 to some, however minuscule chance, which is a pretty big deal. So it was a great panel. Excited Utterance is doing Sarah Boone rewatches every day starting at 6 p.m. So we'll make sure to link to that again as the court day winds down here. But if you want to hop over there, since we're on lunch break anyway, and give Excited Utterance a follow. She covers other trials as well, but that's, you know, Sarah Boone is the court trial to watch this week. So there's her link in the chat there. And yeah, it was great over there last night. I was behind, so I didn't really get to chat, but really, really great panel over there. And then Q has been a member for a month. It says pushing P. Pushing positivity. So let's see, we are, thanks to Thugger Daily, and it's not going to be the most interesting thing because we don't have the PowerPoint. But yesterday at the end of the day, do you guys remember Whitaker and Steele having some conversation about the PowerPoint presentation that the state plans to introduce through Detective Marissa Viverito? And Whitaker said, is that like the Operation Planters PowerPoint? And Steele said something to the effect of, it's just as bad, or it might be worse, or something like that. So we have a motion to eliminate here. And as always, shout out to the Honorable Thugger Daily. Let's get his link in the chat. Pulling this one out for us. And we won't really get all of the context because the slides aren't here, but we can see some of Brian Steele, Keith Adams' reaction to it. So let me make this bigger on the screen, move myself up. And so comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby files his motion in limine number 67 to exclude the PowerPoint exhibit entitled State v. Marquavius Huey that the prosecution is purportedly introducing at trial through Investigator Viverito in the above referenced case. Now I imagine this is supposed to be et al., but who knows? The state may have left that out of their PowerPoint. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. The first slide is entitled State v. Marquavius Huey as an introduction. Mr. Williams asks that this slide not be used as it is not relevant to the trial of this case. And we have a footnote that says the YSL background. So there is a background on the slide with something with YSL, the background of this slide. Objected to on all slides. So they use a theme. They go into their PowerPoint, they go into Canva, and they choose for their theme to put YSL as a backing image for all of the slides. So slide number 2 is cumulative of previous testimony given on numerous occasions by numerous supposed experts over objection. And this is why I thought it'd be interesting, is this language here, this shade from Steele. Numerous supposed experts. And also shout out to Flesh of the Gods. He said it's not as bad. Not as bad, but close. And thank you, L1915. Mr. Williams objects to slide number 3 based upon OCGA 24-4-403, prejudicial, and 704B, deeming Mr. Williams the gang leader, and that Mr. Williams' musical career promoted the gang on a national level. Moreover, pursuant to OCGA 24-7-704B, investigator, and this is, if you guys got to look at that transcript, I haven't had time to do a reading of it. It's like 100 and something pages. But there were a ton of arguments at this Daubert in October of 2023 for investigator Viverito. And I think Bruce Harvey, I think even Carlton Matthews, and Steele kept making, these objections that she can't get into the intent, the mindset. So here Steele's going to preemptively mention the same issue. Investigator Viverito cannot testify, even as an expert, that there were attempts to conceal criminal activity through Young Stoner Life Entertainment label, as same improperly comments on Mr. Williams' intent, an essential element of the crime, and is speculation. The balance of this slide is also cumulative/repetitive and has been testified to by other supposed gang experts. Slide 4, also cumulative. Non-admissible expert opinion, and same is prejudicial pursuant to OCGA 24-4-403. Again, cumulative, because the same information has already been testified to over objection by previous supposed experts. We're just going to keep repeating this. Just going to keep repeating this every time. Mr. Williams objects to slide number 5 as same contains a photograph that has already been shown to the jury, and the cutouts defining slat as this term has been discussed multiple times by multiple witnesses, including supposed gang experts. Mr. Williams continues his objection to slide number 7, which targets lyrics from art, specifically songs without proper foundation, as some sort of admission against interest. This honorable court has already overruled this objection. So we're just putting it in here for keep it on the record. Slide number 8 is cumulative because it's simply emojis from the internet that have already been discussed through numerous experts, witnesses, and non-experts. And the background is a platform of YSL, which really did not go with the emojis. So I want to see slide number 8. Is it just like a bunch of amphibious emojis, green hearts? Do we get the cactus to make an appearance? Just getting a bunch of emojis. 9, the law comes from this honorable court and not from a supposed expert witness, and hence slide number 9 should respectfully be omitted. So it seems like they have a slide in there trying to define the law for the jury to consider. Slide number 10 is a photograph and social media posting and a recitation of reports and opinions which are testimonial. And Mr. Williams objects to the same under Confrontation Clause. So they're trying to bring in other stuff through Viverito where the actual individuals writing or speaking the message aren't going to be called to testify. Slide number 11 is a screenshot from the Atlanta Police Department of Mr. Huey's booking photograph and arrest in 2019. This is objected to by Mr. Williams under OCGA 401, 402, and 403. Mr. Williams objects to slide number 17, as same is hearsay, and same should not be displayed to the jury concerning an October 2nd, 2020 jail call between two persons who are not witnesses and are not part of the supposed conspiracy on trial. So no co-conspirator exception. Hence, this is hearsay testimony and the slide should not be shown. Mr. Williams objects to slide number 18 as same contains photographs of the alleged speakers, especially with the word in red, victim, and the background YSL as if this is a crime of YSL, which was determined already by this image. So basically you're bolstering with this. Slide number 19 is a summary of a purported October 4th, 2020 jail call between Miss Alford and Mr. Alford. This should not be summarized in writing before the jury, violates the best evidence rule, is hearsay, and does not further the conspiracy. Mr. Williams objects to the photographs in slide number 20. Mr. Alford and Miss Alford and the backgrounds of YSL. Slide 21 contains investigator Viverito's explanations that she is confident. So just imagine what the slide says. Viverito's explanation that she is confident that Mr. Huey committed armed robbery and carjacking. and contains other statements which are inadmissible pursuant to 704B. So intent. This slide is not relevant and is extremely prejudicial. So see 401, 402, 403. Further, this decision/conclusion is not beyond the ken of the jury, so they don't need an expert to decipher this for them. It's their role and it's within their capacity to make the determination themselves. Slide number 22 contains items supposedly belonging to Mr. Durham, as well as other items purportedly located in Mr. Huey's home at the time of his arrest. Based upon this information and belief, Investigator Viverito was not present at the time of Huey's arrest. So this is a Confrontation Clause violation / inadmissible hearsay. So who's saying that this stuff belongs to this person? Who's saying that it was located here? We're just going to have Viverito say, I have the answers just because. Mr. Williams objects to the photograph of Mr. Huey in custody on slide number 23. Mr. Williams objects to slide number 25, which contains text messages from an unknown person known as BG, which appears to be requesting illegal contraband, specifically illegal drugs, and is hearsay. Because a buyer/seller are not in a conspiracy together, this cannot be a co-conspirator statement. See Darville v. State. Additionally, there is no evidence that this is an act to further the supposed conspiracy. Slide number 26 should be excluded because 401, 402, 403. Now, as we're going through this, obviously this isn't the full context because we can't see the slides. But what do you think, the balance of either stipulations, what the state will agree to without needing a ruling from the judge, and or the rulings from the judge? Where do you think that balance will lean? So, slide number 27 contains a text message involving a presumably illegal drug deal with location data. Unless this can be tied to an act on behalf of a conspiracy, the individual drug deal is not admissible under 801D2E. Mr. Williams objects to slide number 28, as same contains hearsay through a telephone number ending in 8076 and does not appear to further conspiracy and is double hearsay. Slide number 29 contains hearsay from an unknown person texting with telephone number ending in 8076, and these texts do not appear to further a conspiracy. So we don't know this person, and so there can't be a co-conspirator statement exception because there's nothing to suggest a conspiracy. Mr. Williams objects to slide numbers 30 and 31 on hearsay grounds, as same is not a co-conspirator statement to further the conspiracy by wanting to give back property and being tied into killers. This statement cannot be used against anyone. And I wonder if this is the, you better give it back or whatever text between Huey and Jeffrey Williams. Slide number 32 is an exact replica of slide 30 and 31, and hence is repetitive and should be excluded. Mr. Williams objects to slide number 33 based upon the summary and improper opinion on what excerpts of Mr. Huey's cellular telephone shows. This is more like a closing argument. Slide 38 contains hearsay from an unidentified speaker, which does not further the conspiracy. 39. Unless the photograph contained in slide number 39 is properly admitted into evidence and a foundation is laid, this would be hearsay/confrontation clause for Viverito to attempt to lay the foundation based upon information and belief. And then 40. Williams objects to slide number 40 as same contains an unidentified speaker, which does not further the conspiracy pursuant to 801D2E. So it seems like there's about 40 slides, and we've got 20 issues of 28 of them, plus the issue with the background on all of the slides. So that will be a time. Let's see. This is the link if you want to check this out. And I know it isn't the most interesting without the actual slides. We had the slides as an exhibit for that Operation Planters motion in limine, 47, 49, I forget which one it was. So we don't have it attached as an exhibit here, but we've heard some of the context. We can kind of get a feel for what some of these slides might be suggesting. So there you go, that is in the chat. And I don't know if They're just doing lunch, right? They're not coming back and arguing something, right? Maybe they will. Maybe we'll find out that they've got something to argue still. Also, shout out here, Gwennon says, Bon Jovi owns a restaurant where people can buy meals for the homeless. That is awesome. They put a receipt on a board that the homeless can pick up and use for a meal. That is really cool. And I see some cafes and like sandwich shops kind of has something similar, pizzerias, which I think is really cool. Love that. And I think Andy Warhol says whenever he went out to lunch, dinner with someone, he would either order something and not eat it, or he would order 2 meals, but there would always be something he'd order right away in a to-go box. And as he was leaving, I think this is when he lived in New York City, he would just leave it somewhere for someone to find and eat. He'd put it like right up on a step up high so you knew it was clean and not getting bugs in it. I thought that was really cool. Shout out to Big Baby Jane. So Big Baby Jane went to Delphi. I was able to get into the courthouse in Delphi. If anyone's tuning into that trial, I have some deets. Spill the deets! If you ever wanted to come up, I can drop a link for you, Big Baby Jane, if you just want to drop it in the chat. Either way is fine. I don't think anybody in the chat will be opposed to details. So, but welcome back. Sounds like if you're back, you already did the drive back home? If you did, I hope it was a good trip. And glad to see ya. Okay, this is the phrase, Miku. So Miku says we have a local pay what you can. Yes, restaurant, that is great. I've had to use it when I had literally 0 cents to my name. Yep, I forgot the terminology, but that's the other thing too. Pay what you can to get the meal. Super, super awesome. And Beck says, yes, they still have stuff to talk about. So they should probably be coming back. Because we're going to be 15 minutes. We're going to be at the 15-minute marker. And 15 minutes never seems like enough. Man. And also here, Mocha is me, says, hello, chat and mods. How is the jury supposed to remember all 20 to 50 different jury instructions that will exist by the time this is over? Can you imagine if the jury, they come out, they say, hey, we have a question. We need to ask the judge. And they send a question like, which stuff were we supposed to forget again? Like, just a note that makes it clear they can't remember what they were supposed to do or not do, remember or not remember, strike from their memory or not. Like, to me, that would suggest error and probably leading towards a harmful error if it's acknowledged by the jury. And yeah, I'm sure they won't. But just imagine. Imagine if, like, the chat was the jury. Would you guys collectively... Alright, chat, if you guys were collectively the jury, and you were arguing with each other, and you can only send one post-it note to the judge. You guys got to deliberate and figure out where you're going to put on this post-it note to the judge. What would you say? What would you ask for? What would you do? Man. Crazy. Right, they're going to need a list, a binder of the instructions. The instructions themselves, like at the end of the trial before deliberations, and then a binder to refresh your memory and all the things that you were instructed during the trial. Oh, man. Love this here. So in Norfolk, Perfectly Frank's here. Great name, Perfectly Frank. Love that. Has a no questions asked meal program. If you don't have the money, just walk out after the meal. Every meal I have there, I buy 2 more. Also 10 meal deals. Very cool. Very cool. Love that. And I also just like the idea that the honor system can survive. That there's enough good faith use of something that's based on an honor system that it's sustainable. And also, not to steal, what was this thing that Thugger Daily did? I mean, not Thugger Daily, Doug Weinstein. Both honorable. It's gonna take. Let me see if it takes me to TikTok, and then I'll open it.
Okay, it's time for this. Let's talk about bullshit for a minute. Now, Mr. Frankfurt wrote an amazing book about the difference between bullshit and lying. In lying, the person telling the lie knows what the truth is and is trying to hide what the truth is. Bullshit is completely different. And you guys have seen some bullshit in this trial. In bullshit, the person attempting to persuade, the person spewing the speech, absolutely knows, or maybe doesn't even care if what they're saying is the truth or not the truth. Okay, so they're not trying to hide anything, they're not trying to cover anything up. It's that the truth is irrelevant, and all they're trying to do is persuade. So I have to say, in this trial, there's a lot of bullshit.
That's Doug. The link to that TikTok is in the chat. Oh man, and now I'm using TikTok now because of Doug Weinstein. I've tried to resist. Not for any reason. I just, having another app is just another thing to keep track of and then feel bad that I'm behind on. So try to avoid adding another one to the plate. I'm busy like Detective Hogan. But yeah, we have some motion in the
I know we
court.
still have the PowerPoint presentation regarding Wunnie Lee. Is that what you're talking
Yeah,
about?
that's what I'm talking about. What within there? Thank you.
Your Honor,
Yeah.
I was able to review the times indicated by Ms. Hilton in that
Okay.
email. And on behalf of, I've discussed with Mr. Steele, we don't have any objection. I don't want to speak for anyone else. But I didn't see anything that we object to.
Okay.
In those specific times.
As to the specific times, which, Ms. Hilton, that's all y'all intend to play for that one video, 48 in or whatever it was. Okay, anybody else have objection to those specific times? In 48, I think it was, I don't know, I could be making that number up.
I think it's
Whatever the
46
video
November,
was.
November.
It's 46.
46, okay. All right, I'm taking the silence as no one has any objection to that. How about any of the other exhibits that are contained within this Wunnie Lee?
Yes, Your Honor, page 5, 40 November, November. Just have an objection unless they can lay the foundation because Wunnie Lee is tagged, but I don't know who tagged him.
What is this a picture of?
It's a picture of him sitting in the courtroom during Mr. Ryan's trial.
45?
No, 40 November, November, page 5.
Oh, page 5. 40, okay, sorry.
Your Honor, we actually redacted all of the other content that was actually on this post because I believe Mr. Lee will say that is him while he was sitting in the courtroom. This was during Mr. Blaylock's initial trial of the murder of Mr. Holmes. And our initial understanding, and he had said something different today, was that he was in court when the witness who testified yesterday, Ms. Smith, was testifying and sent her a brain emoji and a rat emoji. And so this was evidence of him being in court.
Okay.
However, he has said to me today that he was not present during her testimony, but this does show that he had actually went to court that day. So things have changed just slightly, given his testimony, but at one point he was in court watching that trial, and essentially he sent these emojis to Ms. Smith, And so someone captured him on video and tagged him in it along with the post also reads free little Bali, free little ride. We've taken those parts out of it because the individual who posted it is not.
All right, I'm not following, I follow what this is a post of, but I'm not following why you're going to be using it. Or I don't understand what you're saying, because you're talking about his testimony and his statements changing. So what do you mean?
So
Why would you be how would this come up at all?
to show that this was a photo of him in court
Okay.
when the witness was testifying, and based upon what Ms. Smith advised us, I believe, or matter of fact, his phone was taken on the day that the posts were made. So back in 2021, during the trial of the case, we believe that Mr. Lee was present in court. While in court,
Yes. And that while in court, he sent those emojis?
he posted those emojis. We believe he sent them while in court. He posted those emojis. Whether or not Ms. Smith was on the stand is something he's saying. He never saw her on the stand. That's what he is saying. What we know is he was in court when those emojis were posted. Whether or not she was on the stand or not, we don't know. But he was present in court, we believe, when those emojis were posted. And so this was just proof of the fact that he was sitting in court in or around the time that these subsequent messages that are coming after this post were posted.
How are you, this is a picture of him in courtroom 7E, apparently.
Yes.
How are you proving that it is during Mr. Ryan's trial? Am I missing something?
He is a part of our, let me
Are you
pull
going to
up
be able
the-
to establish when this picture was taken?
Yes, I believe he will admit that he went to the trial and saw the trial
Okay.
himself.
And which
I believe he
case,
will admit that.
why will
this-
you need this picture?
to show proof of those things. The same way we have a responding officer who goes to a scene.
So you're going to put it up and then say, is this you in court during the Ryan Blaylock trial?
Yes.
Okay. And I guess if he says no, he says no. Okay. So in terms of the objection, then,
If they lay the foundation,
I'm not sure what you mean by if they lay the foundation. So they're going to present it to him and say, is this you in court during the trial? And he'll either say yes or he'll say no.
right, if he puts himself there with the date and the time that they're saying, then that's this foundation. But if he doesn't, if he says no, then it shouldn't come in because he didn't lay the foundation.
I agree. Okay, so that's that one. What else?
And then the next one, 41 November. That's just a screenshot of his Instagram.
40. Okay. Hang on. Hold on. All right. And so what is this? A relevance objection?
Correct.
Your Honor, so for 41 and this screenshot was taken along with 42 and 43 on the day that we learned of the emojis being sent to Ms. Smith. And so this captured that this was his Instagram account direct messaging the witness, Ms. Smith, with these emojis. And so 41 and 42 and 43 and establish that.
So that would be.
I am sorry that I am not following you, but are you saying that that day in court, his phone was confiscated and screenshots from his phone were taken?
So we learned about the emojis being taken.
Thank you.
Our office then went to his actual page and they were able to, excuse me.
Okay,
Let me
you
check
said
first.
something about his phone having been taken, but
His
that-
phone was also taken in court, separate and apart from being able
Okay.
to capture the images from his Instagram page that showed him communicating with the witness.
All right,
And I
so walk me through what on 41 NN shows him communicating with Miss Smith. And I'm sure this is me just being from a different generation than the Instagram generation, but.
And I'm so 41 NN, when the witness reached out to our office, she screenshotted 41 NN, which is his page. Then she
So
also
she screenshotted them.
42 NN to show the individuals who are following her, which it shows Mr. Lee's Instagram handle. And then she also screenshotted and sent to us 43 NN, which is the actual direct message he sent, which is of the brain.
Which is what?
An emoji of a brain. He also sent an emoji of a rat, but that emoji was deleted prior to the witness being able to screenshot that as well.
Okay.
How do you know?
And so how are you getting these things in?
As a part of his plea agreement, one of the things he admitted to was the fact that he sent the emoji. So this is just proof of that fact that he sent them.
So how are you getting the first two in then?
Because this is
He
his,
admitted that he sent a screenshot of a brain.
yes, Your Honor.
Okay.
And a
so
rat emoji.
If he denies that on the stand, you'll show him this and is that what you're saying?
No, if he admits or denies, this is just proof of it the same
Okay.
way of
All right, so then I guess I understand 43 NN and I guess 42 NN.
because this is her page. So you have to be able to show that.
How are you going to show this is her page?
So
Like that would have been something you asked her while she was on the stand.
Her Instagram records are
So,
blessed auntie.
on,
What?
Her Instagram was blessed auntie or blessed auntie. That's what the ADA Hiles testified to.
that was her Instagram in 2019. The trial was in 2021. So she changed her Instagram.
But how are you going to show that this is her Instagram?
He admits to who he sent it to. So he is admitting that he sent this brain emoji, which is but from Slime Life Shawty.
I'm not asking about 43 NN. I'm asking about 41 and 42 NN. I'm sorry to not be clear about that.
So 42 and then shows that he is someone on her page.
How is this her? How are you going to show this is her page?
Her pictures are at the top of the page, Your Honor. That first
mean
picture
anything.
is the young lady who was here yesterday.
Is that
You should
just
have asked
how
her.
everybody's Instagram looks? They have pictures of themselves at the top of the page, and so everybody who's young knows, oh, that's so-and-so's Instagram?
Yes.
Or can you post whatever you want at the top of your page?
You can post whatever you want.
Or could somebody else have posted her picture at the top of their page?
No.
I mean, it doesn't.
I mean, honestly,
I mean, I could pull up a picture of Elvis and put it. I mean, I actually don't know
Elvis?
that.
Your page,
I
Yes, you
think
can.
I
Go at us.
probably
Go keep
could
at us.
This,
find my Instagram and put a picture of whomever
Everybody's
I want
making
on
a Whitaker
there.
page.
But I don't know that.
so,
Of course,
Your
correct.
Honor, this,
You can put whatever
right.
image you want to on your page.
So how does this establish? How are you going to be like, okay, see, this is her.
this is her
page.
Instagram story. So at the top of this story are pictures, Instagram videos or pictures that she posted on her story, which lasts 24 hours. So there's 1, 2, 3, 4 images on the top of 42 NN. When you actually, you can't see it as well on here, but when you have it on the screen, you can zoom in and that is her.
I mean, I believe that's probably a picture of her.
So then what she sent to us is a screenshot of her Instagram stories and she could see who was viewing her stories at the time.
Right, but you didn't ask her yesterday when you had her, hey, are these two screenshots that you sent us back in the day from your Instagram? So how are you going to establish that this is from her Instagram?
Your Honor, I think circumstantially from the fact that he's going to admit that he sent it to her, that he is on 42 NN, you see an individual with the same vanity name that he has viewing her page, that there's pictures of her at the top of the page, and then 43 NN showing the slime, showing his same vanity name with the brain emoji.
What
I
does
believe
41 show at all?
I hope she only includes the brain emoji and says, okay, he admits that that was sent from him, but these other individual screenshots, how do you verify them? Unless you get the witness on the stand to say, yes, I sent all of those too. You should have asked, and Factual Lies pointing out, a bunch of people are pointing it out, you should have asked when Smith was on the stand.
41 is simply to show that this was his Instagram page. Slime Life Shorty is Mr. Lee's vanity name. So this is just the front of his.
All right, we already know that. Don't we know that from some other witness already? So do you need?
We know that Slime Life Shorty is Wunnie Lee, but the individual is taking the stand, so we can.
Fine, you can say, is this your Instagram page? And I guess you can ask him if 42 is her Instagram page that he followed. But if he says no, then I think you're stuck with that answer. Okay? And then 43, sort of the same thing. Okay, what else?
That's it on behalf of Mr. Ryan, Your Honor. Thank you.
Anybody else with any objections to any of these in this compilation?
Nothing further from Mr. Williams, Your Honor.
Okay. Nobody else.
I was going to say, I think it might be beneficial for the
Okay,
defense
are we ready for the jury?
to cross on, these were screenshots brought in that were brought in. It's something that I guess who would have been asked? Hogan?
Question. Y'all didn't want that witness shown, and you're about to put up a picture of her.
We're not, Your Honor.
Okay.
Oh. A big shout out here. STS Steven said, jury instructions published by Westlaw Publications. I don't think a model jury instruction exists for half the scenarios that are popping up in this trial, let alone what they have to do at the end.
Your Honor, Dr. Sullivan is next. We're just trying to find where she is. We did tell her to be back at 1:30, so if we could just have.
Okay, well then she should be back because it's 1:34.
So we're trying to make contact with her, Your Honor.
So where are we going to get these instructions from? I honestly, I feel bad for everybody. Everybody in that room the day that they have to sit there and start working on jury instructions before deliberations. Horrible. Sounds like a horrible, horrible task. Oh, where's Hilton going? Where is Hilton going? Shout out to Dion becoming a member. Thank you so much. K Grammar. K Grammar's gifting 5 memberships. You guys know that's an excuse we can drop the eagle emojis. We can get away from the brain emoji and the squirrel for a little bit and get a nice reprieve. Spamming a couple eagles in the chat. Thank you so much, K Grammar. The banner looks like it says hug trial. And yes, we'll get to hear the jury instructions. We might even be able to sit in and on the motion, like the hearing day where they argue them. Maybe hearing days. All right, so here comes Wunnie Lee. So I think this will be very interesting. This, I think, will be an interesting direct. I don't think we'll need to wait to cross for it to be interesting. Mark Nicholas says, how many RICO cases have relied on emojis as proof to further anything? I don't know, but chat, we got to be careful as a collective. They're going to be like, there's a few thousand people as part of a gang known as KNW. They all use these emojis, squirrels.
Yes, his attorney went to go get him one.
Oh, man. Thank you for the 5, Mark. And shout out to Sonia for the 2 on the Cash App. Thank you so much. Oh, and I got to react with the green heart. Got a green heart and I put a red. My bad. I feel like certain apps, sometimes I do feel like Detective Hogan a little bit. Thank you so much, Sonia. I think the attorney's last name is Rubin for Wunnie Lee. And big thank you to Happy Annie gifting 5 memberships. Let's get Happy Annie in the banner. Thank you so much, Happy Annie.
Wunnie Lee, W-U-N-I-E, last name Lee, L-E.
And good afternoon. How old are you?
25,
And are you employed?
yes,
What do you do for work?
music,
And when you say you do music, what do you mean?
I make music,
What type of music do you make?
hip-hop.
Do you have a name that you perform under?
Slime like Shouter,
And are you signed to a record label?
yes,
What label?
Alamo Records,
And when did you first sign to Alamo Records?
2018,
And I should ask, how long have you been in the music industry?
since then,
Since 2018. Have you been signed to any other label besides Alamo?
no,
Where are you from originally?
Atlanta,
And what part of Atlanta?
Southside, Cleveland Avenue,
And did you go to school?
yes,
Where did you go to school? Elementary, middle, and if you went to high school?
Cleveland Avenue Elementary School. You said middle school too?
Yes, sir.
Crawford Lawn Middle School and Carver High School.
Carver?
Yeah, Carver High School.
Carver. After leaving high school, is that when you started your music career?
During high school, like my last year in high school, or like 11th grade or something. I didn't get serious till after high school though.
You said you didn't get serious until after high school?
Yeah.
And that was around that 2018 year we just talked about?
Yeah.
Okay. As you were growing up in the Cleveland Avenue area, did you ever hear of a gang called Rock Crew?
I heard of it growing up. I didn't know if it was a gang or what it was, but yeah, I know what it is.
And how did you know about Rock Crew?
Because they had popular songs.
What were some of their songs that they had that were popular?
I don't know by heart right now. I just knew like there was the music back then.
Do you know who were some of the artists who were with Rock Crew?
One of them, Big Boo.
And was he performing as a hip hop artist?
Yeah.
Anyone else?
It was some younger people too, like my friends and stuff.
Who are some of the younger people?
They locked up or dead.
Do you have names of some of those individuals?
Let me see. My partners who locked up right now, twin, they used to rap.
Do you know their given name or you
The first and last name?
or their first name?
Nah.
Anyone else outside of Twin?
Rudy. He rapped too back then when we was younger.
Anyone else you can think of?
As of right now, yeah, that's it, I think.
Now you just spoke about Big Boo. Did you know his given name?
His real name? No.
And did you have your own personal relationship with Big Boo?
Yeah, when I got older.
Now, did there come a time when you were younger that some members of Rock Crew began calling themselves YSL?
Mm-hmm.
You said, mm-hmm?
You asking me that? Or
Yes.
you what?
I'm asking you.
Can you say it again?
Sure. As you got older, were there members of Rock Crew who then became members of YSL?
Yes.
Who were those some of those individuals?
Everybody, because YSL music took off and rock crew music died, or just, I don't know, Boo got old, so I don't know.
So who were some of these people? You're saying everybody. So who's the everybody who was a part of the music?
Basically everybody from my neighborhood.
So everybody from your neighborhood was doing music?
There's a lot of people from doing music from my neighborhood though, but not everybody was doing music though. I'm just saying like everybody in the whole, all the people that were rapping or doing music or supported the music was on some YSL stuff now. Like it wasn't rapping Rock Crew or under that name.
Okay. So tell me some of the people that we're talking about.
Me, myself.
Okay.
My friends who I just told you about. Jeffrey. I can't think of everybody's name.
And what does YSL stand for?
It has multiple meanings.
Tell me some of the meanings.
I say it has multiple meanings, definitions, or what it stands for.
So tell me some of the meanings.
Young stoner life, young slime life, young successful lifestyle. I think that's all I can remember right now.
So let's talk about young stoner life.
Mm-hmm.
When do you distinguish between young stoner life, young slime life, and young successful lifestyle?
You said when? Did I?
Yeah, how do you distinguish between the two? When do you use Young Stoner Life versus Young Slime Life?
Slime part is just like the lingo of it. Like, we'll just call each other or something. You wouldn't call your friend or something like, Stoner, what's up, Stoner? We just say like, what's up, Slime or something. So that's how I think Young Slime Life is used. Young Stoner Life, from what I know, was I'm just say like a way of life as far as music, or I mean not the music, but like getting high, or like a hippie, or I don't know.
And outside of the music, is YSL a gang?
You said outside of the music?
Yes, sir.
Some people treat it like that.
What do you treat it as?
I treated it that way before.
You treated it as a gang before?
Yeah.
When did you stop treating it as a gang?
I don't know. I don't remember. I don't know.
You said you don't remember. And when you say you treated it as a gang, what do you mean?
I don't really know. I never thought about that. I don't know how to answer that.
How old were you when you joined YSL, the gang?
Can you tell me what you mean by like join? Like, are you talking about?
Overruled.
What would you consider joining?
I'm saying, like, do you mean join like, cause you know, like to get in the gang, you join the gang, like you get beat up or something like that.
How did you become a member of YSL?
My music got popping and I became a known face in my neighborhood, and I started coming around and going to studios and stuff.
So was that how you became a part of the gang YSL, or that's how you became affiliated with the music of YSL?
I'm gonna say that's how I became affiliate of the music of YSL. But as far as joining a gang or something like that, I never like joined. We just all grew up together. There was no time to join or when I joined. We just all know each other from school and grew up together and stuff like that. But I mean, I came around like I forgot, was 2019 or 18, one of those years, when I came around as far as like officially being YSL.
How do you become officially YSL?
Just coming around more and rapping.
Is everyone that is affiliated with, and I'm talking specifically the gang YSL, rappers?
Some people.
So, but not everyone?
Some people rap. A lot of people rap, but everybody don't take it serious. Some people just rap just because they want to rap, because they want to follow the trend.
I definitely understand that, but I want to ask specifically, is everyone who's a part of YSL a gang trying to rap or rappers?
Can you say it again?
Sure. Is everyone who is a part of YSL the gang rapping or try to be rappers?
I don't know. I think so. Everybody try to rap.
Is there anyone in YSL, the gang, who's not trying to rap?
Yeah. You think?
Now I'm going to ask if you know a few people, okay? Do you know Marquavius Huey?
Yeah.
Okay. And how do you know him?
I didn't know his real name until now, until this trial, but how do I know him? Me and his little brother went to school together. Me and his little brother was in the same class. And I always just knew he had a big brother named Quay.
And is that, sorry.
And seen him a couple times, stuff like that.
And is that what you called him, Quay?
Yeah, I think that's what his name used to be back then.
And you said you went to school with his little brother. Do you know how old he is, Quay?
Quay, how old he is?
Yeah.
No.
Okay. Did you ever used to hang out with Quay
When?
at any time?
Not growing up. He came to the studio with me a couple times. That's it. We never hung out outside of the studio.
When did you start seeing him around the studio? About, if we're in 2024, how long ago was that?
I don't know. I can't remember the exact date.
And do you see him in the courtroom today?
Yeah.
Okay. If you could just identify him by article of clothing he's wearing.
You said identify what?
Identify him by article of clothing he's wearing.
He next to the lawyer with the brown. I think he got on brown too.
Okay. Thank you. Your Honor, let the record reflect that he's identified Mr. Huey.
It'll say reflect.
Do you know another individual by the name of Quamarvius Nichols?
Yeah.
Or another Quay?
Mm-hmm.
Mm-hmm. Is that yes?
Yes.
And how do you know, how long have you known Quay?
I know him longer, I think, since I was a kid. We didn't hang though, but I just knew who he was. I was younger than him though.
Okay. And do you have a friendship or a relationship with him?
Not a strong bond, but we know each other.
And do you see him here today?
No, actually. Oh yeah, I see him now.
And if you identify him as well?
I can't see what he got on. He just got the dreads up
Okay.
in the air.
And, all right. Is he towards the back of the room, the front of the room, or
To the
somewhere
back.
else? Is he sitting in between anyone?
Yeah, I think his lawyer.
Your Honor, let the record reflect that he's identified.
It's really not, that could be a couple of different people.
There's two lawyers right there. He right there, and there's a lady next to him on the left side of him.
Right now, let the record
All right,
reflect.
it'll say reflect.
Do you know someone named Shannon?
Yes.
And do you call him Shannon?
Yeah.
Okay. Do you call him anything else or just Shannon?
I think I just say Shannon.
No.
I don't know.
How long have you known Shannon?
I don't remember. I don't remember when I met him.
Is it longer than you've known Quay, the two Quays?
No.
Shorter than that?
Yeah.
And what is your relationship like, if any, with him?
Now?
Let's talk about before now.
Oh, we were cool.
Are you still cool now?
I don't know him right now. He's been locked up for a couple of years. What, I ain't supposed to say that?
Disregard that.
And just listen to the question that I ask you, okay?
Mm-hmm.
All right. Do you know someone by the name of Yak?
Yes.
How long?
I got a question.
Do you need to talk to your lawyer?
No, I'm just trying to see. I ain't supposed to say that or something. Well,
Don't worry about it, just move on to the next question.
all right.
How long have you known Yak?
I don't remember when I met him. I don't know. I don't remember.
Okay. Is it longer than you know any of these other people? The first three people I asked you about.
Not longer than I knew the Quays.
Okay.
I knew them when I was younger.
Okay.
I probably met Yak when I when I was about 18, 19, 18. When I started rapping seriously.
Next, Jeffrey Williams. How long have you known Mr. Williams?
Like the same thing as yet.
Okay. And then Rodalius Ryan.
I've known him since a kid.
Are you older or younger than him?
Older.
Do you know how much older you are?
Not exactly. A couple years though.
And do you have a nickname for him?
I can't hear you.
Do you have a nickname for him?
A nickname that I have for him?
Do you call him something?
Oh, LaRod.
What is your relationship like with, just generally, what is your relationship like? Good, bad, indifferent? What is your relationship like with Little Rod?
Right now?
Just period.
Oh, good relationship.
And do you see Shannon, Deamonte, Jeffrey, and Rodalius in the courtroom today?
Yes.
Yes. Okay. Appreciate that. So that's stipulated too.
All right. Do you see Deamonte, just describe him by the article of clothing he's wearing?
You said, do I see who?
Yeah, or Deamonte.
Yeah.
What is he wearing?
Like a trench coat.
Is he sitting next to
A
him?
yellow, tan. I don't know what color that is, but a trench coat next to the lady.
All right. Y'all let the record reflect. Is he sitting between two ladies?
Oh, yeah.
Okay.
I didn't see the other lady right there.
Y'all let the record reflect that he's identified Deamonte Kendrick.
Okay, the record will so reflect, and I don't know if jury, y'all been explained what a stipulation is. That just means everybody agrees, so you can accept that as a fact. That as to Mr. Stillwell, that this witness knows and can identify Mr. Stillwell.
Did you see Mr. Williams?
All right. And so it is now, you can accept as fact that this witness knows and can identify Mr. Williams.
And then last, Mr. Ryan.
Yes.
And where is he seated and what is he?
In the front row, next to his lawyers.
All right. Y'all let the record reflect that he's identified. Is he sitting on the right side of his
Right side.
Y'all let the record reflect that he's identified Mr. Ryan.
We need to probably do a little bit better than that with the identification.
What is he wearing?
A suit.
All right. And so you can now accept this fact that this witness knows and can identify Mr. Ryan.
Everyone's
Thank you.
like, move
All right,
on,
just a few more
please.
people. Do you know someone by the name of Trontavious Stevens?
Yes.
All right. And do you have a nickname for him?
Talking about Slug?
Is that what you called him?
Oh, yeah.
All right. How long have you known Slug?
I don't know. Like 2018 or something, I think, when he got out.
Okay.
I think. I don't know.
Do you know someone by the name of Darius Ford?
Bid? Yes, I do.
All right. And when he was living, how long had you known him?
Like all my life.
Did you all grow up together?
No.
How did you know him all your life?
My brother was best friends with his big brother.
Okay.
And they played sports together, so I always knew him when I was a little kid.
What about Christian McMillan?
What about him?
Do you know him?
Yes.
All right. What you call him?
Christian,
How long had you known him?
since a kid.
And what about Deamonte Beebe?
Mm-hmm.
Is that a yes?
Yes.
How did you know him?
We grew up together.
And then last, Demekion Garlington.
Who?
Demekion Garlington.
You asked me how long did I know him?
Do you know him?
I know him. Yeah, I know him.
And how do you know him?
I don't even know how I know him.
And does he have a nickname?
D.
Now, do you have any tattoos, Mr. Lee?
Yes.
And specifically, I want to ask, do you have any tattoos with the wording Rudy?
Yes.
Okay. And who is Rudy?
My little brother.
Is he your biological little brother or someone you call your little brother?
I just call him my little brother.
And your tattoo with Rudy, what, if anything, does it say?
Long live Rudy.
Long live Rudy.
Long live.
And within the Cleveland Avenue area, do some people call themselves the Rudy Gang?
You said, do some people call themselves that?
Yes.
Yeah. It's not really a gang though.
What's the significance? Tell the jury about a Rudy Gang.
His family made that for him. They're just showing that they for him. Like they doing it for him. I don't know. They just said gang.
Okay. Now, do you have social media?
Yeah.
And specifically, do you have Instagram?
Mm-hmm. Yes.
Okay. What is your IG handle?
Slime Light Shopping.
How long have you had that Instagram handle?
I don't remember.
Okay.
When I made it, I don't know.
We're in 2024. Did you have it last year?
Yeah.
You know what, let me ask you a better question. From the time you got into the music industry in 2018, have you had that Instagram handle?
Yeah.
What is your primary purpose of using Instagram?
My primary purpose is just social media. I think I would have had an Instagram whether I rap or not. So just social media.
And have you used IG to post photos?
Yes.
Have you used IG to direct message people?
Yes.
Have you been in group chats on IG?
Yes.
Right. Have you been in group chats or had DMs on IG with Jeffrey Williams?
Yes.
What was his Instagram name?
What is his Instagram name?
Mm-hmm.
Jeffrey. I don't know. What's his Instagram name now? You said what was it then?
Yeah. When you were communicating with him using your IG, what?
I think it's like Thugger.
Is it Thugger or something else?
I think it's Thugger. I think that's his Instagram name right now.
Have you ever used the handle Thugger1?
I think. You said, have I ever used it?
Have you ever messaged him using that handle Thugger1?
Yeah, I think so.
Trontavious Stevens or Tick, did you ever IG him? Or excuse me, direct message him?
Yeah, I think so.
Okay. Do you recall what his Instagram handle was?
I don't remember by heart.
Have you ever heard of the handle _1slug?
Yeah, that probably was it.
Okay. Christian McMiller, did you ever direct message him on Instagram?
I'm not sure.
Okay. Have you ever five or 05?
Slim.
Yes.
Yeah.
Right. Was that Christian McMiller?
Yeah.
All right. Darius Ford, did you ever IG or direct message him on Instagram?
Yeah, I think so.
Okay. And was his Instagram at real1_FR?
Yeah.
Okay. And what about Demekion Garlington? Did you ever direct message him on Instagram?
From what I've seen in the indictment, yeah. But I don't remember his Instagram though.
Okay. And then Shannon Still, have you ever Instagram him or direct message him on Instagram, excuse me?
Yes.
Okay. And do you recall sending here what his Instagram handle was?
Not by heart.
Okay. Have you ever IG'd him on an Instagram handle, OG.BOOL?
Yeah, I think so.
today, have you had the opportunity to look through or look at some of your Instagram records in preparation for your testimony today?
Yeah.
Permission to approach, Your Honor.
You may.
Or Mr. Schardt. I'm showing you what's been marked as 31NN, 31NNA, 30NN, 30NNA, 32NN, 32NNA, 33NN, 33NNA, 34NN, 34NNA, and 35 NNA. Are these the items that we went over today?
Yeah, you showed me that.
Okay. And were they the items associated with your Instagram account, slimelife.shawty?
Yeah, from what these papers say.
Okay. And Your Honor, this time say would like to tender Stacey with 30 NN to 35 NNA. 30 NN and 30 NNA through 35 NN and 35 NNA into evidence.
Your Honor, may I approach briefly?
You may.
All right, so we have an approach. I'm assuming there's a surprise exhibit or something Max isn't sure about. I almost said Max isn't shard about. Or maybe a foundation issue. He did kind of say that's what the paper says. He didn't really concede that, yes. So I'll have to see how that goes. I feel like we spent, how long has he been on the stand? He got up there 30 minutes ago. So it's been 30 minutes. He's been on the stand, and it took like 26 to get through where you grew up and who everybody is. And I am trying to work on an emoji. The one I have for Mr. Williams is like kind of blurry. So if anyone has a good like recent picture of her, that would be awesome. We'll get those up hopefully before cross. I'm sure I have plenty of time to get that done. In the meantime, while we're on a sidebar, Earless Donkey says Buddy looks like Nadine from Hey Arnold. Hey Arnold is one of my favorite shows, so thank you for the unlocked memory there. Anthony Samora says, wait, he's YSL gang, but not labeled. I mean, he's kind of saying, in my opinion, something middle ground. Like, people treated it like a gang. And I never got, like, jumped or beat up or anything. He's treating it more like, I think he's distancing himself from one of the special conditions of his plea agreement. He's supposed to testify that YSL is a gang. And he says YSL is treated like a gang. But yep, so he's not signed to YSL, the label. He's signed to Alamo. So interesting questions. And I don't think the answer was damaging for the defense, but curious to see if Hilton comes back to press on that. Jennifer Devine says most these guys did was sell pot to open studios. No one charged the Rolling Stones, when Hell's Angels killed people working security for them. Right? Was this conspiracy of some sort? Was this an enterprise? And then no charges? So I don't know the background on that, but, you know, why did we turn a blind eye there? Why did we turn a blind eye if this is the case? Good point there, Jennifer Devine. I don't know much about it. Lightning Flow says, damn, the homie Wunnie the Pooh with the green amphibious emoji got them Bullwinkle Moose Dreadwicks. So, I think you guys have said that they are actually called Wicks. That's the most that I know. And I've been saying his name wrong. It's Wunnie. I've been saying Wunnie all day. It is Wunnie. Muckduck Inc., good to see you, says 4,500 people watching the stream. Let's get those likes up. Thank you so much. Hit that like button, especially since we're on a sidebar. And then, holy moly! Mucky Ducky, holy moly, gifted 50 memberships. So, holy moly, that's a ton of gifted memberships. There should be 50 thank yous in the chat. Incredibly generous, Muckduck. Thank you so much for your support. And you guys, there are some emojis in there that you can use. I'm working on adding 2 more before cross-examination starts. More emojis are coming. Welcome aboard if you just got slimed. But super, super huge. Thank you guys for saying thank you to Muckduck in the chat. That is a ton. And we'll get him in the banner here and also make him the sponsor of our squeak counter. Well, seriously, Muckduck, thank you so much. You came in and you doubled the gang members today.
You're going to say like 10 or 30 and NNA through 35 and then an NNA into evidence.
All right, those are admitted without objection.
I'm going to approach again. And Ms. Westmoreland, we're getting ready to do that. I'm going to show you what's been marked as State's Exhibit 36 NN, 37 NN, 38 NN, and 39 NN. Yes, you keep it. Did you see those earlier today as well?
Yeah.
Didn't know?
I said, yeah.
Okay. And first looking at 36 NN, do you recognize the people in that photo?
Yes.
And does that appear to be a fair and accurate depiction of the people who are in that photograph?
Yeah, I think so.
Now showing you 37 NN. Do you recognize the person that's inside of 37 NN?
Yeah.
I think Schardt won something because she had to rearrange the exhibits.
Do you recognize the person in 38 NN?
You said, do I recognize who?
The person standing next to you in 38 NN.
Yeah, I see him.
Okay. And does that appear to be a fair and accurate depiction of you and the person standing next to you in 38 NN?
Yeah.
And 39 NN, do you recognize the individuals in that photograph, 39 NN?
Yeah.
And how did you recognize, and excuse me, is that a fair and accurate depiction of the people inside of 39 NN?
Can you repeat that?
Does that look or appears to be a fair and accurate depiction of the individuals inside of 39 NN?
Yeah.
All right. Your Honor, this time the state would like to admit 36 through 39 NN.
Those are admitted.
And I'm going to first show you State's Exhibit 36 NN. Who is in this picture in 36 NN?
Me and Shani.
And was this photo taken in October of 2020, or was this photo taken at a different time?
I don't know when it was taken. I just see when it posted.
All right. And earlier we talked about Instagram pages. Is this Mr. Stillwell's Instagram page?
I think so.
All right. And can you read for the jury what the caption says?
Fuck the other side. Put them on TV about my dog.
You got to slow down because the court reporter is taking it down.
Go ahead and read it. Just read it a little bit more slowly.
Fuck the other side. Put them on TVs about my dogs. Soldiery, bloody teeth, Glock with beam about my dog. Cause a scene about my dog.
I'm not kidding. Let me enhance it.
I'm going too fast.
Yes. Okay, go ahead. Slow it down. I
Where
know
you
you want to
want me to
wrap
go
it,
to?
but slow it down.
Where you want me to start at?
You can start from the beginning.
Say it again. F the other side. Put them on TVs about my dogs. Soldieries, bloody tees, Glocks with beams about my dogs. Clear the scene about my dog. If he F with them, you can't F with me. No, he is not my dog. That's it.
No, keep going. Keep reading the rest of it.
The rest of it is not my song.
Okay, so the first portion is your song.
Yeah.
All right. But I want you to read the rest of the post, though, for me.
Even if our position ever come down to being back to back, that's just how we're gonna rock out against whoever with you.
All right. And are there some hashtags?
No slime left behind.
All right. And is that an emoji next to that hashtag?
It looked like a crazy emoji. I never seen that.
Okay. What's the next hashtag?
2 B's.
Do you know what that signifies?
Big business.
All right. And what else does the rest of it say?
Many more blessings and riches, I say.
And is someone tagged?
I don't know who that is. Oh, that's somebody who made some clothes.
All right.
Real feel. I don't know who that is.
Okay. And what else does the rest of the post say for the record?
Thank you for this exclusive ass hat and for this crazy ass one of none hoodie.
And then someone else tagged.
Somebody named Marilyn is totally responsible.
Okay. And when was this post posted?
2020.
All right. Now, the verse that you quoted, your verse, what song is that from?
Dang, I forgot about it. Dang, I don't even remember. Okay. I really don't. I think, is it Where the Love at?
And was that a song that came out before 2020 or in 2020?
It probably came out in 2020.
Okay. And in looking at this picture, do you know where you and Mr. Stillwell were when you took it?
At the studio.
All right. And Do you have a particular studio that you used to go to?
No,
Okay. Where was this studio located?
I can't remember by heart, but it looked like sheesh. I don't remember.
Okay.
Yeah, I don't think I remember.
All right, that's fine. Course indulgence for one moment. Ms. Westmoreland. Do you want to see it? What does no slime left behind mean?
I think that's just what it means. No slime left behind. Let me see.
I'm going to show you what's been marked as 37 and admitted, excuse
Oh,
me.
that was my mixtape name. That's why he put the hashtag. He was supporting my mixtape.
Your mixtape was No Slime Left Behind.
Yes.
What made you name your mixtape No Slime Left Behind?
Like the No Child Left Behind thing that's, in school.
Okay.
I just named it that. No Slime Left Behind.
And when you were talking about slime, who were you referencing anyone particular?
No, not nobody in particular. No, I just wanted to be different. I just named it that.
I'm going to publish 37 NN. Who is in 37 NN?
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Read his caption.
Yes.
Said ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
Okay. And is there another hashtag?
Free Quay.
Is there another hashtag on the screen?
Oh no.
Your Honor.
It's in this paper.
Where does
Your
it say?
Your Honor, I have to make a motion.
Yep. There we go. Count it, guys.
I'm gonna excuse.
I wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute and jury?
Now, hold on. Does this have the notes on it that, oh, we won't show that to the jury? Because that's a problem. Because that could have been avoided. I think this is notes, work product notes from the state in the margins of the paper.
For a minute for me, please. Thank you.
That was Miss Westmoreland that asked for the motion for mistrial, you guys. And so earlier we didn't hear it because it wasn't like it was elicited by the state in any way. But this, it's on the paper that you said, oh, don't worry about it. Where's the deep sigh from Whitaker? Oh, man.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that the hashtag, there was a hashtag on that exhibit that said Free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it. And then the state presented, I guess, to the witness the unredacted version, didn't prep him
Asked
to
him to
not
read.
comment on it, and he did. And Your Honor, before we had the opportunity for you to preside over us, this happened already again. And before, and I made a motion for a mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Carter Matthews for Mr. Marquavius Huey. We join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, you know, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. It's you just didn't know, but we'll let you know when to come back in, okay?
So we join in that motion, Your Honor.
Your Honor, and I just want to briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped them, and this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, we all have, it's been established that that his nickname is Quay.
Okay, isn't there going to be, I mean, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? I mean, we did.
Yes,
Two,
sir,
it's
and
they're on
that's
trial anyway.
A few things. So one, Your Honor, it was not intentional because we clearly.
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
And we should have instructed him to read from the screen, but.
Or you should have presented him with a document that had that part redacted. It's just sloppy.
The issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, I'm going to have an issue with that. Can you redact it? That is when the state became aware.
Then it should have occurred to you, you know what, I'm handing him a hard copy of this document that is unredacted.
But
I mean,
not if there's multiple Quays, Your Honor. If I don't know which Quay that.
Hang on, can we stop having people come in and out when I've asked the witness to step out and every time the door opens, they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. God have mercy, y'all. Huh?
The state is in charge of the witness, and they're supposed to be guiding the witness to the wrong.
Yeah, I mean, there seems to be.
And so that is the point in which we learned of it is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah,
when
and you didn't read it. I mean, so the
But I
jury
said-
didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis because there is going to be this stipulation that Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay spent time in jail or in custody or in prison or anything. I mean, they say it about Hollywood stars who are in a breakup. It's not so
No.
obviously, oh, this must mean this person was in prison. But also, we were already saying Quay isn't either of these people. So let's just, and whether this was one of these people, or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of Quays.
You talked to his attorney earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this
It
was
wasn't
one
an
of the
issue
things you were going to, but it's an issue now. And you said before lunch that you were going to ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't, and it wasn't an issue until Mr. West. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slat Quay is not either of these two Quays.
Okay, but this isn't Slat Quay. This is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
So what if it is? Then you're lying to the jury in your instruction.
I don't know if it is. So it was.
Whether it, okay, so.
Your Honor, the state.
We don't know, they'll infer.
It's a stipulation that we weren't referencing any.
Oh my gosh.
Okay, that is not a reference to, if you would prefer that.
Literally nothing will come from this brouhaha.
I don't honestly really
my God.
care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
Yeah, we can come up with
Okay, do it now. Y'all work on that. I'm going to take 5 minutes.
Oh my gosh. Not the break. Not the break. Man. This is crazy. That whole line of argument was crazy. Oh, well, nobody really knows what free somebody means. I get it. We joke. Somebody, like, when my stream crashes or something and I jump off the screen, sometimes you guys will be like, free cat or Rico got cat, whatever. Yes, sometimes there's a joke with a hashtag free somebody. But otherwise, the common meaning is somebody's locked up. And even the joke, right? When you say free cat, when my stream goes down, the joke is us joking that YouTube or StreamYard locked me out. So it's still the same sentiment, even when it's used for like parody or for joking around. The sentiment is always somebody's got you locked up. So how did we go from saying people use free somebody as a hashtag when celebrities get divorced? like what the heck? What the heck? Oh my gosh. Yeah, this is crazy. The day that we use Quay for everything, this is crazy. And they had just said, watch out for the notes that you have on the sides of your exhibits. And then there we go. Yeah, we're just going to give 1,000th instruction. Let me calm down. Let me breathe. Oh, on a nice note, Michelle Warden says thank you to Muck Duck with the Slimer emojis. If you refresh your stream, there should also be a Leah Abbasi emoji in there for you. Also, still got to try to see how easy to look at the screenshots. It's a side profile of Mr. Williams, so I don't know what it'll look like on YouTube. It'd be kind of cool to have a Miss Westmoreland one as well. She just dropped bombs. She argued very, very well. Hit all the points. Like, it's not the witness's fault. The state put it up there on the paper. And I went up to Miss Hilton. And did you guys see the camera pan when Westmoreland was walking away behind where Mr. Williams and Rodalius Ryan are sitting? She had just gotten done speaking with Hilton. It was probably that moment. So there was time for Hilton to be like, you know what? Let me pause because this exhibit has stuff written on the sides of it. And if I wasn't already aware that that could be problematic, I could fix that now because Miss Westmoreland just brought it to my attention. And not only that, but she asked the witness to keep reading. So if she was already aware and she knew that exhibit could be problematic, you should have been treading lightly. You shouldn't have just said, and what else does the caption say? When, in my opinion, or in my recollection, the witness had read everything that was visible on the screen to me, got to the bottom of that caption. So what did she expect by asking him to keep reading? Oh, man. Oh, my goodness. Do you guys want a 60-second all caps? Let's do a 60 seconds all caps. And that would have been interesting because, you know, if a witness says something, it could potentially be a mistrial that they can retry. But if it's the state's fault, if the state caused that to happen, that actually could have tacked on some prejudice. And I really think, like, calling it sloppy still makes it the state's fault. Whether Whitaker wants to concede that Hilton had the power to stop this, beyond it just being sloppy and oopsie poopsie, like, still on the state. It's not the witness's fault. Oh my gosh. Loving the caps, loving the all caps in the chat. And yep, the witness had read everything on the screen. I couldn't understand why she asked him to keep reading more that wasn't there. I know, like, I feel like, and I don't know if it showed on screen, I might have actually had my camera off. I've been trying to eat my sandwich. I have a sandwich sitting over here. The bread is drying out. I might have had my camera off, but I swear I went, like, to see there was still stuff to read. So I don't know. Just the screaming. Just crazy. And then also hilarious, I think, is Wunnie Lee was at the door to the courtroom, seemingly like, sorry, I didn't know. It seemed like he was trying to say we couldn't hear him, so this is just my guess. He was saying, like, sorry, I didn't mean to do that, as if it was his fault. And Whitaker had to acknowledge, like, oh no, like, I know you didn't know. Go ahead out there. And then, why are you letting people in and out of this courtroom? So, oh my gosh, this whole day. Yeah, please, the instruction, please disregard all the quays and quas in the courtroom. Yeah, and that's it. I'm standing on that. He finished reading on the screen, and Hilton said, is there more? Like, and I don't trust it. I don't trust. Just because Hilton seems like, oh, I didn't know, it wasn't intentional. Oh my gosh. Chloe Albert's revenge says, did Florida let Love recycle Sarah Boone's luggage to make a new jacket, or did she break into the evidence locker? I like the plaid, the flannel, whatever. I think it actually, I think it's like tailored nicely. But this is hilarious either way. Oh man. Jason Sorensen says, no wonder Paige is tired all the time. The mental gymnastics she does for the state must be exhausting. Hilarious. It's just too much. I mean, we just got done with lunch, making sure we went through everything, acknowledging everything. We had, I would even say, when he said, was I not supposed to say that? That should also put you on high alert, even though he's a lay witness. He's not a cop that has been prepped 1,000 times for trials, that should know not to mention someone being in custody or whatever. Yeah, nobody moved for a mistrial the first time he said, oh, I'm sorry, was I not supposed to say that? But you would think that would have put Hilton on edge, on high alert, to be extra careful. Like, whew. But no, she says, read more, keep going. Thank you again, Jason. And STS, again, nothing will come from it. Nothing will come from it. 2 mistrials today, you guys. 2 mistrial motions. Nick Johnson says, did Hilton have the same issue with Dennis? Well, she was saying with Dennis, like, we didn't know that he was going to say that. And with Dennis, the difference was, and I agree in part, right? And it's why, like, I'm saying Wunnie Lee didn't know, and he could have been prepped and probably should have been prepped. But Dennis absolutely should have known, which is why Whitaker wanted to admonish Dennis so badly. You've testified at however many trials in your career. You should know that you're not supposed to point out a defendant being in handcuffs or shackles or whatever in the courtroom if they are. Anything that could reference them being in custody. You're not really just supposed to dive into that because it's prejudicial. It hints to the jury that somebody else has found some sort of guilt on this defendant before. And I think that's why Whitaker was so ready to admonish Dennis, and clarifying, Wunnie Lee, I know you didn't mean to do that. Like, don't worry about it. But as far as Hilton played dumb. Oh, I didn't know. Next time it happens. Oh, I didn't know. Next time it happens. Oh, I didn't know. Well, prep your witnesses. Prep your witnesses and watch your questions. And she doesn't seem to do either. So, thank you for the opportunity to rant, Nick. Lemuel Richardson says we can't mistrial for nothing. Now, the only thing that's making me feel like Whitaker is at least genuinely annoyed by this, even though she's not doing anything, is she ran out of there and needed her 5-minute break. So, and I don't put this up because I'm insinuating she's drinking. She needs to, like, her mood shifts. She needs that 5-minute break to come back down. Yeah, won't just call a mistrial. Like, all right, this won't make it to a verdict. We are on Wednesday. We still have a whole testimony to go through here with Wunnie Lee. We could get another motion for mistrial today. Who knows? We could get one tomorrow. We could get 2 tomorrow. We could get another 2 on Friday. Like, Miss K says she went to go talk to Glanville. Yeah, it's a Monster energy drink in a wine glass. A slime glass. Kevin Kirksey, read back the record. I mean, that would be great. I wonder, in heat of the moment, you guys, Westmoreland made great arguments. I think in the heat of the moment, sometimes you just miss the opportunity to ask stuff like this. But can you imagine reading back the record and having Hilton say, like, keep reading, keep going, read more. But wait. Thank you, Kevin, for the 2. KC Dog says, come on, Paige. So was he saying it like free the slaves? That's literally how long ago she seems to be living in and that much out of touch. Yeah, that was one of the most hollow examples. Like the celebrity example. Like, that's not... All of these other times when we're doing evidentiary issues and she's like, well, I think it could mean that. And she leans in the state's favor for an interpretation. And now you're interpreting the hashtag free somebody, which clearly the state is interested in that hashtag, or they would not have written it in the margins of that paper or left it sitting in the margins of that paper. Clearly the hashtag is favorable to the state, or it wouldn't have been part of the screenshot. And Whitaker's like, no big deal. So I think that's messed up, and I also think she's out of touch. Josh Lilly says, remember Paige appellate issues? Yeah, won't hold up. Yeah, she expressed concern about that this morning. And, I don't know. I don't know how that's going to look for her, personally. Like, this is just... Shout out to Josh. And also, let's do a time check. I'm like, I've been ranting, so this is 12 minutes or so at this point. I'm checking the timer down here. A bit more than a 5-minute break, so... Nick Johnson says, is it a mistrial if judge says, I'm cleaning up your mess? Imagine if she quotes the I need my ish mopped quote from, I think that was from Lil Rod to Blaylock. Let's mop this up, and then she won't know the alternative meaning for mop. You can't clean up everything. Shout out to Michelle Warden here for the super sticker. And then I'm trying to remember, do you guys know the exact quote on what she said about the appellate issue? Oh, something about baking, right? Baking reversible error into the trial, right? That was like the verbiage of it. Something like that. Like, I know defense, you'd be happy for us to bake reversible error into whatever to take up on appeal, something like that. I wonder if I timestamped it. I'll go back and listen to it in the transcript and timestamp it in the video for the replay. Peter Ortiz says, sloppy equals unprepared and lack of professionalism and qualifications to prosecute a RICO case. Yeah, I'd put a check mark on all three. I would put a check mark on all of those here, Peter, for sure. STS says, 2 more mistrial motions and all the gifted memberships expire. Joking. Yeah, I love that you do that time frame. You know, 30 days or... What's your number that you're putting out there? Will your membership expire? Either 30 days or 8 mistrial motions, whatever comes first. I love that. Kimmy P813 says, Paige, quote, assuming common vernacular is ridiculous in so many ways. Yep. Mistrial is the only remedy for the 100th time. And it's like, at this point, like, they've been told so many times, like, oh, don't think into that. Just forget you heard that. It just doesn't work. And I see here, Brooklyn, thanks for being a member, says, what's the most mistrial motions in trial if not for YSL? I mean, I don't know. I don't really think that there's like a database that tracks something like this, right? But I would imagine there's got to be some trials where a petty attorney, or I can picture a pro se litigant, just like motion for mistrial every 2 seconds. So I'm sure there are other ridiculous examples of trials where motions for mistrial seem to fly, right? Here, part of it is the length of the trial, but I'm sure there's got to be something out there that's close in number, but probably not as long of a trial. Great question, though, and would be awesome if there just was a database that tracked it. Yeah, Meech, that's where I'm landing. Like, the keep reading was crazy work. Like, Hilton, what are you doing if you're not doing this intentionally? Like, there is no, oops, that was an accident, to tell someone to keep reading. Because she was either looking at the paper exhibit and saw it and knew why she was saying keep reading, or she was looking at the screen and knew we were at the end. So I don't know. I don't know. Definitely no room for me there for benefit of the doubt. Colleen says Paige needs a double dose of Slimosas. I love that. Slimosas is really cute. On her break right now. The state's wilding out again. Mistrial Slimosas for everyone. Love, love, love that. And love a good glass of orange juice. It is apple cider season, you guys. There is a orchard in New York called Red Jacket, and the Publix down here is carrying some Red Jacket ciders, and they have a Honeycrisp apple cider. It's so tangy. It's got that good cidery tang. It doesn't just taste like a sweet juice. It's so good. I love apple cider. Love fresh orange juice. And a little champagne in it. You know, icing on the cake. So shout out, I love Slimosas. We've definitely got to adopt that. Kevin Kirksey says, Paige and admitted to helping clean up the state. Yep. I don't know where they're going to go from here. So Kevin, the Fuji one is good in its own way. It's very tasty and sweet juice. It's very light. I think it's more like a nice juice that would be good with a ton of ice. Super ice cold. Oh, but I love that Honey Crisp one. It is so good. Oh yeah, it's so good. Kiana Shaw says, Honey Crisp apple cider is the only kind I'll drink. Man, I gotta go get some after this stream. This is gonna be me for the cider after the stream, you guys. Sassy Experiences Paige is full of it. Her saying she has to clean up Hilton's mess so that 12 months won't be wasted is clear indication she knows a mistrial is warranted. Yep, and not for nothing, but it shows that the only reason that you're moving forward isn't on the merits of any individual argument, right? So you know that stuff in the past has warranted a mistrial, but you're also telling us that you're going to keep barreling forward, right? It's kind of the same thing. Same sentiment in both directions. Whose deep sigh was this? Was that Whitaker? Guys. Oh, man. Her face. Her face, you guys. Yep, watermelon juice, same thing. Judge made clear that no matter what, because of the time spent on this trial, she will not call a mistrial. That's just bad. And not for nothing, but that kind of... To be fair, the defense has said they don't really want a mistrial at this point in time for anything without prejudice. But this seems like a hint that you can keep doing the BS. You can keep being sloppy. It's condoning it. The watermelon juice, I don't know. And I know we gave all this love to orange juice and to apple juice. Shout out to watermelon juice. Thank you so much, watermelon juice. Yeah, FFS, this is a great example. Kat, the Daryl Brooks conundrum of mistrial motions. He was pretty frequent with them, right? I don't even remember. I just remember him yelling grounds every 3 seconds. Oh, man. STS says, imagine if Fani Willis has to take over. I don't think she can because of the conflict, right? Because she had, I don't know, there has to be a conflict there. I don't think she can actually do this case. But man, for the entertainment. Imagine like, all right, forget the conflict as long as we can talk about it in front of the jury why you're conflicted.
Maybe I'll come up with... All right.
Wait, hold on, Matthews. Before you say we have a stipulation, F, Judge, once you rule on our mistrial,
Right.
on my motion for mistrial.
Okay, so are you asking, what kind of a mistrial are you asking for?
Your Honor, I believe that we were goaded into the mistrial.
Okay, well, I do not believe that, because if you had seen Miss Hilton's face when that came out of the witness's mouth, she was appalled. And I do not believe that they are purposefully trying to insert error into this trial to make y'all ask for a mistrial so that they can try this case again. I think it is continued, and I am sorry, y'all have, you know, this gigantic, ginormous universe of evidence that maybe if you narrowed down, you would not be making these kinds of mistakes. But I believe that to be a mistake.
Your Honor,
So I'm going to deny a motion for a mistrial with prejudice. That one, I don't believe that the facts bear out. Would you like a mistrial without prejudice?
Oh
Yes.
boy.
You would?
Yes?
Who else would?
Holy
That
holy
means,
shit.
of course, that
Oh
the
my
state
God.
would be free to try every one of y'all again.
What do they do with this?
Judge, just a moment.
Sure.
Did you guys see Miss Persifield's face? Oh man. And I'm wondering if it's like split, can they just sever the ones that they granted for? Guys, I don't know. Drop some emojis in the chat. I don't know what to say. I don't know what to say, you guys. I'm just staring into space. Whew. And Westmoreland already said yes. Guys, she just asked if they wanted a motion. Where is it? I think it was Miss Scorpio. The chat's moving so fast. She just asked in response to Miss Westmoreland, she denied Miss Westmoreland's motion for a mistrial with prejudice. If she wants one without prejudice, Westmoreland said yes, and Whitaker said anyone else, and they all want some time to think about it. So, let's see. Let's see, you guys. Yeah, we might do, all right, we might do all caps if there's a mistrial just for the rest of the stream if this happens. We'll take off the 60-second limit. But, oh my gosh. Oh man. And I agree. Leah's dad says Paige wasn't banking on Westmoreland saying yes. And Westmoreland said yes, like kind of like, yes. Oh boy. KC Dog says Cat, we're gonna need all caps if mistrial. Yeah, we're gonna take the caps limit off even if it's partial, right? Even if only some people want it and there's like some severance. Apunenwu, welcome aboard. Yes, so Wunnie Lee is on the stand. They show him a picture and he ends up reading something that's on the page in front of him, the paper in front of him, that's not on the video exhibit that they talked about at a bench and Miss Westmoreland had brought to the attention of Hilton before this exhibit was brought up. And also during the lunch break, they mentioned like, hey, be careful about the notes on the sides of these exhibits. Oh, we won't bring that in. Don't worry about it. And that might have been about a different exhibit, but same principle. So they get into this question. They have an Instagram post on the screen. It's like a 2-sentence caption, and Wunnie Lee reads through the caption, and then Hilton prompts him to read more. And so he reads something that says free Quay, hashtag free Quay, which is apparently on this paper exhibit, not supposed to be on the exhibit shown to the jury. It's not on the computer screen. And you hear Miss Westmoreland say, Your Honor, and she has the motion for a mistrial because now it's referenced that Quay or Qua, or some Quay or some Qua, in custody, right? So that's what you missed there, Apunenwu. And Whitaker's weighing. She's offering mistrial without prejudice. So thank you so much also for the 10 gifted memberships. What a way to pop into the party with 10 gifts. Heard we're doing mistrials today. Guys, whew. And I don't have much to say. Like, I'm just kind of like, crazy. And I think Thug technically can be retried, but it's a figure of speech. He can't be retried because of the speedy trial motion. They'd have to be ready to like run his court, start his trial in like a couple days. I don't know the exact time frame. But I do believe there's a small time frame. So when someone says he can't be retried because he filed a speedy trial motion, he can. It's just such a small window that it's not practically going to be, it's probably not going to be possible because of the lack of practicality. So in a way, yes, they probably can't actually retry him, but technically they're not barred from trying to retry him, technically. They're just going to run out of the time. And yeah, if they do a mistrial, they could, you know, there could be a renewed question of bond. Like just... Yeah, and Tofo also says, when does it stop being sloppiness? I don't know. And not for nothing, it can be sloppy and on purpose, right? It can be both. So it could continue being sloppy, but at some point, when are we going to say, this is too much to say it's only a mistake? Because I think a lot of this is both. It's sloppy and it's slick. CT Benny with a great phrase here, enough is enough. Does everyone get out if it's a mistrial? I believe we would have to go through motions for bond. Everybody would have to file a motion for bond because obviously there's a significant change in circumstances there. So, but that doesn't necessarily mean the bond will be granted. It would give a new opportunity. It is Ramon says, if Young Thug is removed from consideration on the next trial, does that mean the evidence that includes him is gone? Would he have to testify in new trial? I'm sure they could subpoena him, but I mean, this is such a loaded question with a ton of options, right? The prosecution would probably strategize on what they'd want to do. Do we want to, if we speed through and try to issue or start a new trial, that's one thing. If we decide we're not going to retry Thug but want to call him as a witness, we're probably going to run into some instance where they're going to find some way that there's an overt act that he hasn't been indicted with and ran out of time to try him on through speedy trial. Like, I can just imagine the state finding something else, if that makes sense. I'm not saying that that's what they should be doing, but I'm saying I wouldn't put it past them to try to have some issue hanging over his head to get him to come testify against the others. Right? So, this is like a... I feel like this question's like a Fulton County DA's office, choose your own adventure. What do you want to do? What do you want to do here? But great question here, and good to see it, is Ramon. Ms. Jazzy Jazz says, if no mistrial, then she should make them wrap it up and before Christmas. Yeah, right, finally time limit, like as a... I don't know, like, she's not going to sanction them, but a sanction where she makes them cut stuff down, that would be nice. And they're really thinking about this, you guys. This is a big deal. And I'm sure the defense attorneys, I wish we could see, but I'm sure some of them with co-defendants, they're talking with each other because their decision could depend on what somebody else wants to do. So there's probably a lot of conferring going on with clients, with each other. Big question there. And Wunnie Lee is just out in the hallway like, oh man. Yeah, Paulette C says, yes, why did Hilton ask if there was another hashtag? Intentional for sure. I am 100%, it was intentional to me. Sloppy is not, it's sloppy and intentional. But sloppy separately, that's just a separate issue. Always. But intentional 100%. Thank you so much for the 5, Paulette. Nick Johnson says, hashtag free all of us, hashtag KNW fam, and hashtag slat. Be careful now. You're going to end up on an exhibit. Oh, man. Guys, this is a day. Yeah, Manders says, poor guy, he didn't knowingly do anything wrong. Can you imagine if they try to do something shady with Wunnie Lee? Oh, that is true. Lucia says, I'm gonna miss y'all if there's a mistrial. Well, if that were to happen, we have to reconvene for Supreme Court arguments on November 5th for the Blaylock appeal. That's, Steele's arguing that. So we'll see. But this is super cute, Lucia. Guys, we're on day 150. Day 150 of trial days. Yeah, we have other suitcases. All right, so you guys that went back, and I mean, let's just look at it again. I know we're, let's see, where did the post come up? Was, did I go back too far? Okay, it's like right here somewhere.
Hashtag 2Bs. Life size.
And is there another hashtag?
Free
Is there
Quay.
another hashtag? Free Quay.
Is there another hashtag on the screen?
She asked twice. She asked twice. Oh my god.
Is there another hashtag on the screen?
So she asked, is there another hashtag on the
Oh, no.
screen
Your
when
Honor.
she realized
It's
she
in
read
this
the
paper
paper?
right here. You got me reading.
Your Honor, I have to make a motion.
All right, I'm gonna excuse
I
you.
wasn't looking at the screen. I was looking at this paper.
That's fine.
So we can't really see her face that close. We can just kind of see her in the corner. So that kind of sucks. I wish it was like, you know, the regular camera angle. You can kind of see some of the expression from the side of the face. Oh my gosh. Oh, the banner was in the way for you guys. My bad. Where was it? Oh, that was the arguments for the mistrial. Now, why is it so hard to find?
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Oh, Atlanta News First might be blocking it.
Read his caption.
Yes.
Said ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
And is there another hashtag?
Free Quay.
Okay, so there might be a line here behind the ANF, the Atlanta News First banner, because he said life size. So that's probably spelled out like here, and there might be a hashtag under here, and that could be what she was asking about. But either way, don't give your witness something with the other stuff showing that you don't want them to read. And then, yeah, don't ask twice. Oh, Brigetta, you've missed a serious motion for mistrial without prejudice. The attorneys are debating what they want to ask for, or if they want to say yes. Westmoreland has said yes for Nichols, that she wants a mistrial without prejudice. So... oh my god, the tea! Oh my gosh, Lottie B. Oh my gosh, Catherine Roussan just posted on X that Miss Love is visibly agitated. Hold on, let me go to the other side so I can freeze this comment because it is moving quick. That Love is visibly agitated in the courtroom. Infamous Sylvia mentioned in her chat that Love was arguing with Hilton and that she was cursing. Oh, trouble, trouble, panic button. Oh my goodness. Love to hear it. I love to hear that. In all seriousness, yeah, I would love to see the faces right now. Yeah, Trouble in Paradise. Oh my goodness. Oh my gosh. Love showed up right on time, huh? Jason says, Paige said Hilton was in shock and horror. She pretty much did. She pretty much did. Bobby says, would they still be held in jail if it's I think this might have been without prejudice because there's extra letters, but it could have been with. So would they still be held in jail if it's without prejudice? So if it was with prejudice, that means, in case that's what you meant, if it was with prejudice, they should be out unless they're there for other reasons as well. Like if this is the only thing they're in custody for, and a mistrial with this indictment, again, the charges against them, this trial is called, they should be out because double jeopardy, they can't be retried. So what would you keep them in custody for? But without prejudice, they don't need to be arrested again. They could stay held. The attorneys would end up filing another motion for bond, saying that there's been a change in circumstances. And then that request would have to be evaluated again on its own merits. So, and it's possible that, yes, they could still be held till the next trial. Erica, thank you for the 2. Appreciate you. STS says government calls it plausible deniability. Yep, you can't prove that we did it intentionally. So when we say it's an oops, that's all you can make of it. Andre Cook says, Thug Speedy motion trial has how many days in it? See, I don't know the specifics. I don't know how many days it has in it. I really think that was intentionally asked for. When it was clear, he made it to the end. And I don't know the exact dates, but I mean, just think about how long it seemed. I don't know. It took them forever to get this stuff in place. So for them to speed and try to do it again, I don't know. Oh, is it really Fonnie Willis's birthday today? This FW for Fonnie Willis? I could be wrong on what FW is supposed to mean, but in context, if FW is Fonnie Willis's birthday and there's a mistrial on the table in one of the baby Rico cases, one of her baby cases. Oops. But yeah, Andre Cook, so sorry. I don't know if anyone in the chat knows the speedy trial counter. It's close to the edge. That's whatever it is. I believe 100% that whatever a number of days is left on that clock, it wouldn't be feasible to retry. And, or if it was, it'd be like some cartoon style speed to get it together, just so we fall within that speedy trial clock, and then we'll have another mess of a trial that's unorganized, sloppy, preparing it as you go. So it's really a no-win situation for the state. A whole mess. No, and KC dog. Bittersweet, right? If it's a mistrial, I'm gonna miss my KNW family, but hey, man, if it's a mistrial, I'm happy to see it. I think the state has done a lot wrong in this case. I think there should have been a mistrial granted. I mean, the Glanville stuff, I think. Like, hello. I think that was a pretty big deal. I think, the state should be glad that they made it to day 150. So... All right, so let's read some updates real quick here from the X universe. I still have the court in the background, so I can hear it. I can hear it. Let's go down a little bit. All right, and this is where they break off because Whitaker makes it clear there's no chance of a mistrial with prejudice, but leaves the possibility open for a mistrial without. Westmoreland says she would be good with that, and the rest of the lawyers are currently discussing. To something Valerie, shout out to Valerie, says, can they actually try this case again, considering it's supposed to be a speedy trial? To be determined, I think yes, but the state will be in such a huge time crunch. Others disagree with me. We'll open up that discussion when we get there, but reading the statute, it seems like they'll have around 2 months to start jury selection, my personal understanding of it. Kathy Roussan says, she mentions that all the teams are huddling in this quoted tweet. It sounds like Judge Whitaker is ready to declare a mistrial if the defense teams want it. She won't do it with prejudice, meaning the case is permanently done. I think that's a typo. She'll only do it without prejudice, giving the state the opportunity to try again. The problem for the defense teams is the vibe in the courtroom. Wait. Did that just jump? Oh, it had to expand. The problem for the defense teams is that their clients could still be behind bars for years with a new trial. The vibe in the courtroom, prosecutor Love is visibly agitated. All the defense teams are huddled in one area. The defense needs to make a decision on if they think they are winning this case. If they do, they should stick it out. It's been a long 20 plus months. 2 judges. And remember, Young Thug has been denied bail over and over. I don't think that would change with the mistrial. He could still be behind bars waiting for a new trial. However, Fani Willis' opponent vows to dismiss the case if she gets elected. Now, but you can't wait till after election to make that decision, so that's a gamble, right? Yep, new jury. Let's see. To be clear, the judge would absolutely hear motions for bond. That doesn't mean she's absolutely granting anything. And yeah, that's true. If a higher court rules that this error was not enough for a mistrial with prejudice, agrees with Whitaker, but would warrant a mistrial without prejudice, if the defense rejects this opportunity, they waive this specific error, and it won't be used to reverse any potential conviction. So this is why it's a big question why they're huddling. And there we go. I think we're caught up on that. We still haven't come back over in the courtroom. Will Detective Dennis be able to come back? Oh my gosh. I mean, the state would try it. The state would try it for sure. Oh my goodness. Ayana Davis, good to see you, says, state and judge gaslighted Abbasi. On Twitter, there are timestamps 2 times where state said they would call Ooten and Mitchell. And I believe the judge, I think the judge reviewed those, because when she called that break and discussed that immediately, I think it's because she reviewed the footage, the clips that were going around. That's why she ended up coming back and saying, hey, actually, there was this motion over to the doors over here at the end of the day yesterday. So do you guys actually want to call Mitchell? And Abbasi at that point declined. But yeah, she really did gaslight them, and she took the word of Abbate, who I don't think is known to have a stellar track record of honesty. She just took his word over Leah's. Because Leah was honest enough to just say, hey, humans don't have perfect recall. And Whitaker was like, yeah, I don't remember either. But suddenly it's okay for Adam to swear he remembers everything. And we'll just take his word. We'll put the weight over in that basket. So thank you so much for the super. And, you know, at least Whitaker, I think she kind of like panicked and corrected that, which doesn't make it okay that she gaslit Abbasi in the first place. Yeah, HVAC for Dummies says excuses. That's all this is. I agree, although I'm a little surprised we're getting the motion for mistrial without prejudice at all. I'm a little surprised. But you guys were commenting all day. Paige seems defeated. She seems like she's over it. She's coming to a realization. And maybe that whole, like, sum of all parts thing is what's making today different with this motion. Meech says, I thought they only get 2 tries at a RICO. I mean, I don't actually know. I feel like since it's a question, maybe that's something established somewhere, but if you're charged with something and then, like, if you're, like, arrested for something and then it's dropped against you and then they want to arrest and charge you again for it, they can. But even if this is a mistrial without prejudice, they could still probably will retry these defendants. So really why, I don't know what the 2 tries distinction would mean. 2 tries what? 2 tries at what stage? Because once double jeopardy attaches, that should be the final try. But there may have been other attempts to get to that point before double jeopardy attaches, multiple attempts. So... Element Design says, I hope it's not a mistrial. We were all 4 months from an associate's degree in surveillance camera systems. Oh my gosh. Man, shout out to Brian Steele. Holy moly. That is the downside, you guys. We'll miss all the other questions and answers to future witnesses about what they know about video surveillance and how the footage is stored. Oh my gosh. Positive Q says, hey there, he's very smart and has been watching. I think this is about Wunnie Lee. I think he comes off as very earnest on the stand. I don't think he's trying to manipulate. I don't think he was being slick reading that hashtag, but he was very quick to realize that it was a uh-oh. And I feel bad because I do think in a way he felt like he did something. And it was just Hilton giving him a bad piece of paper and asking a dumb question. So I think he's been a great witness. Honestly, I was looking forward to the rest of his testimony. Yeah, we're all on mistrial watch. What do you think the jury's doing? Yeah. Apun and Wu says, Whitaker really said Hilton was shocked. Ma'am, I can play shocked too. And not for nothing, but I can do something on purpose to sneak something in front of the jury and then feel genuinely shocked when I realize, wait, that might have been a step too far across the line. I can't sneak away with that one, right? So you can be shocked, genuinely shocked at the result of something that was intentional that you were doing. So I agree with you here. Like, she can play shocked, but I also think she could have been genuinely shocked that it went a little too far and was a little too obvious even though it was her fault. So, I wish that camera was on her face. STS, I will check my email as soon as there's something going on here. I mean, I can check it now. It's just, I'm really bad at multitasking on stream. So there's that. Okay, hold on. We're gonna have to make a channel emoji. This is a good one, Steven. This is a perfect look. So if there's a mistrial, we have to have some kind of stream where we can use the emojis that we didn't get to use today. Thank you, Steven. I've got it. I'll have to hop over and make it into an emoji when we have some action in the court, which I don't know when that's going to be. I don't know. Stan Busy says, I don't think they'd want to retry this. I think any sensible person would think twice about trying to retry this, especially against all of the co-defendants and the way that they're doing it. But there's a huge possibility. I just see them trying to retry it the exact same way. So, just a whole mess. Gigi says, Paige, how could Hilton be surprised if she urged him to read it? Twice. Just nuts. And Peter Steele says, what's Love's face got to do with the law? And I don't know if this is like a song lyric pun. Like, what's love got to do with it? We're putting the face, or why we want to see her facial expression. I think you might mean Hilton. And this being in relation to whether or not Hilton's facial expression indicates, intent being absent from what just went down, right? So I think this is supposed to be what's Hilton's face got to do with it. Yeah. So, I don't know. To me, I would just say my answer here is that it's an excuse. It's a plausible deniability route. KC Dog says, I guarantee all the defendants are awake now. Oh, man. It's a big question. I mean, I think it's a big decision to decide to go to trial once, but to decide, do you want to risk waiting and starting a trial all over? It's a huge question. Dang, the court got silent, but it was just reloading. And again, guys, I see a lot of tags and I'm trying to keep up with them. I don't have a count on the clock for the speedy trial for Jeffrey Williams. I don't think anybody has provided a count of the days remaining on the speedy trial clock. So again, I do think that it's a figure of speech to say the state cannot retry Jeffrey Williams because of the speedy trial clock. I don't think that clock has run out, literally. I think they practically cannot retry him because they can't move fast enough to fall within whatever's remaining on the clock. So we got to be careful about what we're saying or what we're claiming. I don't think anyone can factually say they literally cannot retry someone because the clock has run out. I haven't seen anything anywhere saying that. I don't know if it's 90 days, what the speedy trial clock is in Georgia. I haven't seen anyone put that clock up, but it just practically, it's not a reality, right? So let's just be accurate in the way that we're speaking. We got a 1 week count from Sylvia. Yeah, so imagine trying to, yeah. Yeah, so this is like really how I would say that we should word it. The clock didn't run out, so let's not say that the clock has run up. But there's not enough time with what's remaining on the speedy trial clock to get the jury seated. Mocha is me, says, why is this so scary right now? It's a huge decision. That's it. I think that's the only answer there. It's a big decision for 6 different people. And honestly, even one person being severed from the trial can make an impact because you don't have that attorney in the room making certain arguments that maybe you don't think of on the fly. I mean, we've kind of looked at the defense as a collective, even though they're all supposed to represent the rights of their clients first and foremost. But at times it's been strategic for them to do things like ebb and flow together. And one of them being out of this room would be pretty different. Like, imagine no more YSL ponytail. He's the only one that wants this. Nichols gets out of there. No more Westmoreland. We'd miss some of those arguments coming from, you know, Harvey Westmoreland on behalf of Nichols. So huge question, Mocha. Dale Johnson says, rocked to sleep yesterday. Oh yeah, this is a big contrast to yesterday. Yesterday we were rocked to sleep, and oh my, today, human psychology makes us want to know why the prosecution is so ill-prepared when the past DA passed. Would think there would be 1, 2, 3, etc. efficient. And I don't know why the 1, 2, 3 just made me think of ADA Brown getting yelled at because he was reading the exhibit numbers out of numerical order. But yeah, I mean, 150 days in, and we're still, and years down the road from when most of these incidents took place. And we're still just piecing it together, packaging it together on the fly. So, thank you, Daryl, for the 10. A. Willie, sorry, I'm getting to this late. You'd asked what kind of mistrial this would be without prejudice. I'm sure you've heard the answer now, so sorry I'm getting to this late. But yeah, cumulative motions for mistrial. 2 today. 2 today. Sassy Experience giving us the parenting language says, why do I feel like Paige is doing this to spite the defense for always asking for mistrials? Like, we can start over since y'all are so damn annoying with the Paige face. Hilarious. And it might be in part. Like, whatever, let's just finally do one of them. Especially you can kind of like pin it on an interaction with a lay witness, right? Thank you so much, Sassy. Mama Girl says, they need to ask for a recusal because you can't base a mistrial on a facial expression. So what if she was appalled? That's insane. Well, so the problem is the judge is making the determination that it wasn't intentional, right? And it not being intentional means they weren't goading for a mistrial. And the judge can make that judgment. Doesn't mean that it's the right judgment, but what an appeals court might argue if there's nothing else to conflict with that, they could just say, well, the judge in the courtroom as the 13th juror would know better in the moment what somebody's facial expression or demeanor or expression, how things were happening as it actually played out. In some regards, and I think in this regard, the appeals court would say the judge would have a better read on this than we'd be able to. So that's the problem there. And I get why it's like, great, your excuse is the facial expression. But at the same time, the appeals court isn't going to say, well, we read her facial expression differently because they're not there to see it. So, unfortunate part of, you know, the trust placed in the judge's discretion, the trial judge's discretion. Nick Johnson says, let's pay Ashley to do a visit to do a RICO versus the DA's office. Oh, man. And I think someone like this, she was calculating her rates for the billable hours or whatever to request those public records, and she gave a discount. Maybe she'd do a discount for that. CLK says, witness said it's in the paperwork you got me to read, as defense was asking for a mistrial. Yeah, it's definitely on the paper that was handed to him that he was reading off of, and not the exhibit on the screen. But what I was saying is, if there was something in that line below, another hashtag that he had not yet read, that is part of the video, Hilton could have been asking about that hashtag after style, because we couldn't see the word style, and we could probably go to like law and crime and see if the full exhibit had a line under it. But that's all I meant when I said that. I know the witness also said he read the thing on the paper, and that there is something on the paper, and that the state should have just given him an exhibit with only the things he would be asked to read on it. So it doesn't remove the responsibility from the state, but I'm saying there is a gray area there where maybe she was asking a question because of that line that was hidden by this banner down here, this ANF banner on our screen. Oh gosh, this is a throwback. Old Grumpy Batman says, at first, judge said no more chances. Yeah, zero more chances. What was that, like day like 110? Then one more time. Now she says, too much time in 12 months to give a mistrial. WTF. Yeah, that logic doesn't really math out if you ask me. 0 more chances. That was so long ago. It was so long ago. Shout out to 0 more chances. FFS says, no, absolutely effing not. Please deny it. Want a mistrial with prejudice. Start over for what? F the state, playing games with these guys' lives, FFS. And I think this is a real problem, right? If they go for a motion, if they accept mistrial without prejudice, I don't know. Maybe it depends on the judge hearing the bond motions. But these bond motions have been denied. So I think they'd still be in custody waiting months, years to restart a trial that could go on for months and years. I don't know. Not an easy decision at all. But glad to see you pop up, FFS. Great time to say FFS. Quanice, thank you so much for the 2. AK says, Love's got nerve. She's been in Hilton's shoes times 10. Yeah, right? Cursing her out, but come on, Love. Love is probably like, I would have argued it better and blamed it on the defense somehow. Why didn't you blame it on the defense, Hilton? What is with you guys? We're doing the emojis. Mark Lyon, thanks for being a member for a month. We've got a ton of green amphibious emojis. And also shout out, I don't know if it was Instagram, but it like made something look like an iguana, maybe? There was like an emoji, and Wunnie Lee was like, I don't know, I've never seen that in my life. Because however they took the screenshot from Instagram, it must have used a different emoji keyboard. That was a good time. But shout out to the green amphibious emojis, and thanks for being a member, Mark. Frandrew P. Diddy, one of my favorite haircuts to see on screen. The old Dora says, we've got a bunch of green amphibious emojis with some green hearts. Love to see it. Thank you for being a member for 2. Dirty Old Sailor says, Navy, it's a snafu. Situation normal, all effed up. Snafu is a great one for this. Put a snafu in the chat, you guys. Oh, yeah. Jennifer Devine says, so much money lost. Sledge and the jury will be pissed. Right. That is a crazy timeline for Sledge. You testify, your lawyer half argues for you sitting down. You get 5 years revoked. And then that was Friday. After court, the jury was sent home for the day. And now Wednesday the following week, this trial could end, like potential mistrials if all of them say yes, right? That's a big question. I don't really know if I see all 6 saying yes. But it could be a bit of domino effect, right? Imagine one of the big guns. What if Steele wants to say yes? Can you imagine those other defense attorneys thinking like, well, I don't know. I don't know. This is a huge question. Canadian Crispy Bacon says stormy seas on the Love Boat. Oh no, they almost came back and then they went away. That was a bit of a teaser there, you guys. Mason Martin, thanks for being a member for 2 months. Okay, thank you, Lola Marie. 11 Alive has it without banner, and there was more. So whatever life and presumably a hashtag was after that. Thank you so much for checking that, because I am not caught up here. So I have a huge appreciation for you, Lola. Thank you for doing that. So yeah. Dolly Talk says, so anything eventful happened today? You know, just another motion for a mistrial. But at least one defendant seems willing to take the offered mistrial without prejudice offered by the judge. 1 of 6. And that could change. Maybe she could change her mind on that. Maybe she'll say, hey, I spoke with my client more, and we change our minds. But right now it seems like there is a 1 out of 6 that's interested in taking it. Good to see you, Dolly. Talked about the Sarah Boone panel a little bit earlier. Got lots of great feedback in the chat. I had a great time watching that on replay and can't wait to see day 4 later today. Good to see you, Dolly. Erica says, can the feds pick up the case? I don't think they will. I don't think they will. And then, would I take the mistrial? I mean, I don't know. That's a huge question. Whose shoes would I be in? So... And yeah, Black Butterfly, so what else was on there that Hilton wanted read? I think it was just he read the letters, lifestyle, it carried over, and then there must have been another hashtag. And Happy Annie says it wasn't redacted from the papers he was given, but was on the screen. All right, I see you guys. Judge went back in the back again, so it might be a minute or 2. Maybe they'll come back soon. Great point. I mean, how are they going to seat another jury at this point? Just take another 10 months trying to seat a jury. Good luck. Good luck. Mason Martin, this is a great point. Fulton would go crazy if they do this case again. I mean, the money being spent is astronomical. And then, you know, I don't know the average days that other trials take in Fulton County, but I'm sure in this courtroom with Paige Whitaker's time, there could have been several other defendants awaiting trial. Could have had their day in court already. Start to finish, gavel to gavel, done, out. You know, victims could get some closure. We're on day 150 of this trial. So, I mean, a lot of cases could have gone through and gotten off the docket at this point. Casey Dog says, kind of a long wait for them to come back and say no. I mean, I don't know. I think honestly, if I was a defendant, I'm either going to feel in my heart I have my answer, right? Or I'm not going to be sure. So I'm either going to know for sure or I'm not going to be sure. And there's not going to be something that makes me sure. I'm just going to have to decide, weigh the pros and cons, and say yes or no. But that doesn't mean if I say yes, that doesn't mean I'm not going to still have some reservations about it or feel like I'm taking a risk. If I say no, same thing. So I don't think it means all that much that people are taking some time to weigh this decision. It's a big decision. And Joel thinks that Fani will retry if she's reelected. Uh-oh, let's see, you guys.
All right. Ms. Westmoreland,
Thank you, Your Honor. May we approach?
you may.
Oh, we're approaching. We're back to the seal again. And then Jamie Patrice Emporium, thank you so much for gifting a membership, helping someone become green. I think we've got to update this. Definitely got to get this banner updated. I think 118 new slimes. They'll end this trial and then come for us, gang. And then Nick Johnson says, would the same lawyers be able to do a second trial with Thug and Crew? Now, I'm assuming that would be a question of the retainer agreement, and maybe there's a question a defendant could decide, look, I want to switch counsel. But I would imagine that without those reasons, the ability is there, right? Keeping the same attorney. The ability is there, but maybe some logistic questions need to be answered there, and things could change out of choice. LB says, charge the state with RICO to make this fair. Right, just, you guys both, 2 RICOs, one over here, you guys just duke it out. Mahadi De Jesus says, Weinstein has to be involved. Oh, and I'm sure we've had the consult there. I mean, I know he's not in court this week, but I'm sure he was dialed in. Gary Indiana says, looks like Harvey will get the severance after all. Yeah, through a different means. But, kind of similar in concept. Severance one way or the other. Andre Cook says, is it appellate review if they accept the mistrial? Well, if they accept the mistrial, I mean, they can't go back on the decision. Right? You can't just accept the mistrial, start a new trial, and then try to get out of the new trial based on a different issue from earlier in this trial. So, Jason Sorensen says, if the DA wasn't corrupt, they would go offer sweetheart plea deals and just end it. They get, right, especially the number of months and years served already. So, if the DA wasn't corrupt, they would go offer the sweetheart and plea deals and just end it. They get a conviction and everyone goes home. It's a win-win. I swear, you guys, it comes down to wanting that big fish. Finding Good says, everyone knows oopses have consequences too. Right. I mean, I feel like the state in a way doesn't actually know that. But everybody else does. Thank you for the 2. L1915 says, if mistrial but retried, who could be the judge? I mean, I think we'd see the game of like Odyssey musical chairs where it would probably get assigned to somebody, and then we'd see if that judge says for one reason or another they're conflicted out. Similar to what we saw with the recusal motion. Like Ingram was like, hey, look, I've had issues with the deputy and Christian Eppinger, so I gotta be out. So similar to that, we could see something like that. And then Jay says, if a mistrial granted for this, I wonder if Attorney Hilton gets fired for this easily available issue. If she just took the paper away. That's the thing. Like, to me, it doesn't matter. Like, I was giving an explanation why she was asking, keep reading, right? There could have been an explanation. But she should have been on edge and aware that you, dummy, being willfully unprepared, have other stuff on this paper that's in front of this witness. So what did you expect when you asked somebody to keep reading? You could have prevented the problem. So you could have and you should have, and you didn't. Oh, man. Exactly, Jay. Thank you for the 5. Calm Turbulence. Calm Turbulence says, can they motion right now to argue prejudice or appeal prejudice rulings to Georgia Appeals Court? I mean, I don't know. Oh, and we're getting the jury sent home. Jury sent home. Which also means Wunnie Lee. Just up and out. Yeah, so this is what we've got. Shout out to Rose for the ping. James says there's no way Love and Hilton legitimately passed the bar or legitimately graduated from law school. No way. Now, hear me out. I think they did, and I think they're kind of more like too much momentum. Nobody's going to stop me. Like, you know, the mad scientist. You're smart, but you get ahead of yourself, and if nobody checks you, you push the limit more and more. Your gall, your boldness grows. And again, we saw it in this trial, my opinion. A few of the, we didn't mean to, Your Honor. All right, that might be believable a couple times. But we're in the dozens of times. So, I think they're intelligent and just ill-intentioned. Which, to be honest, I'd rather have idiots that are good, that are well-intentioned. So, I never want someone with bad intentions to be trying to do something in the criminal justice system. Because someone with bad intentions isn't going to be seeking justice. They're just going to try to be right, try to win. And that's not right. And if they're intelligent and play dirty, they'll get a lot farther than someone who means well and makes mistakes. So, great food for thought, though. We have some camera action.
For the day.
Oh. So I guess court is recessed entirely. What the heck? Guys, this is a cliffhanger. They just Dragon Ball Z'd us. She said, oh my gosh. Holy moly. No, they recessed for the day. The stream is done. We'll wait. We'll refresh for some updates, you know. Let's see. Oh, well, the judge just adjourned for the day. So if I read this tweet, I know it's words, but it seems like a little bit of surprise here from Kathy. Well, I guess that's what we're doing then. Wow, guys, I don't really have... It's just... Oh. Well, what are your thoughts? What are your thoughts? Spill all. You guys can have in all caps. We'll see if anything's written, submitted in writing. I'll keep watching. I'm shocked. I'm shocked that they recessed. She said she's got to go to lunch with her friend. Kathy just posted a cliffhanger. Oh my goodness. Holy moly. That is perfect. And what a day. Chris, thank you. You have a video of DeWilliams on, I don't know what CW means, but I have you on X, so thank you. If we can get a better angle, I'll come find you on X. Thank you for that. Because, yeah, the pictures coming up on Google were they were older and really blurry, like far away. It is Ramon says, I think the defense should take the mistrial. So much evidence was ruled in with Glanville, and they'd have another shot to get that thrown out, right? This is a great point, and yes, and I do think it's still a gamble, right? Because we're not just going to get another judge that suddenly rules in the exact opposite way. But some of the critical rulings that became a hot mess, that could be a significant difference. So there could be an advantage of that, doing the whole beginning over with a different judge, but at the expense of doing it all over again. Punanwu says, the state thought they were safe and burned most of their witnesses. Right, and it's like, what are you going to do in a future trial? Refer back to, like, now how Kenneth Copeland testified, it didn't help you. Quindary Zachary didn't help you. Antonio Sledge didn't help you. Your best strategy with them was just to read the factual acknowledgments, and I don't know. I think it'd be very difficult to imagine 12 jurors putting zero weight into someone signing off on factual acknowledgments when they were sitting in Rice Street. Maybe they don't know the conditions of Rice Street, but all 12 of them to just accept the factual acknowledgments at face value and not give any weight to the cross of those witnesses, I'd be shocked. So, great point here. One happy white girl, and I wonder what the jury's thinking right now. One happy white girl says, if they mistrial, I bet the jury is going to be pissed. Heck, I am going to be pissed. Nothing to do while at work. Yeah, there will be more trials if you like watching trials, but this one has just been such a spectacle, right? Day 150, you don't get that with a lot of other trials. So much going on. It's interesting in a way because it's RICO. We don't get to see federal RICO trials because they don't televise federal cases. But watching Fulton County try a RICO case is a spectacle in and of itself. Just a lot here. Definitely one of its kind. And at the end of the day, if there's a mistrial happening, I'm fine with not having something to watch or stream. And, before I was streaming this and I was just doing the motions, it wasn't like I was streaming the daily streams. I was watching a lot of them when I wasn't watching another trial. So I'll miss it too, but oh well. I'll find something else to do. Hopefully catch you guys out in the YouTube streets for other stuff. Club Classy once in a while. But I feel you, unhappy white girl. What's my background going to be from 8 to 5 every day? That's a big change when you've done 150 days plus with this trial. L1915 says, oh yeah, we did this. Jesse, thank you for the update here. Kathy Roussan said that everybody has left the courtroom. Just a crazy ending to the day. And at this point, you'd think the jury might learn that, hey, this is the 3rd time, 4th time, whatever, how many times we've had to go out of the room when someone mentions someone being in jail, in custody, just got out of custody, free somebody. Like, the jury's got to be cued into why we might have just been ushered on out this time. So, AK says she's bluffing. It's a scared straight attempt. Yeah, I don't know. Guys, I'm so curious for tomorrow. Yeah, and Chopomatic says, are we sure these prosecutors passed the bar? I have no doubt that they passed the bar. I think that they just are ill-intentioned. So that's my stance on it. I think they know full well what they're doing and chose to be reckless with it. Pink Slime says, opinion, Paige's denials have been as much about protecting defense as the state. She knows what a mistrial without prejudice would screw the defense. I agree, and I think it's interesting, you know. You could kind of hear her wording when she first asked Miss Westmoreland, well, which one are you arguing? Then let her argue. And then we knew Whitaker was going to be like, well, no, I'm going to deny it with prejudice. But, and I think the but was the shocking. I think the offer of a mistrial at all being offered was the punch of today. But I agree. I think she's acknowledged a few times, right? I don't think you'd want mistrial without prejudice. I think she's made that statement out loud. Not in this scenario, but she's done it before. And then Pink Slime also gifting a membership. Thank you so much. Will the state have a deadline to retry? So with Jeffrey Williams, he had a speedy trial motion. So you've got to race that clock. And I don't know if there's a way to practically beat that clock, because it took them 10 months to seat the jury the last time. For the other defendants, I would imagine, I don't know actually if they could make a speedy trial motion if there's a new trial on the table, right? If they waived their right to a speedy trial previously, I think it might be possible for them to now ask for a speedy trial, but I'm not sure. I'm really not sure here. All right, and so no jury tomorrow. All right, so looking like an afternoon start tomorrow. That's what was announced. However, the judge told our photog to be on standby at 9 a.m. just in case. Thank you again, Rose. So this is mixed. So what I'll do, you guys, tomorrow is put your notifications on. We'll schedule something. I'll put it at like, I don't know. I'll schedule it for like a time in between morning and afternoon. And if they end up going live, just look for that live notification. I'll jump on. So, but I'm not going to go live at 9 if I don't see them start at 9. If they start at 9:15, I'll start the stream at 9:15. I'll keep watching. So, okay. Daffy Daff says, does Rod's attorney have to represent him in a new trial? I think if she wants to try to withdraw as counsel, she can make that. She can motion for that. It would depend on, you know, his choice, her choice, and then the attempt. And so I don't really know. I don't think necessarily she has to. I think she could request to withdraw. So. Canadian Crispy Bacon says, Love/Hilton, no, the case is poop. Stage spat for effect. I don't know. I don't really think they think the case. I don't think they see the flaws in their case. I really think they're confident. I don't know. I think they're confident. Be Frank About It says, is the defense taking time to put together a prejudice argument with case law? Yeah, I think so. And by highlighting every time this has happened just under Paige. That's what I think is going on. Because this notice here, probably an afternoon start. However, be ready at 9 a.m. just in case. It sounds like the judge is trying to maybe taking something under consideration already, under advisement. And or she's waiting for people to turn stuff in. So I think this is exactly what's going on, for, Be Frank. And thank you for the 5. Kathy Roussan right now on X. Attorney Matthew said he needs more time to talk to his client. I'm telling you, this could happen. Yeah. Yeah, I think so. And thank you guys for all the updates. This is a lot of stuff moving fast. Marlena Mack says they need to give them bonds for this. And it would suck to see some of the bond motions. And it's, you know, just in the context of everyone that had a plea after they were denied a bond, they finally get out because they sign a plea deal. but we're still denying bond for those that I think there's some defendants weren't offered a plea, right? Or something with Jeffrey Williams, the plea involved like life or something close to it. So it was a plea, but it was like basically not. So I can picture it still being denied. Even though when bond was denied for the others that were indicted, they let him get out with a plea. This just seems imbalanced. I don't think that they're using bonds appropriately. And I agree that there should be reconsiderations for bond, but we've seen these attorneys make great arguments for it previously, and it got nowhere. But I'm sure we'll see it filed. We might see some plop in, like, this week. Peter Ortiz, we have a green amphibious profile picture here. Love to see it. Free my fellow green amphibious emojis. I love it. Love the new pic. When I was a kid, I used to love like frogs and lizards and all of that. There was like this goofy show called Amazing Animals with a little lizard mascot called Henry. That was my show. Loved it. Thank you for the 2 and for the good message here. Lottie B says, Rusan on X, the jury has been excused for the rest of the day. Yeah, this is still just all crazy to me. I'm sure there's still some updates. Yeah, just Thugger Daily saying an ominous ending with 0 extra info. You have just the cliffhanger. And look at her tipping the mic and just cutting to walk out.
For the day.
It looks like she walked out like, like over it. Oh my goodness. The Honorable Yeah That says, Unlove is coming for KNW next if she grants it. Yeah, we gotta be careful, you guys. Oh man. Carrie H is gifting 5 memberships. Shout out to Carrie H. Let's get Carrie H in the banner. Drop some Carrie H's in the chat. And we're being a little bit lax on the caps today, you guys. All right, so Mistrial says if mistrial is granted, you will have to pick up Diddy's case coverage. Guys, I don't see that being possible. I'm already losing track of other things outside of this case. That's an immense case. I think it's a lock. I personally don't find the Diddy case all that interesting because it just seems like no matter what, he's gonna get got. So, and maybe there's a possibility that that's not the case. But I think it doesn't really have something that I'm interested in figuring out. I might look at some of the lawyering, some of the arguments. But that's an immense case to consider covering. And since I can't be in the courtroom, there's no streams, and it's in New York, guys. I don't plan to order transcripts to read transcripts for the Diddy case. Like I might be inclined for other cases. I don't know. There's so many other people. I know I'm not a lawyer, but Mel, I know she's going to be looking at the Diddy case, and I'm sure she's going to do amazing coverage and commentary on it. So that's one option. I also think like the usual set of New York reporters, Molly Crane and Pilar, let me see. She's right here. Pilar Melendez. I don't think she's not always in the courtrooms in New York City, but she shares a lot of court reporters that go to trials in New York. And you can follow their coverage on X, covering these trials where cameras aren't in the courtroom, but these reporters are. So I would absolutely defer to them in this instance. That's a monster, you guys. I mean, there's like hundreds of suits being filed against Diddy. And I just don't see anything interesting about it except, you know, about time, but still let him have his day in court and follow the process. Let's see. Chloe Albert's Revenge says, how would you know it's Fonny's birthday anyway? I was like, well, I think you can figure that out. You can look it up. And then she got me in the second half. It says, is it the day she hatched or the day the egg was laid? Which came first? Shout out to Chloe. Chloe, you got me. Mocha is me says, Kat, your slimes are here to support no matter what. Yeah, no slime left behind. Oh, man. And what a great answer that was. Like, what answer did Hilton think he would give to explain no slime left behind? You're just making a play on another phrase. So, thank you so much, Mocha Ismi. Love that. Mama Girl says, I don't know for a fact, gang, but that huddle with those OG lawyers on the defense, they know the law, and Judge was too emotional at the end. Yeah, I agree. I think it'll be interesting, and I think we're going to see some arguments for it to be with prejudice. So we'll have to see. And again, what a cliffhanger. I wish there was a way we could, like, you know, bootleg, sneak peek the movie release before it's out here, but it's just not something we can do. If retried, what happens to Rule 22? I mean, since it'll be a different trial. I think they just have to reapply. But I don't think that they would... I think a judge would look super stupid if they tried to keep the media out. Although I'm sure the state's going to make their argument that it shouldn't be televised. So, and we can absolutely read the state trying to fight a Rule 22 if there's another trial. Because I'm sure they will. Oh, man. Melissa, thank you for the 2. Shuri says, Kat Nat Williams' court will resume tomorrow afternoon per Sylvia. And remember, guys, there is a small possibility that it could start up at 9 a.m. because they're telling the lawn crime photographer to be on alert, which I think is Maurice. So shout out to Maurice. Chloe Albert's Revenge says, at what point are they going to consider that this keeps happening because there's no evidence without breaking the rules, which means no case. And, you know, certainly not a case that meets the beyond a reasonable doubt burden. But it sucks. And, like, guys, this is not... It's really refreshing every once in a while you watch a trial where you can see attorneys say, all right, I shouldn't do that, or I'm not going to do that. You're right, that's a good argument. And the trial just moves along. But there are a lot of other trials, even in, you know, I'm one person, I can only follow so many trials. But I do watch trials almost every day in my downtime. This is actually keeping me from watching other trials. But over and over, there's a lot of trials that I've watched as one person where you see issues like this. Backdoor something into the case because the evidence we have isn't good enough. And we are so certain that we are right with who we've got that maybe we're willing to play dirty because we really think we're right. But have you guys ever come across someone that swore they were right about something and they were absolutely wrong? I mean, kind of find if you go around far enough and talk to enough people in a day and ask them enough questions, you could probably find at least one example of somebody being loud and wrong every single day. And it's in our justice system, and that really sucks. So, yeah, this is happening here. Happens other cases, and I'm sure this is not to preach at Chloe or anybody. I know Chloe's like, yeah, the Karen Reed trial. So, same thing. And as a relevant point here, in the Karen Reed trial, they're now trying to get new records from, cell phone records from Karen Reed's dad and brother? A different family member, 2 family members. So, you know, maybe you should have looked at that years ago already. But alrighty. Thank you so much, Chloe, for all your support. Okay, so Mama Girl is saying that they just argued case law showing judge she has to grant mistrial with prejudice or recuse herself. I mean, I'd be interested in either outcome. And I think, guys, so if something gets filed, I'll keep checking, but you might see me pop up on a live later tonight if there's something to read, which, you know, I love doing the readings. So, Mama Girl, thanks for the ping there, and I'm looking forward to seeing the arguments if they're put down in writing. I really am. Mr. Face says, hi, I'm not a member, but I love it here. Love that you love it here. Whitaker told Munktung, we got to start taking the law more seriously. That was Friday. But gives the state more chances than a game of Monopoly. Oh my gosh. And Monopoly is a great example because Monopoly can go on for a very long time. But exactly this, great point. Take the law more seriously. And then, oopsies. The whole court, it's an oopsie. This whole trial's an oopsie, and that's okay. 3 days later. So, great point. Glad to have you here, Mr. Face. And thank you so much for sending a super. Jennifer Devine says, Icarus, fly too close to the sun, get burned. Yep, I really think that that's what Hilton, not just in this instance, but other instances, is doing, has done. Stuff for the Lord, thank you so much for becoming a member. I think we got this. We got to watch out for love coming for us, gang. Kay Grammer, thank you so much, gifting another 5 memberships. Let's get some eagle emojis going. When I flipped over here, I'm seeing today has been crazy. This has been insane. Just a lot. Yeah, and I can imagine Steele and Harvey. And remember, it was Miss Westmoreland that asked to approach, right? When we thought we were coming back the first time. They're like, all right. And then you hear Miss Westmoreland saying, Your Honor, can we approach? So I agree. I think that fight for with prejudice is probably shared across all the defendants. I'm sure they all want that. Maybe there's one crazy defendant that's just like, no, I want to do this all over again. But in all seriousness, I think these are good guesses here. Steele and Harvey already arguing the case law, showing that this should actually be a with prejudice argument. So... Touche says, been lurking, but what a day. At one point, I started thinking Paige was just giving the defense stuff for appeal. Now, 100% want to see the prejudice arguments. I agree, and I'll look for it. I'll keep refreshing every once in a while. I'll refresh those documents and go live whenever to look at them if we see them come through. And this is kind of big. I mean, think about the energy if a mistrial with prejudice is granted. For the clients, for the defense attorneys, like regular people watching this trial, members of Fulton County. My big question, though, is it going to have a positive impact? Will the state do some reflection? Self-coaching? Will they do anything to grow from it? Because if they're supposed to be, in Love's words, advocates for victims, and they wreck a case that had 40 passes on mistrial motions previously, will they finally do some self-reflection? And I just don't see it. I don't see that happening. I think 10 toes down, stuck in our current pursuit of a win. So great food for thought. Thank you so much for stopping in, Touche. And absolutely, what a day. STS says Fulton County has a gang problem. Fonnie Willis ran on it. RICO may not be the best way. And I agree. Like, it's too much of a mess. It gets too confusing. I don't really see how it helps the witnesses, because they're very well maybe witnesses that get up on the stand and are trying to tell the truth, and we're doubting them, the jury's doubting them, because it happened so long ago, because they waited to put this big monster of a case together. You know, trying things in a smaller chunk without trying to make it one big RICO might be a better way to actually solve individual crimes. That doesn't answer the question of, you know, the trials that have already taken place and they're tacked into this as an overt act, right, of some sort. But still, I think it'd be a lot more effective to tackle this gang problem by chasing the crime and not the music. And STS also says 2 words, October surprise. A good one. Yeah, that works here. That fits. Okay, Lucia says sent on X Georgia code for mistrial for the speedy trial. Let's see. And hold on, did you tag me? Let me find it. Okay, so I think this might have been someone else that tagged me in it, but I think it's similar to what you were pointing at. So let me open this and we'll switch over. So here, if the defendant is not tried when the demand for speedy trial is made or at the next succeeding regular court term thereafter, provided that at both court terms there were juries impaneled and qualified to try the defendant shall be absolutely discharged and acquitted of the offense charged in the indictment or accusation. For purposes of computing the term at which a misdemeanor must be tried under this code section, there shall be excluded any civil term of court in a county in which civil and criminal terms of court are designated, and for the purpose of this code section, it shall be as if such civil terms was not held. Any demand for a speedy trial filed pursuant to this code section shall expire at the conclusion of the trial or upon the defendant entering a plea of guilty or nolo contendere. If a case in which a demand for speedy trial has been filed, as provided in this code section, is reversed on direct appeal, a new demand for a speedy trial shall be filed within the term of court in which the remitter for the appellate court is received by the clerk of court or at the next succeeding regular court term thereafter. Okay, now E is the... Oh, we can read it. This thing isn't blocking it. If the case in which a demand for speedy trial has been filed as provided in this code section results in a mistrial, the case shall be tried at the next succeeding regular term of court. So, no need to refile. We've got the clock. So, let's see. And I'm sure there's a motion somewhere. I wouldn't be surprised if Steele has already made a motion counting the clock. I would just have to go back and look for it. But yeah, keep in mind that the defense attorney has to count the clock and make the arguments, and I have no doubt that Brian Steele will. But just saying, speedy trial is not just suddenly known to a judge and the judge goes, oh, the clock's run up. A defense attorney has to make this argument, or a defendant, a pro se defendant, has to make the argument and show the math. So, could Mungtung be released if case is dismissed with prejudice? I mean, his plea deal is separate from this trial, so unfortunately, nope. Nope. And like, just think about that. That was just Friday. So, good to see you, Sanman. William Hepley says, guess we could watch reruns of the Amber Heard and Johnny Depp trial. I mean, I did do a deep dive on some of the exhibits on that case, and if you guys never looked at some of the sidebars, Andrea Burkhart did a crowdfunding to obtain some documents that were sealed but ended up getting unsealed by the court because of the appeal. She ended up getting those. So there is some extra stuff out there that is interesting outside of the 6 weeks of trial as well. So that could be an option. I don't know if I could commit to a dedicated rewatch of that trial, even though I'm sure I reference it quite a bit. That was a moment in time. Chloe Albert's Revenge says, love avoids a mistrial by the skin of her teeth. And Hilton says, hold on, hold my beer. Just a mess. Otto MC says, funny the day after the Supreme Court tells Glanville and the state they were wrong, Whitaker actually makes a mistrial motion to be legitimate. Well, and I think this is a bit of coincidence because we still had a mistrial motion earlier today that, you know, moving on, it was fine. And then this one, apparently it wasn't expected. So But at the same time, I still think it's interesting timing, just because it's interesting timing. So thank you so much for the super here, Otto. Left Coast Mana says, no chance a jury can be found if this group took forever, 10 months. The next group is going to know about this case. And honestly, they estimated when they were doing jury selection, they said the hardship, it could be 3 to 6 months. And anyone that raised their hand said 3 to 6 months is too long. I can't afford that. It would be an issue. I have a planned surgery coming up, whatever the case may be. It makes it harder to seat a jury because you got to go and rotate and find a new pool after people get out on hardship. Now, if they were honest the next time around and said, hey, this could be like a year-long trial, the amount of people having to take themselves out of the rotation would also be bigger, right? So just that alone, I think, would make the process take even longer for them to find jurors. And imagine the amount of people who've heard about this trial and might have an opinion, a strong opinion on this trial. Like, because the contempt for Brian Steele was national news. A lot of other big happenings might not necessarily be national news outside of so many people watching the streams. But all the big news outlets covered Brian Steele contempt when it happened. And then yesterday, I saw widespread nationwide coverage on the Georgia Supreme Court ruling. So think about that. Like, the pool is way tinier. Oh, man. STS says, I can't be on this jury. I will most likely die before the state's case in chief is finished. Like, it sounds like a comic panel, but it's true. Thank you again, Left Coast Mana. I was thinking says, did y'all see the court clerk smirk at the state? Now, so we are going to have a Miss Persifield emoji, so you guys thank STS for that. I just got to get into, cut it out so it's got like no background and get it up on the channel. So look for that tomorrow. But yes, the Persifield smirk. She makes interesting faces. I like her. And again, thank STS for that. YSL Jeffrey says, Judge Pageville is biased and it is sad they are playing with these men's life. Yeah, for voters too, right? It could all be for politics. We're going to end crime. That was our platform. We're going to get, they estimated that YSL was the cause of the majority of the gang violence that was going on. That was the platform. That was the press release. Those are the speeches. That was the theme. Don't really know if that theme rings true, and yet we're spending so much time and resources because we said that this would solve the problem. So I'm with you, YSL Jeff Free. Always love how you spell your name there. AK says, I don't think it let me buy my super chat. I think Paige is bluffing. I see your super chat here. I think Paige is bluffing, and this is a scared straight method for the state. She's exhausted all options. It's possible, but I'm really interested in seeing why we're maybe not coming back until tomorrow afternoon. I actually don't think that this is yes, court is recessed for the day. Whitaker says possibly back at 9 a.m., but probably an afternoon start. And they tried to come back. Ms. Westmoreland said, can we approach? So I don't know. I think the consensus and very likely probability here is that they are arguing for a motion of mistrial with prejudice. So, and while I'm here, I can also refresh and see. Okay, I refreshed and let's see. Raymond, this is the first thing I see in my feed. Judge Whitaker this morning versus this afternoon with the this is fine. And then this is not fine. Oh my god, everything's on fire. What the hell is my problem? This is good. This is pretty accurate. Okay, so Xeno, maybe that one is a plus, like an L. Xeno B1S. Maybe it's Xenoblus or Xenoblues. If you go back again, Wunnie gets asked about any other hashtags and he says free D. Then Hilton says no on the screen. Wunnie looks back and goes, oh no, no others. Okay, so I mean, we can rewatch that. And I can pull up a different feed. We'll pull up Law and Crime and see.
I don't know who that is. Oh, there's somebody who made some clothes.
All right.
Real feel. I don't know who that is.
Okay. And what else does the rest of the post say for the record?
Thank you for this exclusive ass hat and for this crazy ass one of none hoodie.
And then someone else tagged.
Somebody named Marilyn is totally responsible.
Okay. And when was this post posted?
2020.
All right. Now the verse that.
Dang, I don't even remember.
Okay.
I really don't. I think, is it Where the Love at? 2020. Studio.
The studio. Ms.
That's what it means.
And
Name.
Sorry, I'm trying to catch it all the way from the beginning.
who is in 37 and N?
OG Boo.
Yeah, so you can see there is
And who is
another
that?
caption down there,
Shem.
hashtag.
Alright. And can you read for the jury the caption?
Read his caption.
Yes.
Said, ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
And is there another hashtag?
Free Quay.
She says, well,
Is there
right
another
away.
hashtag on the screen?
Oh no.
Your Honor.
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
So, yeah. I mean, to me, it seems like that whatever he's reading from the paper is in this part right here that's been redacted out. So why would he not read that? Like, it's not like this changes it for me. Like, okay, there's something over here he tuned out when she was really trying to get him to read this. But now that I see that this line is like this, I think they redacted this hashtag free Quay would fit here in this area. And it makes sense with the emoji. And she told him to keep reading because her dumb self gave him a piece of paper that had this unredacted. So he kept reading from this point as prompted. That's her fault. That is her fault. And thank you also to Lola Marie, like check another feed. And Lola had also gone and looked and said there is the other line underneath it, blocked by the banner on the feed we were watching. So big appreciation to both Zeno and Lola here. But yeah, you guys get what I'm saying about this redacted spot right here? I think Free Quay was right there. So, like, how did she not realize that that's where he was reading from? My gosh. Yeah, sloppy. I'll just call it sloppy. Just a mess. And then Amanda says, tagged you in some fun on TikTok. Now I'm weary about playing TikToks. I mean, a lot of TikToks have music in it, and TikTok has licensing agreements that YouTube doesn't have. Even songs that are licensed on both platforms, YouTube might have a different usage license than TikTok. So, a little nervous on that. And I'm not signed in. I'm on a company account on my computer, so if I don't know my password to sign in, oh my god, the music just scared me. A loud TikTok. If I don't have my password right for the account I created to follow Doug, because I used a link to get to Doug's earlier, I'm not going to be able to sign in on the account to pull it up on the screen with a tag. If you want to link it to me somewhere else, I can get the link from there and pull it up. But I'm not signed into the Catnut Williams account. Because really, I created it for the sake of creating it, and I really don't use TikTok personally. So sorry about that. If you are on X and want to shoot a link, like tweet me a link really quick, I could grab it through that and open it that way on desktop and share it. Chloe Albert's Revenge says, they made us sit through all that trash before, and we finally get a witness we kind of like, and this is what they do. Evil! Yeah, right? I was excited to see the rest of this day play out. Oh, man. And then Zion42 says, interesting content on day 100 and day 150, right? It's like the numbers just gave us bookends there on those big days. Just can't wait. Just wait until day 200. Maybe Freakway. And yep, I think this, I can't highlight on a StreamYard highlight, but I really think that Freakway is sitting right here. Down here. Down here. So there is that, you guys. Again, hit the bell notification because we don't know what time they're going to start tomorrow. It could be at 9. It could be in the afternoon. We'll throw up a live stream whenever we see the courts go live tomorrow. But I don't know. And Freedom from Fear says, hello, Kat. While I was at work, I got an email saying I was gifted a membership. Thank you to everyone gifting the memberships. Def appreciate it. Happy you got one. And thank you for saying thanks to someone out there. No, Robert. Robert says a remedial training video will cure this. We've tried that again. Don't suggest it because they might be like, that's a good idea. Oh, man. Hilarious throwback there. And good to see you, Robert. Hope you're doing well. KC Dog says, Westmoreland gets shaded by Paige the most of all the defense, and ironically, she scores the mistrial that sticks. Poetic justice. And I love Westmoreland. I mean, I really like all the defense attorneys. I don't think I have a less than positive view of anybody over there. I think they all match their clients really well. But yeah. It is poetic justice because she's been so snippy. And even earlier today, Whitaker was looking for it because Bruce Harvey got up. I don't even know what the argument was at that point in time. But he must have turned his body language to face the state, and Whitaker was like, why are you motioning over there? Like, orient yourself to talk to the court, because she's always telling him talk to the court and not opposing counsel. Just out to get them. Yeah. I don't know. And YP Com Chic says, why would they give him a paper that has it on it still? Because they're bold. They figured we'd rather be lazy, and who cares if we prevent something that could be a problem. It was brought to their attention at the bench and with the walkover from Miss Westmoreland that it could be a problem. And look, it was a problem. So they made their cake, they can eat it. And that's I mean, I can't come to another conclusion. They wanted him to read it. And she knows that you give the paper exhibit, unless you have someone like turning and pointing, or it's a video that you can't print out on paper. These paper exhibits, when you hand them, you're asking the witness to look at the thing you just handed them. So, just stupid. Oh my gosh. Run this back one more time. Oh, did I go ahead? I think it skipped ahead.
No.
Who is in 37 NN?
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Read his caption.
Yes.
Said, ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
And is there another hashtag?
Free Quay.
Well,
Is there
gets
another
me every
hashtag on the
time.
screen?
Oh no.
Your Honor.
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
All right, I'm gonna excuse.
I wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute? And jury,
All right,
I'll excuse y'all for just a minute.
So that's how we got there. Do you guys want to hear the arguments one more time? I want to hear the arguments. Miss Westmoreland was spitting. I like her a lot.
Mr. Lee, can you step outside for a minute for me, please? Thank you.
Everyone's like, yes, love you guys. Oh, Ike, today was a time. Did you see the the detective this morning? Al Hogan. All right, and this might be a little quieter because we're back on law and crime, but we have captions, so.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that there was a hashtag on that exhibit that said Free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it. And then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And Your Honor, before we had the opportunity for you to preside over us, this happened already again. And I made a motion for mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Schardt Matthews for Mr. Marquez. We join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. You just didn't know, but we'll let you know when to come back in, okay?
So we join in that motion, Your Honor.
Your Honor, and I just want to briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped him. And this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, it's been established that that his nickname is Quay.
Okay, isn't there going to be, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? We did.
Yes, Your Honor, and that's a few things. So one, Your Honor, it was not intentional because we clearly.
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
And we should have instructed him to read from the screen, but
Or you
when
should have presented him with a document that had that part redacted.
issue-
It's just sloppy.
the issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, "I'm going to have an issue with that. Can you redact it?" That is when the state became aware.
Then it should have occurred to you, you know what, I'm handing him a hard copy of this document that is unredacted.
But not if there's multiple quays, Your Honor. If I don't know which quay that.
Hang on, can we stop having people come in and out when I've asked the witness to step out and every time the door opens, they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. God, huh?
The state is in charge of the witness, and they're supposed to be guiding the witness to the room.
And so that is the point in which we learned of it, is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah,
when
and you
I came
didn't read it. I mean, so the
But I
jury
said-
didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis, because there is going to be this stipulation that Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay spent time in jail or in custody or in prison or anything. I mean, they say it about, Hollywood stars who are in a breakup. It's not so
Who says that?
obviously, oh, this must mean this person was in prison. But also, we were already saying Quay isn't either of these people. So let's just, and whether this was one of these people or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of quays.
You talked to his attorney earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this
It
was
wasn't
one
an
of the
issue
things you were going to, but it's an issue now. And you said before lunch that you were going to ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't. And it wasn't an issue until Ms. West. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slat Quay is not either of these two quays.
Okay, but this isn't Slat Quay. This is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled. They only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
I don't know if it is. So it was.
Whether it, okay, so.
Your Honor, the state can enter stipulation that we weren't referencing, and we as the state of Georgia.
Okay, that is not a reference to, if you would prefer that.
I don't know what the poster is referencing. 'cause-
I don't
but
honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
Yeah, we can come up with it.
Okay, do it now.
I think, is this where they go to the seal? Or does Westmoreland
Y'all work
argue
on
more?
that. I'm going to take 5 minutes.
She takes her 5 minutes. So there you go. And then essentially, they take much more than 5 minutes. Then they come right back and say, Westmoreland says, Your Honor, can we approach? So I don't see any filings. I did see some, and sometimes it just takes time. I did see, we, at the beginning of the stream, looked at a motion in limine from Brian Steele about the Viverito PowerPoint. And Carton Matthews says, we adopt all the arguments put forth in Jeffrey Williams' motion in limine number 67. We also want to iterate that all slides contain this background with the image YSL. We ask that the background be removed. Slide number 10 is a photograph and social media post, which contains hearsay in its caption, and a recitation of reports and opinions which are testimonial. Mr. Huey objects to that as well. And then slide number 11 is a screenshot from the APD of Mr. Huey's booking photograph and arrest in 2019. So Huey objects. So he's adopting Brian Steele stuff, and we saw Brian Steele argue these things as well. So I'm not going to dive too far into that. We'll have to see them play those arguments out. They'll probably go through it slide by slide, and then at some point Whitaker might say, hey, you know what? Can you guys just not use this PowerPoint? And whatever's admissible, you find a way to lay the foundation and bring it in through the witness testimony. We'll see how that goes. But other than that, I don't see anything else new filed quite yet. So. The Adventures of Chloe and Daisy says, I bet the defense is writing motions and talking with the defendants' families to see what is best for them. Guys, it is a huge decision. There is not just if it's for without prejudice. I'm sure there's two things happening, right? These defense attorneys need to be prepared. They're probably trying to argue that it should be with prejudice. And then they're also going to have to be ready to say what they want, what their decision would be, if it's on the table for them to choose a yes or no. Do you want a mistrial without prejudice? That's a big decision to make. So I agree, Chloe. I think absolutely this is what's going on. Only wait and see. And then Brian, I don't know how to say your last name, Barati? Brian says, day one slide with bad character evidence. Right, the two motions for mistrial and opening statements. Day one slide with bad character evidence. Brady violation retraining. Yeah, that good old video replay. Cop did it 4 days ago. Now today, slide before that one had unredacted hashtag also. Like the sloppiness can only be an excuse for so long anyway. Like, just because you say something sloppy doesn't mean it's a harmless thing to do. So, I don't know, you guys. So what I'll do is I will keep refreshing and checking these portals, and, you know, I'm not going to check like every second, but like every hour or so I'll check for the rest of the night to see if we've got any filings that we can read, because I really want to see you guys. So I'll pop back up if that happens. As far as general housekeeping, I'll pop up on a stream tomorrow anywhere between 9 in the afternoon whenever the court decides it's going to go live. It seems like jury knows not to come in tomorrow, so I'll have to see. I don't know. We'll go live when we go live. And then Classy Beats, if you want something to wind down tonight. Today's Wednesday, right? We've got Classy Beats tonight. I think we probably got Flesh of the Gods at 9 p.m. And Sarah Boone with Excited Utterance is starting at 6. But I did see Potentially Criminal is streaming day 4 of Sarah Boone, so I have my redirect set up to spill into that. They're currently watching day 4 of Sarah Boone. And just keep in mind that at 6, Excited Utterance will go live with her recap. Other than that, anything else? How many times did they do? Is this like a mistrial thing? Because a lot. I'm just going to say a lot. I don't have an exact count. Oh, man. There is on X, and it was hilarious. I recently retweeted it. Let me see if I can find it real quick on my timeline and link it out, because the commentary is hilarious. Yeah, okay, so we have Clutch DWG going back and trying to count the mistrials. Because he said someone said that October 2nd was number 45, but I'm just not getting that many unless a ton were motion denied without any other commentary, banter, or filings. Meaning they probably went through the days on Law and Crime and searched the transcript for motion, mistrial, a couple keywords. And this is what they were able to compile. But they gave a reason for the ruling, and the column says things like, let's just pretend that didn't happen. Denied hard, denied cause nuh-uh, denied chastised prosecution, denied judge had tantrum, denied instructions to ignore her whining. I just all around appreciate this for putting the information together, but also for the good laugh. So there is a link to that in the chat, you guys. Check it out, hit the like button if you use X. Show some support for their work putting this together and their sense of humor. I got a great kick. We will have new emojis tomorrow, guys. So stay tuned for that. Give a big thanks to STS for sending over the Persefield facial expression. We're going to make that an emoji. And to Factual Lie for getting a great picture of Leah Abbasi. And Chris, I think I've got to find on X, you had a good clip of DeWilliams. So we'll get those worked out. We got some encores here. We've got some free birds. Renee Stevenson says, my first thought is that some of these guys may not have the funds to fight this case again. And I think that's problematic. And I don't really know. I mean, I can imagine certain personalities of attorneys would be like, forget it. I'm here. Let's burn this courthouse down. I'm in it for the long haul. I don't care about the money. But at the same time, you've got to make a living. You've got other clients. So could go either way. But great point. I mean, huge consideration to ask someone to go along for another potential year, 2, 3 years. Thank you so much for the super here, Renee. And then Chloe, will close with Chloe says, if she gives another chance, the defense's position has got to be, Your Honor, they're gonna F it up. Yeah, probably by tomorrow, by Friday. If not then by Monday. So, absolutely. Chloe, I think you could put money on it. I don't think the return would be very high because the odds of it happening are so high. But you know, you guys all have a great one. It was great to have you guys in here, especially like I didn't know what to say for a good part of it. So I appreciate you guys being okay with that and giving me tons of food for thought and watching it with me. This will redirect over to Sarah Boone trial. If I catch you guys somewhere else in between today and tomorrow, can't wait to see you out there. And if not, see you tomorrow. You guys all have a good one. And see you if you come over to the Sarah Boone content. Bye-bye.